ಫ್ರೆಶ್ ಅಂತ ಕೊಟ್ಟರು ಅದು 25 ಒಂಚೂರು ನೋಡಿ ಸುಮ್ಮನೆ ಹಾಕಿಸ್ಬಿಟ್ಟ ಮಾಡಿ ಬೆಳಗ್ಗೆ ಅದು ಒಂದು ಅವರು ಲಕ್ಷ್ಮೀನಾರಾಯಣ ಅವರ ಅಲ್ಲ ಅದೇನಾದ್ರು ಇರಲಿ ಟೋಟಲ್ ಫ್ರೆಶ್ ಇರಲಿ. ಅಲ್ಲ ಈ ಗ್ರೂಪ್ ಬರಬಾರ್ದು ಅಷ್ಟೇ ಸುಮ್ಮನೆ ಹೆಂಗ್ ಕೊಟ್ರಿ ಯಾರು ಕೊಟ್ರಿ ಎಲ್ಲ ಕೇಳ್ತಾರೆ. ಏನ್ ಸರ್? ಕೇಳಿ ಆಪೋಸಿಟ್ ಸೈಡ್ ಇಂಟಿಮೇಟ್ ಮಾಡಿ. ಪ್ರಶಾಂತ ಆರ್ಡರ್ ಆಗಿದೆಯಮ್ಮ ನೋಡಿದ್ರ? ಅಲ್ಲ ಅದರಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟಲ್ಲಿ ಹೇಳಿ, ನಾಳೆ ಚೇಂಜ್ ಮಾಡಿಸ್ತಾರೆ. $70 ಅಲ್ವಾ? ಎಲ್ಲ ಇಯರ್ ನಾನು ಕೊನೆ ವಾರದಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟಿದ್ದೀನಿ. ಅವತ್ತು ಅವ್ರಿಗೆ ಸಾಟರ್ಡೆ ಹಬ್ಬ ಇತ್ತಲ್ಲ, ಅಲ್ಲ ನಾನ್ ಸಿಟ್ಟಿಂಗ್ ಡೇ ಇತ್ತು ಅವ್ರಿಗೆ. ಸಿಟ್ಟಿಂಗ್ ಡೇ
Yes. Service matter. Yes. 17th. Yes.
17th, 18th, 19th.
Yes. 17th. Yes.
ಒಂದು 17 ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದು ಮುಂದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ಮಂತ್
Third chamber.
ಕೊಟ್ಟು
Yes, we'll see that. Chamber culture. No, fresh matter. Yes. Yes. 18th. Yes.
ಅದೊಂದು 18th.
Yes. Yes. Murarji Desai. Saturday ಇರ್ಬೇಕಲ್ಲ ಅದು. No, some matters has posted on Saturday that on the weightage 5% weightage in Saturday. Yes. Then 18th. Yes. Yes. Yes, next month 18th. No, 18th or Saturday. We are giving in a chance on no memo is taken on Saturday. All on 17th, 18th. You are given Saturday is this week itself. You don't want, then take it. Yes. ಏನ್ ಮ್ಯಾಟ್ರು? Yes, 10th. Yes.
10th next month.
RSA
ಕೊಡಿ ಸರ್.
RFA is not our this thing roster. Yes. 18th. Yes.
18th.
Fresh matter tomorrow. Tomorrow. Now, what has happened that fresh matter? First time. Yes. Yes, day after tomorrow.
Day after tomorrow.
Here.
May I mention, my lords?
Yes. Yes, 12th.
ಅದು ಚೇಂಜ್ ಮಾಡಿ 12 ಮುಂದಕ್ಕೆ.
Yes. Yen bunch. Yen all are Anganwadi. Yes, 12th letters.
ಇಲ್ಲ ಕನೆಕ್ಟ್ ಇದ್ರೆ ಆಟೋಮೆಟಿಕ್.
Yes, 18th. Yes.
ನೋಡೋಣ ಆಮೇಲೆ 18. ಅದು ಸೈಡಿಗೆ
RSA.
ಕೊಡಿ RSA ಕೊಡಿ ಸರ್. RSA WP ಪ್ರೆಸ್ ಎಲ್ಲ ಕೊಡಿ. Only Friday.
Yes, 17th. Yes.
Move ಮಾಡ್ತಾರೆ ಅವರು.
17th. Yes.
It's 17th.
Yes, correct.
For page wise adjournment. Adjournment if any.
Serial number 30, my lord.
Huh?
50.
57. Yes. You are appearing for? Filed by that advocate for the petitioner. You have filed a memo for retirement. Now, what's your name? Now that you are filing in a wakalat, you have not filed. Yes, at the request of counsel for the petitioner, leave this matter up to 2 weeks. Yes, file madi. 45. At the request of counsel for the petitioner, leave this matter on 11th. Yes.
Serial number 30, my lord.
Yes. ಅದಕ್ಕೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ 11th. 23rd ಆಗಲ್ಲ, ಬೇರೆ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗ್ತದೆ. You are appearing for? Respondent.
I appear for R5 in that matter, my lords, please.
Yes, at the request of counsel for the respondent number 4. Leave this matter after 2 weeks.
My lords,
Who has filed IA for vacating?
my lords,
You have filed.
I appear for R5 in that matter, my lords.
You are appearing for
It is
R5.
me who has filed this application seeking
You
for
have filed
vacating.
and vacating.
Yes, my lords.
Yes, mister.
My lords, so far as R5 is concerned, my lords, he has attained superannuation. Now, my lords, he is not even getting pension. Therefore,
No,
if
I am
you lords
asking
may
that who has filed that IA for vacating?
it is me, my lords, R5.
Yes, what you say about that is
Kindly have it on next Wednesday, my lords, please.
next Wednesday.
Some date may be fixed, my
Yes,
lords.
third.
Please.
Yes, at the request of counsel for respondent number 4, leave this matter on third. Yes,
Serial number 30, I appear for R3, my lord.
interim order granted earlier is extended till next date of it.
Serial number 30, I appear for R3, Kuvempu University.
30.
My lord, we have to file our counter, my lord. We have not been served with a copy.
Have you informed other side?
No, my lord, we have not been served with a copy of the writ petition.
Matter reach out. We'll ask them to serve a copy.
Obliged.
Yes, madam.
My lord, the serial number 70, it was supposed to be posted for hearing on IA, my lords. It's been posted for B group, my lords. If it could be taken.
We will have it day after tomorrow. Office is directed to post this matter. Day after tomorrow.
Please, my lord.
May I mention a matter, my lords? My lords, writ petition number 31196 of 2025, my lords. It was a notice was issued in it on 4th November. However, since then it has not been listed. The urgency is that, my lords, last week a coercive action has been taken against me and a penalty proceeding has been initiated.
You have to move that memo, mister. Which is that matter? You have to move that.
As I have been instructed that memo had been moved.
Who has moved that memo?
Well, just
If
confirm
they
with
have
local
moved that
council.
memo, then you have fixed the date. Yes.
List number 1 for preliminary hearing, serial number 1, Jaya Prakash Rai for petitioner.
Appearing for petitioner, my lord.
Yes.
My lord, here the petitioner is the second wife of Boralingaya. He is a gunman who used to work in a engineering department in KPT. He died in 2015, my lord, and he is retired in 1998. In his nominee, he has nominated both his two wives, like wife number me and my another wife who is Savitri. I am legally wedded in 1984, and even the marriage certificate can be seen in the annexure B, my lord. The problem is
even after 1988, the retirement benefit is not.
No, my lord.
Neither you or that.
No, my lord. The first wife also died in 2009. The death certificate is also there.
Then what are you doing from 1998, 2008, madam?
When we approached for the pension, they given us the endorsement, which is in annexure number A, saying that as my second marriage was not considered as a valid one, they denied the pension to me. And I am kindly requesting to set aside that endorsement and promote alert the mention, my lord.
With 11 years, what are you doing from last 11 years, madam?
My lord, she is an uneducated one and she is a senior citizen. She was dependent on a relative. Till now, she was not having the knowledge that they should approach the higher authorities to have the pension, my lord.
Where is that endorsement?
In annexure number A, my lord, page number 8.
Yes, you take notice. Government advocate is directed to take notice for respondent number 1. Amresh N is directed to take notice 2. Issue emergent notice to respondent number 3 and 4. Counsel for the petitioner is directed to serve one set of copies on government advocate 1. Yes, Amresh. Yes.
Serial number 2, Ashoka T for petitioner.
My lords, this is a petition of writ of quo warranto, my lords.
Dispensation of production of certified copies on HRM for a period of 4 weeks subject to condition has to produce within 4 weeks.
My lords, it's a writ of quo warranto, my lords. The respondent number 5 was a minor when he was appointed as a bill collector, my lords. Challenging his employment, this writ petition is filed, my lords.
Who are you?
I'm a RTA activist, my lords.
Who is that minor?
Respondent number 5, my lords.
Upendra TJ.
Kindly see annexure E, my lords, in page number.
What is the documents you have to share?
Let's annexure E, in page number 24, my lords.
Annexure E.
Annexure E, in page number 24, my lords. In page number 25, my lords, in serial number 31, his name is shown as tax collector and his date of birth and also date of appointment, my lords.
Date of birth
1970, my lords, in the 4th column, my lords, that is date of birth.
70 adre esta aittu alige?
17 years, 3 months, my lords. 17 years, 3 months, my lords.
1987 he was appointed.
Yes, my lords.
What are you doing on this day, mister? Now he has become major and he has worked for. Why you have filed now, mister? What is that intention behind that, mister?
My lords, the thing is, this employment is taken in violation of the rules, my lords. Therefore,
what you say about the delay?
My lords, in case of writ of quo warranto, the delay is not applicable, my lords.
You have to see that intention why you have approached, mister.
My lord, the rule
that he has worked 87 ಅಂತ ಅಂದ್ರೆ ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು? 40 ವರ್ಷ he is going to retire.
Now this is
Now we'll see if that is the case. Yes, you take notice. Government advocate is directed to take notice for respondent number 1 and 2. Counsel is directed to serve 2 sets of copies on government advocate issue emergent notice to 3 to 5.
Great, my lord.
Serial number 3,
that motive. If it is wrong, we will impose heavy cost on that.
Please, my lord.
Serial number 3, BV Emalata.
My lord, I appear for the petitioner, my lord. My lord, petitioners are the guest faculty members of the Mysore University, my lord. Respondent university has passed the impound order wide annexure H, page number 35, stating that there is no workload in the department, hence reduce the working hour from 12 hours to 4 hours, my lord. On the same day, they have issued one more appointment letters to the new guest faculties, wide annexure J, my lord, stating that there is a workload, my lord. It is very difficult for the petitioner even the writ appeal is pending for consideration, while Annexure F in writ appeal, they have given direction not to disturb the my lord, wide Annexure F, page number 32, my lord, not to disturb the employment of the petitioner, my lord. They have given direction. In spite of that, they have reduced the working hours of the petitioners, my lord.
You take notice. Government advocate is directed to take notice. Nevilva.
Respondent, university, my lord.
Studies in education, Manasa Gangotri, head of the department. Nevilla. Yes. Yaridara Mysore University. Abhishek Kumar is directed to take notice for respondent number 1 and 2. Council for
My lord, kindly interim order may be granted, my lord. It is very stay may be given, my lord, for impugned order.
Yes, you are in the service. You let us see. Yes.
Serial number
My
4,
lord, kindly, my lord.
Now you take notice, madam. Yes.
Lordship, this is with regard to the NPS scheme being applicable for all the government autonomous institutions. The petitioners are the medical professors in SIMS, that's Shumaga Medical Institute. There is a similar petition challenging Annexure Y that is filed before this court. Notices issued in that as well. This is with regard to in 2020,
Yes.
the impugned orders passed at Annexure Y, page number 269.
Yes.
Wherein prospective implementation of NPS scheme is ordered.
Yes. No, it's 2020 has issued. What are you doing all these days?
Your Lordship, after that, there was back and forth, back and forth. There are other orders internally which is passed.
Yes. Or
The
issue notice.
government, Your Lordship. All three respondents.
Government advocate is directed to take notice for 1 and 2. Counsel for the petitioner is directed to serve 2 sets of copies on government advocate. 3 Shimoga Institute of Medical Science. Rajwal. So and so is directed to take notice. Correct? Either. Yes. Directed to take notice for respondent number 3. Counsel is directed to serve 1 set of copies.
Your Lordship, it has to be connected with another
All
petition.
this matter along with that.
1699 of 26.
Yes.
Serial number 5, Lakshmikant K.
My lord, the petitioner is challenging the dismissal order, my lord. My lord, petitioner is suffering from the severe medical health issues, my lord. My lord, he is he took the unauthorized leave, my lord. ರೆಗ್ಯುಲರ್ ಆಗಿ ಇವರಿಗೆ ನಡೀತಾ ಇದ್ದಂತಹ ರಿಪೋರ್ಟ್ಗಳು ಟ್ರೀಟ್ಮೆಂಟ್ ಇದನ್ನೆಲ್ಲನೂ ಕೂಡ ಅಧಿಕಾರಿಗಳಿಗೆ ಕೊಡ್ತಾ ಇರ್ತಾರೆ ಸ್ವಾಮಿ. ಬಟ್ ಆದ್ರೂ ಕೂಡ ಅವರು ಅದನ್ನ ಪರಿಗಣನೆಗೆ ತಗೊಂಡಲೆ ಅದನ್ನ ಅನ್ಆಥರೈಸ್ಡ್ ಲೀವ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅವರನ್ನ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಆ ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್ ಅಲ್ಲೂ ಕೂಡ ಈ ಹಿಂದೆ ಒಂದು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಇತ್ತು.
24ರಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿರೋದು ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ
ಸ್ವಾಮಿ? 24ರಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದು, ಬಟ್ ಆದ್ರೆ ನಂಗೆ ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್ ನನಗೆ ತಲುಪಿಲ್ಲ ಸ್ವಾಮಿ. ನಾನು ಅದಾದ್ಮೇಲೆ ನಾನು ಹೋಗಿ ಕೇಳಿದಾಗ ಏನಾಯ್ತು ಅಂತ ಅನ್ಬಿಟ್ಟು ನನಗೆ ಒಂದು ಫಂಗಲ್ ಕಲ್ಚರ್ ರಿಪೋರ್ಟ್ ಬರ್ಬೇಕಾಗಿತ್ತು ಸ್ವಾಮಿ. ಅಂದ್ರೆ ಮತ್ತೆ ನಾನು ಯಾಕೆ ಕೆಲ್ಸಕ್ಕೆ ಸೇರ್ಕೊಳ್ಳೋದಕ್ಕೆ ಸರಿ ಹೋಗುತ್ತೀನಿ.
ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಹೇಳಿದೀರಾ ನನಗೆ ತಲುಪಿಲ್ಲ, ಯಾವಾಗ ತಲುಪಿದ್ದು ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದೀರಾ? Para 7. To decision of not furnished the inquiry report, petitioner against finding in this report, inquiry report, impugn order. The same was served on the petitioner on 6/9/2024. It is served.
6/9/2024. ಹೌದು ಸ್ವಾಮಿ. ಅದಾದ್ಮೇಲೆ ಫಂಗಲ್ ಕಲ್ಚರ್ ರಿಪೋರ್ಟ್ ಎಲ್ಲ ಬಂದಾದ್ಮೇಲೆ ಮತ್ತೆ ಅಪ್ರೋಚ್ ಮಾಡಿದ್ದು ಸ್ವಾಮಿ. ಅವ್ರಿಗೆ ಈಗ್ಲೂ ಕೂಡ ಅವರು ಹೆಲ್ತ್
asking that 2024 to 2026. What are you doing?
My lord, he is suffering from the major health issues, my lord, like tuberculosis, asthma, breathlessness, and COVID also attack ಆಗಿತ್ತು ಸ್ವಾಮಿ. ಮತ್ತೆ ಲಂಗ್ ಡ್ಯಾಮೇಜ್ ಇತ್ತು ಸ್ವಾಮಿ. ಅದಕ್ಕೆಲ್ಲ ರಿಪೋರ್ಟ್
24ರಲ್ಲಿ ಎಲ್ಲಿತ್ತು ಕೋವಿಡ್?
ಅಲ್ಲ ಸ್ವಾಮಿ, 19 ನಲ್ಲಿ ಅಟ್ಯಾಕ್ ಆಗಿದ್ದು. ಅದು COVID-19 ನಲ್ಲಿ ಅಟ್ಯಾಕ್ ಆಗಿದ್ದು. ಆ ಟೈಮ್ ನಲ್ಲೇ ಇವರಿಗೆ 2018 ಇಂದಾನೇ ಇವರಿಗೆ ಹುಷಾರಿಲ್ದಲ್ಲೇ ಇರೋ ಕಾರಣ ಇಟ್ ಇಂಪ್ಯಾಕ್ಟ್ ಜಾಸ್ತಿ ಆಗೋಯ್ತು ಸ್ವಾಮಿ ಅದರಲ್ಲಿ.
ಆಯ್ತು, ಈಗ ಹೇಗಿದ್ದಾರೆ
ಸ್ವಾಮಿ? ಈಗ ರಿಕವರಿ ಆಗ್ತಾ ಇದ್ದಾರೆ. ಫಂಗಲ್ ಕಲ್ಚರ್ ರಿಪೋರ್ಟ್ ಬಂದಿದೆ. ಈಸ್ ನಾವು ಓಕೆ ಟು ಕಂಟಿನ್ಯೂ ವಿತ್ ದ ಜಾಬ್, ಮೈ ಲಾರ್ಡ್.
Yes, hard issue notice. Government advocate is directed to take notice for respondent number 1. ಯಾರಿದ್ದಾರೆ? ವಾಟರ್ ಸಪ್ಲೈ. urban water supply. Urban water supply and drainage. Issue emergent notice to respondent number 2 and 3. Council is directed to serve one set of copies on government advocate. Yes.
Grateful.
Serial number 6, Jagan Mohan MT for petitioner.
This petition filed for the relief of Mandamus. Not this,
Ide file.
What is this FEF?
judgment passed by the coordinate bench of this honorable court. The Dharwad bench.
What is this order, Mr.?
Lord, consider the stop of recovery of the commuted pension beyond 10 years. They have given a representation, my lord. That coordinate bench,
To recover the commuted value pension beyond 12 years, the petitioner submitted that representation annexed. Not to consider. To the statutory authorities to govern so and so. No, that directly respond to the representation. Here also same relief.
yes, my lord.
To read Mandamus, void annexed, yes, will dispose of, Mr. Huh? Yes. Government advocate is directed to take notice for respondents. This writ petition. Petitioner sought following relief.
Annexure C and E. my lord.
The case of the petitioner that the respondents proposed to recover the commuted value of pension beyond 12 years. The petitioner submitted a representation with annexure E.
Annexure C and E.
Annexure
There are two
C.
petitioners.
And the annexure C dated 30th/10/2025 and annexure E dated 31/10/2025. The said representation has still not been considered, but the respondent are proposed to recover that amount. In view of the above, the petitioner is before this court. Since the representation submitted by the petitioner has not been considered, it is suffice for this court to direct the respondent to consider that representation submitted by the petitioner within reasonable time in accordance with law. Reasonable time. The government advocate submits that in view of the above, pass following order. The petition is disposed of. The respondent is directed to consider that representation submitted by petitioner with annexure E, C and D in accordance with law as expeditiously as possible, not later than 8 weeks from date of receipt of the copy of this order.
Until recovery of the commuted pension will be stopped. my lord.
Needless to say, until such representation is considered and order is passed, no recovery can be made from the petitioner. Yes.
Serial number 7, Srinivasa K for petitioner.
Yes, Mr.
Similar case, my lord, has been admitted by the Sambu court.
Yes. What is this matter?
This is a matter, my lord, wherein the petitioner, my lord, was working as junior assistant under the respondent management. Lord, the charge of the misuse of the, my lord, the funds of the respondent corporation was made.
Yes.
Based
You
on
will
which,
take
my lord?
notice for the caveator undertake to appear for respondent 1 and 2.
Yes,
Yes.
I will serve the copies.
Petitioner is directed to serve 2 sets of copies on. Yes.
Public.
Serial number 8, PN Nanjareddy.
Yes, Mr.
Milord, it is always a shortage of materials. Milord, the inquiry officer held that there is no shortage of materials. There is no loss caused. In spite of the same, twice, Milord, the punishment, that is withholding of 9 lakhs, Milord, has been the retirement benefits only. Twice it was passed by the Honorable Court. Again, the same order has been passed, Milord.
No, that on the inquiry, it is order has been W.
On inquiry, Milord, inquiry officer report annexure B, Lordship gets it at Milord, page 64, Lordship. ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ದಾಖಲಿಸುವ ಎಲ್ಲಾ ಸಾಕ್ಷ್ಯಗಳನ್ನು ಕ್ರೋಢೀಕರಿಸಿ ಪರಿಶೀಲಿಸಿ ಅಪಾಯದ ನಂಜುಂಡಪ್ಪನ ಜವಾಬ್ದಾರಿತ ಅಧಿಕಾರಿಯಾಗಿ ಡಿಪಿಜಿ ನಿರ್ವಾಹಕರ ನಿಗ್ರಹಣಕ್ಕೆ ಸರಬರಾಜಾದ ದಾಸ್ತಾನುಗಳನ್ನು ವ್ಯವಸ್ಥಿತವಾಗಿ ಜೋಪಾನವಾಗಿಟ್ಟುಕೊಂಡು ಮೇಲಾಧಿಕಾರಿ ಆದೇಶದಂತೆ ಶ್ರದ್ಧೆಯಿಂದ ನಿಷ್ಠೆಯಿಂದ ಅಲ್ಲಿನ ದೈನಂದಿನ ಕರ್ತವ್ಯಗಳನ್ನು ಸರಿಯಾಗಿ ವಹಿಸಿಕೊಂಡು ದಾಸ್ತಾನು ರವಾನಿಸಿ ಉಳಿಕೆ ದಾಸ್ತಾನ ಲೆಕ್ಕವನ್ನು ಲೆಡ್ಜರ್ ಅನ್ನು ನಿರ್ವಹಣೆ ಮಾಡುವಲ್ಲಿ ಹಾಗೂ ಸಿಬ್ಬಂದಿಯವರಿಂದ ಆದೇಶದಂತೆ ಕಾರ್ಯವನ್ನು ನಿರ್ವಹಿಸುವಲ್ಲಿ ಸುಭದ್ರತೆಯನ್ನು ಪ್ರಾಮಾಣಿಕವಾಗಿ ಕಾಪಾಡಿಕೊಂಡು ಬರುವಲ್ಲಿ ವಿಫಲವಾಗಿರುವುದು ಸಮರ್ಥಿಸಿದೆ ಎಂದು ನಿರ್ಧರಿಸಿ ಅವರ ಸದರಿ ಕರ್ತವ್ಯ ಲೋಪ ಪ್ರವೃತ್ತಿ ರುಜುವಾಗಿರುತ್ತದೆ.
Issue emergent notice to respondent.
Cell number 9, Nagarajatti.
My lord, respondent number 10, my lord, who is the retired EO. Now, my lord, he was in power during 17/1/2017 to 13/5/2019, my lord. During his period, my lord, he permitted to run the school, Delhi Public School at Malnaiknalli instead of J. Agrara, my lord. My lord, after retirement, my lord, new BO, that is Somesh P, the petitioner herein, my lord, assumed power during the year 2019 on 30th/9, my lord. Sorry, my lord, 16/10/2019, my lord. As he found irregularities relating to the school.
Inquiry has been initiated against you.
Please, my lord. Against respondent number 6 to 9 and against me, my lord.
Who are you?
My lord, I am BO then during 2019, my lord.
Then you have to go to the KT. You are a government servant.
No, my lord, the reason is because proceedings have been.
No, we are not hearing on that merit or reason.
Please, my lord.
If you are a government servant,
Please, my
you
lord.
have to go to that KT, that's all. At outset, government.
My lord, sorry, my lord, sorry. My lord, what has happened in this matter, my lord? Because interested party has reported, respondent number 6 was accused in a complaint, my lord. He reported to the authorities that petitioner has committed irregularities and dropped proceeding against himself.
No,
and
I'm
other.
not deciding on merit.
Please.
I said,
Please,
you have to go to the KT.
please,
That's all.
I may be permitted to.
Yes, yes.
Please.
Government advocate at outset submits that the issue involved in respect of civil post, petitioner has to approach Karnataka State Administrative Tribunal in view of judgment of apex court in so and so. The above petition is disposed of, reserving liberty to the petitioner to approach appropriate legal forum if law permits.
Please. Cell number 10, Nagashri MC.
Yes, madam.
Wait for Mandamus to implement the order of ARCS, my lord. Page 21 is the order, my lord. Lord, I have lost both my parents in the COVID period, my lord. I
What
compassionate
Mandamus
to-
you are seeking?
Yes, my lord.
Seeking Mandamus for what?
For implementing the order, my lord, of the ARCS, page 23 may be, sorry, my lord. Page 21 may be kindly be perused, my lord.
What is that?
My lord, all reinstatement with all the consequential health benefits. She was terminated from the service.
Who has to implement that?
My lord, the third respondent, my lord, MD.
Yes, heard. Issue notice. Government advocate is directed to take notice.
1 and 2, my lord.
1 and 2.
3, 4 and 5, my lord.
Issue emergent notice.
My
Yes.
lord, I may take permitted to take handsome as well, because
Petitioner is permitted to take out hand summons to respond
Oblige
number
me.
3 to 5. Yes,
Cell number 11, Vasant Kumar N.
My lords, I'm for the petitioner.
yes.
Now, the petitioner is the retired Air Force officer, master wing officer. And after his retirement in 30 June 2018, there was a commutation of pension which includes two parts, my lords. One is the regular commutation of pension, which is second is the disability pension, my lords. Now, at the time of retirement, my lords, my commutation of pension was only given, and disability pension was not given, my lords, which amounted to, my lords, about 5 lakh rupees, which was not paid to me. And I,
No, where you are working?
in the Indian Air Force, my lords.
Indian Air Force.
Indian Air Force. And at page number 11, I would like to draw your lord's attention. This is speaking
Yes.
order, my lords. The speaking order, I would directly go down to the paragraph number below 4. Below paragraph number 4.
Yes.
With your honest permission, lord's permission, that it says the petitioner was
Yes.
sanctioned service element only wide PPO number so and so dated so and so, and later on granted disability element wide PPO. Commutation on disability was erroneously left out at the time due to oversight. Now the same
Yes.
has been done, wide corrigendum PPO number so and so, arrears of 2,81,000 has been paid. My lords, before even paying me the amount, the EMI was deducted from my commutation of disability pension. Now, at a later stage, after deduction, and I've been paid only about 2,81,000 rupees, 875 rupees, whereas originally it was supposed to be paid about 5 lakh rupees, my lords. 5,96,492 ಕೊಡ್ಬೇಕಾಗಿತ್ತು.
Where you are working, mister?
Indian Air Force, my lords.
No, in which place? You have retired when you are working in where, mister?
My lords, I will seek direction from the party, but Directorate of Air, Indian Air Force is all I know, my lords. I will seek instructions from my petitioner.
Yes, when you are retired, where you are working, you just, because of respondents both are then out of the jurisdiction of this court. We'll see that. Yes.
Okay.
When will you get back?
In 1 week's time, my lords.
Yes. 1 week. Leave this matter. Next week. Yes.
Cell number 12, Madhu MT for petitioner.
In this case, my lords, the petitioners are retired lecturers and teachers, my lords. They opted the commutation pension, my lords. The beyond 12 years is over, my lords, but the respondents are deducted the commutation pension, my lords.
Where you are working?
Working as government college.
Government teachers.
Please, ma'am.
Then you have to go to the KT, mister.
Lords,
Government teacher means you have to go to that KT.
but in similar matters, my lords. Lordship has passed the order, my lords.
Similar either.
Till then, my lords.
Huh?
Till then,
No, you go to that KT. Tomorrow itself we can go that before the KT. If it is, you are holding the post of teacher in government school, then it is yes. At the outset, learned government advocate submits that. Petitioners are retired government teachers. They have to, if they have any grievance in respect of their service condition, they have to approach Karnataka Administrative Tribunal in view of judgment of apex court in case of so and so. The above writ petition is disposed of, reserving liberty to the petitioner to approach Karnataka Administrative Tribunal in accordance with law, if law permits. Yes.
much.
Pending application.
All pending applications are disposed.
Cell number 39, 13, HJ Ananda.
But the petitioner, my lord, is retired warehouse, my lord, the regional manager of the respondent corporation, my lord. He was retired on 31/1/2024, my lordship.
Yes.
As per annexure A, my lord, page number 48, the respondent has passed an order for the deduction of 44,71,334 from the retirement benefits of the petitioner, my lord, without issuing any notice and without conducting any.
Where is that order?
My lord, the allegation is that, my lord, KFCSC has to pay the warehouse rents of rupees 44 lakhs and add.
ಕಾರಣವಾದ ಆರೋಪಗಳು ದುರ್ನಡತೆ ವಿವರಗಳು ಆರೋಪಗಳು ಸಾಬೀತುಪಡಿಸಬಲ್ಲ ದಾಖಲಾಪಟ್ಟಿಗಳು ಇದರ ಜೊತೆಗೆ ಅನುಬಂಧ.
This order, my lord, was challenged before this honorable court.
ಪಕ್ಷೀಯ ಹೇಳಿಕೆ
My lord, annexure J.
ನೀವು ಖುದ್ದಾಗಿ ಹಾಜರಾಗಿ ಹೇಳಿಕೊಳ್ಳಲು ಇಚ್ಛಿಸಿದರೆ ಎಂಬ ತಿಳಿಸಲು ನೋಟಿಸ್ ಕೊಟ್ಬಿಟ್ಟು ಹೇಳಿದ್ದಾರೆ ಬನ್ನಿ ಅಂತ ಎನ್ಕ್ವೈರಿ ಮಾಡಕ್ಕೆ, ನೀವು ಅದನ್ನೇ ಯಾಕೆ ಚಾಲೆಂಜ್?
Annexure J is the order passed by this honorable court, my lord. This order was quashed by this honorable court and direction was issued to consider the representation of the petitioner and also, my lord, liberty was given to the respondent to hold an inquiry if law permits, my lord. Thereafter, my lord, as per annexure K, the respondent again passed the same order, 54, page number 54, for the withholding of very same amount out of the retirement benefits, my lord. Page number 56 is the operative portion. That is dated 30/10/2025. My lord, ordered for 44,71,334 ಗಳನ್ನು ತಾತ್ಕಾಲಿಕವಾಗಿ ತಡೆ ಹಿಡಿದು ಇನ್ನುಳಿದ ಸೇವಾ ನಿವೃತ್ತಿ ಸೌಲಭ್ಯದ ಮೊತ್ತ 19,76,501 ಪಾವತಿಸಲು ಆದೇಶಿಸಲಾಗಿದೆ. This is the order, my lord. Thereafter, my lord, petitioner filed the contempt petition, my lord, before this honorable court. The contempt court, my lord, has issued notice. After the issuance of receipt of the contempt notice, my lord, now annexure A came to be issued by the respondent. Notice come article of charges. Kindly see, my lord, page number 20, my lord. imputation of charges, ದುರ್ನಡತೆ ವಿವರಗಳು. Para number 2, my lord, page number 20. The time of the alleged incident, my lord. 20 is, my lord, page number 20, my lord. Para number 2. ಆಪಾದಿತ ನೌಕರನಾದ ಶ್ರೀ MR ರೇಣುಕಾಸ್ವಾಮಿ ಪ್ರಾದೇಶಿಕ ವ್ಯವಸ್ಥಾಪಕರು ನಿವೃತ್ತಿ ಮೈಸೂರವರಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸದರಿಯವರ ಅವಧಿಯಲ್ಲಿ ರಾಜ್ಯ ಉಗ್ರಾಣ ಬನ್ನೂರು ಶಾಖೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ 2013-14 11-2012 ರಿಂದ 2016-17 18-1-2017 ಅವಧಿಗೆ admittedly, my lord, petition was retired in the year 2024. The alleged incident, my lord, relates back to the 9 years old incident.
You take notice. Yes.
My lord, interim order, my lord, other my lord, case 214-2B, my lord, does not permit to hold a departmental inquiry in respect of the retired government servant in respect of more than 4 years old incident, my lord.
Now, when you have retired from the service?
31-1-2024, my lordship. Article of charges, my lord, issued on 5-2-2026. The alleged incident relates to the, my lord, 1-1-2012 to.
ಆಯ್ತು, ಅದ್ ನೋಡೋಣ. ತಾತ್ಕಾಲಿಕವಾಗಿ ತಡೆ ಹಿಡಿದಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಅಲ್ಲ, imputation of
not recovering from you.
ಅಲ್ಲ, ಈಗ now they want to hold an inquiry, my lord. ಇದು annexure A, my lord.
Yes.
Annexure A. Now they want to, my lord, propose to hold an inquiry and called upon the petition, page number 20, my lord, article of charges. Para number 2, my lord.
Page number
20, my lordship.
Yes.
Imputation of charges. Paragraph 2. ಆಪಾದಿತ ನೌಕರನಾದ MR ರೇಣುಕಾಸ್ವಾಮಿ ಪ್ರಾದೇಶಿಕ ವ್ಯವಸ್ಥಾಪಕರು ನಿವೃತ್ತಿ ಮೈಸೂರವರಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸದರಿಯವರ ಅವಧಿಯಲ್ಲಿ ರಾಜ್ಯ ಉಗ್ರಾಣ ಬನ್ನೂರು ಶಾಖೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ 13-14 1-1-12 ರಿಂದ 2017 2016-17 18-1-2017 ಅವಧಿಗೆ admittedly
ರಿಟೈರ್ಡ್ ಯಾವಾಗಾದ್ರೆ
31-1-2024, my lord.
24.
My lord, after 9 years, my lord, now this imputation of charges has been made. 214-2B2, my lord, does not permit. To be 214 2B subclass B, the department of proceedings, if not instituted while the government servant was in service, whether before his retirement or during his re-employment, subclass 2, my lord, shall not be in respect of any event which took place more than 4 years before such institution. As per the imputation of charge, my lord, 18-1-2017 is the date of the alleged incident, my lord.
Yes, as the government may direct in accordance with the procedure. In which the order of, yes. Heard. Issue notice. Stay of annexure A. Dated 5-2-2026 for a period of till next date of hearing. Who is that respondent? Issue emergent notice to respondent.
Earlier proceedings AK Vasant or appear either.
Emergent notice.
Please.
Yes.
For order serial number 14, Rajesh Shettigar.
Yes, memo filed for withdraw the writ petition. Memo is taken on record. The above writ petition is dismissed as withdrawn.
Serial number 15, Jayadevaya JM.
Your Honor, this is the case of KCSR 214-2B, which my learned friend has now explained. The same type of case.
Awaiting service of notice.
He retired on 31-1-2013.
No, Mr. Counsel. Notice is not yet served to R3.
It was served on 19-1-2026.
Your
Can you show the name, Venkatesha Sarbati name?
Yes.
Venkatesha Sarbati, no, name.
Venkatesh Sarbati is undertake to file wakalat for R3. Office is directed to show his name. Yes, when
Can you have this next week any date?
Yes. And 6 weeks time.
7th.
No, he is appearing today. He wants time. Yes. This matter on 11th. Yes.
Serial number 16, Malaya MR for petitioner.
Non-compliance of subsection.
My lord, I can do it in the, can you pass over, my lord, please?
No, you have to file an application, mister.
That is, this, my lord, certified copy only is
Certified copy?
required.
Yeah.
Yes, my lord.
Then file it. Pass over. Is there any urgency or we will have it tomorrow?
Urgency, my lord.
Yes, pass over.
Serial number 17,
Right,
Udaya
ma'am.
Kumar RL.
Not the objection is regarding the submission, the chronological order not mentioned. There are daily was
Petitioner-
appointed in different dates. As per the petitioner's ranking, I mentioned that has no relevance in that.
Not
Only
petitioner
equal for
ranking.
equal work.
It should be chronological, not petitioner ranking.
I will make it, my lord. It's only equal for equal, covered by judgments, my lord. Annexure H may be seen. They are working from the last 16 to 24 years.
Which
in
department?
response. Annexure H already similarly placed employees, they are already honorable court considered.
Where you are working?
They are working in, from, one is working in Assam PCRD Bank, Anekal PCRD Bank, Valenarsipura, and also Chandrapatna. All five are working in different PCRD banks. They are working, Annexure A, my lord, please. They are working since last 16 to 24 years against the vacant post, my lord.
You complied.
And that I will make it, my lord, please. Then Martina, notice may be ordered, my lord.
Notice.
I'll
Yes.
comply in the condition that I will do.
Yes. With a condition to comply office objection.
I'll take emergent
Course
notice.
of the day. Ivate ಮಾಡಿ.
Martin.
Yes.
Hearing interlocutory application matter, serial number 18, Nayak VS for petitioner.
For amendment filed.
And I filed an application seeking amendment, my lord, urging additional grounds.
Who is your opponent?
My lord, KPC, my lord, is government.
You have any objection, mister?
ಇದನ್ನು ಅವ್ರ ಹತ್ರ ಕೊಟ್ಟು ಕಳ್ಸಿ.
No, who is contesting, Mr. Bhatt?
My lord, the government is contesting respondent. And my lord, the Karnataka Power Corporation, my lord.
Who is appearing for Karnataka Power Corporation?
ನೋಡ್ತೀನಿ ನಾನು ಮಾಡ್ಸಿಸಿ ಹೇಳಿ.
What
My
is
lord,
this matter?
previously,
Hmm.
one learned counsel was appearing, he has given NOC and somebody else, my lord, has filed wakalat.
The respondent number?
4, my lord.
4 ಯಾರಿದ್ದಾರೆ ನೋಡ್ರಿ.
I appear for respondent number 4, J. Manil Kumar.
Huh?
J. Manil Kumar, my lords.
Anil Kumar,
Please, my lords.
Power Corporation,
ಅಲ್ಲ ಗೌರವ್ ವಾರ್ ಅಂತಿದೆ.
Our private respondents. yeah,
Private
Kumar.
respondents, my lords.
Gaurav R, where is that? Yes, what is that amendment you sought?
My lord, additional legal grounds, my lord, not facts.
No objection has been filed by
No
any-
objection has been
Yes.
filed.
IA 1 of 2025 is filed for amendment of petitioner. The government advocate has no objection and no other respondent has filed any objection. None appear for respondent number 4 for the reason stated in that application. The IA 1 of 2025 is allowed. Petitioner is permitted to file an amended petition after serving copy to that respondent.
Much obliged.
Serial number 19, Akhil S for petitioner, H. Devendrappa.
Amendment of prayer, my lord.
Yes. Amendment of?
Prayer, my lord. Second respondent had produced one document in his memo dated.
What is this matter, mister?
My lord, annexure A has been
Amendment
challenged.
filed for petitioner, copy served through that WhatsApp acknowledgement for third
Last
time.
open court alle ಕೊಟ್ಟಿದ್ದೀವಿ sir ಮಾಡಿದ್ದೀವಿ.
Yeah, no, what is this seeking amendment?
Karnataka State Pollution Control Board order has been challenged, my lord. That is annexure A.
Amendment.
No, you have any objection for allowing that amendment?
No, no.
You-
Last time we had produced the memo of document, we have already asked, entrusted the state, they have to answer. This is
No, I am just asking that he has filed an you have no objection. IA 1 of 2025 is filed for
Annexure A challenged.
amendment of
Please amend.
writ petition. The respondents have not filed any objection and counsel for the respondent submits that they have no objection to allow that application. In view of the above, for the reasons stated in that application, IA 1 of 2025 is allowed. The petitioner is permitted to file an amended petition after serving copy to that respondent. Yes.
Serial number 20, Krishnamurthy R for petitioner, Pradeep S. Saukar.
Yes.
Actually, it is listed for hearing on my IA for early hearing. Actually, on the last date, that is on 2nd February,
It was listed under final group matters and at the request of my learned friend, it was adjourned finally to today
Yes,
under final hearing. I'm ready, ma'am.
my learned friends ready, I can argue.
I'm ready, my lord.
What is this matter, Mr.?
Lord, matter pertains to payment of provident fund.
This is a
Lord,
release
under
of,
banks, there are separate rules framed and there is an exemption granted to the bank insofar as PF regulations are concerned. There is a gazette notification to that effect. As per that, my lord, if there is a disciplinary proceedings initiated and he is dismissed from service and there is a quantification of loss caused to the bank is entitled to deduct the employer's contribution insofar as banks are concerned. That has been upheld by Supreme Court also, and there is a separate gazette notification for that. My lord, non-payment of employer's contribution of PF is what is challenged for your lordship.
No, that you have recovered because of departmental inquiry.
Department inquiry, which is upheld by this honorable court, my lord, punishment of dismissal from service and quantification of loss also, my lord, in the order of punishment is there. Is issued show cause notice saying why such amount should not be appropriated. Challenging that is before your lordship.
Yes, Mr.
actually, there are two issues, my lord. One is payment of employer's contribution along with interest, my lord. For that, in the
No, we'll pass it over. Matter request the hearing.
Sorry, my lord.
Yes. Pass over.
Lord,
This is a small matter, my lord.
No, that either it should be in that B group or hearing. In that orders list, I cannot struck. You may take how much time?
My lords may hear, allow the application for early hearing. And my lord, post it, my lord, next week for arguments.
Yes, IA 1 of 2026. ಏನು rule issue ಆಗಿದೆ ಅದರಲ್ಲಿ?
Rule last time.
ಆಗಿದೆ sir. It was listed for final hearing.
11th November rule issued.
Yes, IA 1 of 2026 for early hearing is allowed. Post this matter for hearing.
27th or 28th could you my lord date?
Fourth,
Second could you my lord date?
second, third,
ಇಲ್ಲ
second,
ಅಥವಾ
yes, second.
obliged.
ಆಗ್ಬೋದು. Great.
Cell number 21 adjourned, cell number 22, K. Ravishankar for petitioner, TP Rajendra Kumar.
Prepare for respondent, my lord, in this case.
But I filed two applications.
That the matter itself, my lord, could be disposed of out by judgment, my lord. Mandamus has been issued seeking regularization. There is a direction, my lord, I am just passing on the order. Put of the world. Similar matters, my lord. This court has passed an order. Last page, my lord, is.
Keeping in view of the expectation found, I don't bet so on. So, yes, Mr.
Let kindly have a look at my prayer
Yes.
in the red petition. But there are three prayers in page number 11.
Yes.
One is with regard to the representation.
Hmm.
Another is with regard to Milord to regularize as is been ordered by this honorable court in WP.
Hmm.
Second prayer.
Hmm.
The third prayer is Milord with regard to the Manish Singh Gupta's case.
Hmm.
Milord, kindly have a look at this honorable court order and page Milord annexure F page 40. Operative portion is annexure page 121. Last
I thought you let them consider
Yes.
keeping in
ಅಲ್ಲ,
view of that all.
ನಾನು ಹೇಳೋದು what they are doing is they are creating artificial breakup. The temporary ad hoc employees cannot be replaced by another set of ad hoc employees, the settled proposition of law. But it can only be done only by filling up of a regular post as envisaged under the PR Singh and latestly the Manish Singh Gupta reported in 2022 Supreme Court judgment. But this court has already held that they should be regularized. And have a look at that is why I pointed out.
ಆಯ್ತ್ರಿ ಈಗ in terms of that let him consider they have to
ಅಲ್ಲ ಎಲ್ಲ ಮಾಡುತ್ತಾರೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿ ಬಿಸಾಕ್ತಾರೆ.
reject ಮಾಡ್ಲಿ ಆಮೇಲೆ ಬನ್ನಿ here no order has been passed.
But I am your last may kindly say so in the light of my prayer number 3.
No, you see that page 17 of that. ಅಲ್ಲಿ ಆಲ್ರೆಡಿ 3 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಹೇಳಿದ್ದಾರೆ. ಅದ್ರ ಜೊತೆಗೆ ನಿಮ್ದು ಇನ್ನೊಂದು ಸೇರಿಸಬೇಕು.
ಆಯ್ತು ಈ ಪ್ರೇಯರ್ ಮನುಷ್ಯ
ಅಲ್ಲಿ ಜಗ್ಗು ಹೇಳಿದ್ದಾರೆ, ಧರ್ಮ್ ಸಿಂಗ್ ಹೇಳಿದ್ದಾರೆ, ಇದು ಇನ್ನೊಂದು ಯಾವ್ದು ಹೇಳಿದ್ದಾರೆ?
ಎರಡು ಹೇಳಿದ್ದಾರೆ. ನಂದೊಂದು 2022 15 SCC 540 annexure H page 132.
ಕೊಡಿ ಅದ
ಅಲ್ಲ ಅಲ್ಲಿ ಇದೆ ಪಿಟಿಷನ್ ನಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ
ಪೇಜ್
132.
Yes.
Manish Gupta. Let the Supreme Court says kindly have a look at para 13 onwards. And lastly, it says it can only be done by a regular employment, not otherwise.
Yes. In this petition, petitioner sought following relief. ನೀವೆಲ್ಲ teaching or non-teaching staff?
Non-teaching.
Yes. The petitioners are working in different posts of non-teaching staffs for more than 10 years continuously in the Mysore University. The petitioner have submitted a representation to the respondent university to consider that request of the petitioner for regularization. Notwithstanding the same, respondent have failed to consider the request of the petitioner ಇದು brief facts of the case as follows and are illegally denying the benefit of regularization. Hence, the petitioner has submitted a representation wide annexure
E, page 38.
wide annexure E. Hence, filed this writ petition seeking for direction to the respondent to consider annexure A. Learned counsel appearing for that university has submitted that in identical matter, this court has disposed of the writ petition in WP number 20452 of 2022 on 6 November 2025. In the terms, the above writ petition can be disposed of. In view of the above, without expressing any opinion on the merit of the case, the following order is passed. The writ petition is allowed. Component number 2 is directed to consider that representation submitted by the petitioner wide annexure E dated so and so, keeping in view of the position of the law laid down by that honorable apex court, adralli hakidare avardನ್ನು ಹಾಕ್ಬಿಟ್ಟು, and also
Annexure H, page 132.
in case of Manish Gupta and others reported in 2022 15 SCC 540 accordance with law within 8 weeks from the date of receipt of copy of this. Yes,
They shall not be disturbed till then.
you are already in that
Yes,
service.
yes, either.
If the petitioners are in service, they shall not be discontinued from the service till consideration of their representation.
Public.
All pending applications are disposed.
Serial number 23, Prakash MH for petitioner, Abhishek Kumar.
Identical writ petition as the previous one. But this is the continue, the next stage wherein the petitioners have suffered an order at the instance of the respondent number 1. That is the
Salaries, Lords. With respect to the salaries, they have filed an application. Lords, now the petitioner, my lords, has been relieved. This court of my lords has not given an interim order, my lords. Now the my lords, the petitioner has been relieved, my lords. Some of the employees, my lords, who are the permanent employees, my lords, have been posted. The case was, my lords, the particular institution, my lords, where the petitioner were working was the constituent college of the university. My lords, the university was the right person to appoint anybody, my lords, even if the temporary employees. In this case, my lords, the principal, my lords, who is the head of the institution, my lords, having no power, my lords, has appointed this particular petitioner, my lords. Hence, my lords, they have been relieved. My lords, with respect to, my lords, the salaries, my lords, your lordships has directed me to, my lords, seek instructions. My lords, post facto, my lords, whatever the interim order was passed by this honorable court in the earlier writ petition,
Yes.
Till the last date of, my lords, the employment, it has been paid. My lords, from 4th July 2024 to 28th February 2025.
4 July
2024. My lords, to 28th February 2025.
28 January.
28th February 2025.
Yes.
My lords, they have worked, my lords, without there being an order issued by the institution.
Yes.
My lords, they have worked, my lords, to that extent. My lords, our difficulty is, my lords, without there being an order of continuation, my lords, they have worked. Hence, my
No,
lords,
interim order was there.
my lords, that is after that. Whatever the interim order was there, my lords, we have paid.
No, on 4th July 2024, what you have removed from their service?
My lords, we have not given the extension order. But
When they have approached this court?
My lord, sir.
When was that interim order?
First week of March 2025.
No, you are, till then you
But,
have not
yes,
approached us.
No. What happened?
No, from
For-
4 July 24, you
Please,
have been.
please,
Yes.
please. 1st of July 2025, we were ordered to be terminated.
No,
Well, thereafterwards, by oral instructions, we were allowed to work.
no, I am
And-
asking that he's saying 4 July 2024.
2024 in the end of February 2025, we were continued in the work. My lord, in the last phase of February
No,
2000.
is there any official communication on
Ye-
4 July
Yes,
2024?
ಮಾಡಿದ್ದಾರೆ ಅಕ್ಕ. ಇದು ನೀವು ವರ್ಕ್ ರೆಸ್ಯೂಮ್ ಮಾಡಿ ಅಂತ ಎಲ್ಲ ಡಿಫರೆಂಟ್ ಆಫೀಸ್ ಆರ್ಡರ್ಸ್
I am asking that on 4 July 2024, is there any official communication for you to that, not to come to that work?
ಇಲ್ಲ ಆತರ ಯು ಆರ್ ರಿಲೀವ್ಡ್ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ರು.
ಅದೇ ಆರ್ಡರ್
ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ದಟ್ ವಾಸ್ ದೇರ್ ಆಫ್ಟರ್ವರ್ಡ್ಸ್ ವಿ ವರ್ ಪರ್ಮಿಟೆಡ್ ಟು ವರ್ಕ್.
ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಅದು?
ಪ್ಲೀಸ್. 37. But 3724 annexure G,
Page.
page 130, I'm sorry. 44 petitioners in the previous writ petition ಕರ್ತವ್ಯದಿಂದ ಬಿಡುಗಡೆಗೊಳಿಸಲಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರು.
ಮದ್ಯಪಾನದಿಂದ ಬಿಡುಗೊಳಿಸಲಾಗಿದೆ.
Please.
ಆಮೇಲೆ ನೀವು they have worked according to.
They worked, my lord.
Then
In fact,
Hence,
wait,
please,
he
please.
is not disputing that. Yes.
But hence my request is, my lords, let there be a direction from the court because of the reason, my lords. Now the university in the difficulty, my lords, without a,
After that 28th June, January 25, they have not worked.
my lords, after the impugned order has passed, my lords, now they have not completely worked.
Yes.
My lords, for
Now,
8
first
months.
we'll see, we'll directed you to pay that salary from this period. Then
up to February, like end of February
no, 28th January 2025.
25 and November 2025 and December until the point of the impugned order is passed.
Consider one by one.
Yes, one by one.
Yes.
My lords.
ಎಷ್ಟು ದುಡ್ಡು ಕೊಡ್ತಾರ ಅಷ್ಟು ಫಸ್ಟ್ ತಗೊಳ್ಳಿ ಆಮೇಲೆ ನೋಡೋಣ
ಯಾಕೆಂದ್ರೆ ಹತ್ತತ್ರ 70 ಲಕ್ಷ ಬಾಕಿ ಇದೆ.
Allah, my lords, I cannot say on the amount, my lords.
I can understand the difficulty of my
Whatever that materials you have produced that you are working.
My lords, they have maintained their own attendance, my lords, which they have already produced to us now. On
You
that
have not
very,
disputed that.
no, my lords, on that basis, my lords, we will do it. My lords, the difficulty is, my lords, there is no order, my lords, of extension. That, my lords, may be directed by.
That I will.
Please, my lords.
By court order, I will direct.
It
Which are
comes
the
up to,
documents you
it
have
comes up to
Yes,
8
yes.
months, my lords, from
Yes,
4th
yes.
July 2024 to 28th February 2025.
Documents to
That
show
kindly
that,
come
to
to-
pass my order, to show that they have worked. Where is that document?
Yes, Lord, post passing of this order on 3/7/2024, page 130, Lord, immediately we have given a representation at page 132, annexure H. Thereafter, kindly come to page 134, annexure J. For 3 of the petitioners, an office order was issued. Next, at page 135, for 2 of the petitioners. And at annexure L, page 136, 30/11/24, for about 26 the remaining petitioners.
Issued.
Yes.
Order is issued, Mr.
Yes,
To work.
sir.
My lords, that is, my
And-
lords, 30/11/2024. That again, there'll be a gap, my lords. Instead of that, my lords, your lordships
ಲಿಖಿತ
may say.
ಪರೀಕ್ಷೆಗಳು so and so. Yes.
instead
ಇದನ್ನ?
of- Because, my lords, if in case we take on this thing, my lords, again, there will be a gap, my lords, from.
No, I will clarify that.
Since, my lords, anybody has worked with the attendance, they will verify and issue
Yes,
the,
yes.
this thing is what can be said.
Yes.
If in case there are arguments is taken on record, my lords, it will become, my lords, for whatever the work order is issued, we
Yes.
may have to give the salaries. My lords, that is,
Yes.
that
yes.
becomes a
And
difficult
one-
task, my lords. Instead of that, your lordships may say, if in case they have worked, some
case-
documents to.
If in case
verify
ಅಲ್ಲ,
that.
ಇಲ್ಲ.
Yes.
ಯಾಕೆಂದ್ರೆ one second, my lord, sir. I want to clarify.
Lords, on
Identical,
this-
1 second, sir.
Yes.
Identical application was filed in the previous writ petition,
Yes.
wherein my learned friend, the university and the college have submitted the statement of objection. They have conceded that for 4 months, from July to, the October.
Yes,
There afterwards, then the documents which we have produced
yes.
are manifesting that we have continuously working. If at all we were relieved, there is no question for the college to indicate these petitioners to resume particular nature of work. And I can understand the difficulty what my learned friend is expressing.
No,
But
no, no,
for
I
8
will
months-
make my order.
Yes, please,
By
sir. That's why.
document shows that they have worked for that
Yes.
period. Therefore, they are
And,
entitled, you pay.
and one thing, my lord,
Yes, I want to go on merits,
throughout
my lords.
eight
This order-
months.
No, no, not on that merit.
This
By-
orders which of
Use this
extension.
document shows that they have worked from the period of 4 July 2024 to 28 January
To
2020.
verify
February.
the same
February.
and issue my lords salaries within the
And-
time frame.
and
your
one thing, my
lordships
lord,
may say, my lords, we will.
Throughout the 8 months period, a provident fund amount is deducted by the college and they have not deposited to the concerned
All that
authority.
we'll see, Mr.
Yeah,
First,
please.
let them give an
My lords,
example.
once we are giving this, my lords, we, the only
All
difficulty.
you can say subject to the result, Mr. Even then it is, that payment is also
Yeah,
subject.
please,
Don't-
first we need to,
Yes. IA 2 of 2026 is filed for direction to payment of salary. The petitioner was appointed on contract basis as a lecturer or professor,
the non-teaching staff. my lords.
appointed on a temporary basis
There are 34 petitioners. my lords, sir.
in non-teaching post. By communication, where is that communication?
The next year, G, page 130, my lords.
Appointed by my lords, the respondent number 1.
130 page.
Yes, by communication, annexure G, dated 3/7/2024. In view of their contract term has been expired from 3/7/2024. They have been relieved from the service. Learned Counsel appearing for the petitioner submitted that even after that passing order dated 3/7/2024, they have submitted a representation seeking for continuation of their service. And he contended that thereafter, till passing that impugn order herein, they have worked in that respondent college. To that effect, he has produced annexure J, K and L. The documents produced by the petitioner prima facie shows that even after passing that order annexure G dated 3/7/2024, they have worked till end of January 2025.
ಇದು February.
January and February.
February, my lords, 28 February.
Yes, till February 2025. Therefore, the respondents who has to,
My
Respondent
lords,
number 1.
Respondent 1, my lords.
respondent number 1 is directed to verify that records and pay that salary to that petitioner from the month of July 2024 to February 2025. If any payment is made, he is also subject to the result of this petition.
Without expressing anything on the merits, my lords.
Is subject to the result under, yes,
Please.
and directed to complete that process within 4 weeks from today. Yes,
A date may be given, notes.
within 4 weeks, they have, yes,
At least 2 weeks. ಯಾಕೆ ಅಂತಂದ್ರೆ ಒಂದು ವರ್ಷದಿಂದ ಇವರೆಲ್ಲ ಏನು ಗ್ರೂಪ್ ಡಿ ಎಂಪ್ಲಾಯೀಸ್
I'll try to get
ಒನ್
it earlier,
ಸೆಕೆಂಡ್
my lords.
now
6
within
weeks.
4 weeks ಅಂತ ಅಂದ್ರೆ it's a maximum.
Maximum,
They can do
right.
it 2
We will
weeks
try to.
later. Yes.
Can I seek for fixing of the date after?
ಇವತ್ತೆಷ್ಟು ಸರ್ ಇವತ್ತು 18th. I will have it on 23rd March.
Please,
Only 4
at least an observation could be made, looking into the status of the petitioners.
That is what
The
that-
college is directed to, maybe directed to, take the case of the petitioners, my lord.
My lords, they are
Or
trying
what?
to re-argue on this again, my
No,
lords.
that merit will come.
Yes.
First you take that salary that.
Please.
He is also not disputing, therefore I have straight away directed to.
Grateful to my
The
lord.
initial appointment was itself illegal. My lords, they also know
Can see,
that.
Mr. Yes.
The group matter, Serial number 24, Manju MS for petitioner, N. Sriram
My lord,
Reddy.
my lord, I am
My
for
lords.
the respond number 1.
I'm a proxy counsel appearing, my lords. Kindly pass over.
You are appearing for?
Petitioner, my lords.
What is this matter, madam? From 2015, dismissal.
My lords, I'm proxy counsel, like kindly pass over.
Or
Kindly go through the last occasion, the orders of the last occasion, my lord.
IA 1 of 2025 for vacating stay. Yenagide vacating. You have filed an IA for vacating, mister.
It is not required, my lord. She is
Then
already.
we'll post for hearing.
Yes, my lord. Once it was in 10/1/2018 itself, it was dismissed for non-prosecution, my lord. The council is not attending the court. That's why
Mr.
last occasion, your
Mr.
lordship has
Reddy.
passed. Yes, my lord.
No, IA 1 of 2015 you have filed. Yes, for vacating. That will be, yak post agide ಇವತ್ತು orders ಗೆ?
It will become infructuous, my lord, now.
None appears for the petitioner at last chance leave this matter on 18/2/2026 ಅಂದ್ರೆ ಇವತ್ತ for hearing ಅಂತಂದ್ರೆ big group ಗೆ ಹಾಕ್ತಾನೆ. For hearing ಅಂತಂದ್ರೆ why it has been posted? ಏನ್ ಮೊದಲು ಬರುತ್ತೆ? ರೂಲ್ ಇಶ್ಯೂ ಆಗಿಲ್ಲ ಇದರಲ್ಲಿ. ಹ? ಮತ್ತೆ? Yes, we'll post it for what is that? Why it's become infructuous, mister?
He is already retired from the service.
What is that he is challenging? No, even if it is retired, that
No,
punishment
they-
is set aside, he is entitled for all benefit. Yes, post for
My lord, the appellant has challenged the orders of the KAT.
order of
KAT. My lord,
EAT.
kindly go to page number 81, my lord. 81 of
EAT order. Cooperative society. Yes, yes. IA 1 of 2025 is dismissed as not pressed. Is this matter in hearing? Yes. Hearing list, yes.
Kindly give the date, my lord.
On 11th, yes.
Okay.
Serial number 25, TP Rajendra Kumar for petitioner, government advocate.
Okay, for petitioner, my lord, in this.
Yes.
Petitioner, my lord, was considered as an excess teacher. My lord, in an institution. My lord, was ordered to be transferred to other schools. My lord, it was 4 teachers were considered as excess teachers. White annexure D, my lord, page 29.
In which school you are studying, teaching?
My lord, the Navaratna Kannada Vidya Prathamika Shale. My lord, there, my lord, it was found that there were 4 excess teachers were there. Then, my lord, page 30, my lord, may kindly be seen, the next page ಅಲ್ಲಿ. ಹೆಚ್ಚುವರಿ ಶಿಕ್ಷಕರ ಬಗ್ಗೆ. These 4, my lord, last 4 ಜನ, ವೆಂಕಟಾಚಲಯ, ಗೋಪಾಲಕೃಷ್ಣ, ಗೀತಾ and ಲೀಲಾವತಿ. Then, my lord, they said they would give allotted some other places. Then, my lord, white annexure F, page 39 may kindly be seen. There, my lord, the 2 persons, my lord, were allotted. See, my lord, the counseling to other schools. Gopa, Venkatachalaya, Geeta. The other one, my lord, did not come. Then, my lord, for me, my lord, they did not allot anything.
Yes.
Representations were given, nothing has been done. Then, my lord, I filed a writ petition before this honorable court, seeking for a direction. Lord, that is the order, my lord, the passed in the writ petition is that one minute, my lord, just page number 79, my lord. Direction was issued, my lord, it was on 6th April 2017. Tell my lord, the para 4, my lord, is further contended the petition has made a representation by annexure H and dated so and so. It is submitted the respondents are not initiated any action pursuant to the same, and the representation remains pending. It is also pointed out that annexure L, the writ petition dated 2016, the petition has also issued a legal notice despite that respondents remained mute speculators. And additional government submits that if 2 months time is granted, the representation of petitioners will be considered in accordance with law. Submission is placed on record. The writ petition is disposed of, directing respondent number 2 to consider and dispose of annexure H within the period of 2 months. There, my lord, we have sought for a transfer of from other college, and also the salary, my lord, because the salary was also not paid. Because there is a government order. which
Then what
says-
has happened to that
Then,
representation?
my lord, this representation, my lord, now by virtue of this, the representation was considered, but the order does not say anything about the transfer of page number 95 may kindly be seen, my lord. This is the endorsement which they have issued.
ಏನು ಮೇಲಿನ ವಿಷಯಕ್ಕೆ
26/8/2017. ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದೆ ಶ್ರೀ ಲೀಲಾವತಿ ರಿಟರ್ಜ್ ಸೋ ವರದಿಯನ್ನು ಮಾನ್ಯ ಉಪನಿರ್ದೇಶಕರು ಸೋ ಅವರಿಗೆ ಸಲ್ಲಿಸಲಾಗಿತ್ತು. ಉಲ್ಲೇಖ ಪತ್ರದಲ್ಲಿ ಹಿಂಬರವು ನೀಡುವಂತೆ ಆದೇಶಿಸಿದ್ದು ನೋ ವರ್ಕ್ ನೋ ಪೇ ಅಂತೆ 191 ಅವರಿಂದಲೇ ವೇತನ ಅನರ್ಹರೆಂದು ಬರೀತಾರೆ. They do not consider about anything about my shifting of the other school. That's what challenge.
Yes, Mr.
There is absolutely no consideration at all.
Earlier, my lord, this petitioner approached this.
Transfer school of the department visited and directed, closed down the school and deputy director of instruction. But that thereafter 3 teachers were granted posting. Yes, Mr.
My lord, earlier this petitioner approached this honorable court. Petition number 1434 of 2007. This honorable court directed the respondent to consider the representation and pass appropriate order. Accordingly, we have issued endorsement on 26/8/2017.
ಏನು representation ಏನಂತ ಕೊಟ್ಟಿದ್ರು?
Representation ಇವರು salary ಕೊಡಿ ಅಂತ ಕೊಟ್ಟಿದ್ರು.
Salary ಅಲ್ಲ.
ಹೋದ್ರೆ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಅವ್ರ ಕೇಸ್ ಇರೋದೇ ನನಗೆ ಬೇರೆ ಸ್ಕೂಲಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ.
I'm coming there. After this endorsement, my lord, change is the annexure R2 man.
R2.
Before that, R1 man, page number 9 man.
Objection ಹಾಕಿದ್ದೀರಾ?
Yes, sir. Objection has been filed.
Objections ಹಾಕಿದ್ದೀರಾ? ಕಾಪಿ
Para second.
ಕಾಪಿ ನನ್ನ ಹತ್ರ ಏನು ಕೊಟ್ಟಿಲ್ಲ. I don't know.
ನೀವೇನ್ ನಿಮ್ದು objections ಗಳು ಕಾಪಿ ಅವರಿಗೂ ಕೊಡಲ್ಲ ನಮಗೂ ಕೊಡಲ್ವಾ? ಇಲ್ಲಿದೆ. Yes. Yes, para.
Page number 9.
Yes.
R1 is the inspection report map. In appropriate carriage, page number 9, second term.
Yes.
ಸದರಿ ಶಾಲೆಯು ನವರತ್ನ ಕನ್ನಡ ನರ್ಸರಿ ಮತ್ತು ಹಿರಿಯ ಪ್ರಾಥಮಿಕ ಶಾಲೆ ಎಂಬ ಹೆಸರಿನಲ್ಲಿ ಸ್ಥಾಪಿತವಾಗಿ ಆಡಳಿತ ಮಂಡಳಿ ಒಳಜಗಳದ ಫಲವಾಗಿ ಮತ್ತು ಬಾಡಿಗೆ ಕಟ್ಟಡದಲ್ಲಿ ನಡೆಯುತ್ತಿದ್ದು ಆ ಕಟ್ಟಡದ ಮಾಲೀಕರು ನ್ಯಾಯಾಲಯದಿಂದ ಶಾಲೆಯನ್ನು ಖಾಲಿ ಮಾಡಿಸುವ ಆದೇಶವನ್ನು ತಂದ ಕಾರಣ ಸದರಿ ಶಾಲೆಯನ್ನು ಆ ಸ್ಥಳದಲ್ಲಿ ಈಗಿರುವ ಬಾಡಿಗೆ ಕಟ್ಟಡಕ್ಕೆ ಸ್ಥಳಾಂತರಗೊಂಡಿಸಿರುತ್ತಾರೆ. ಅಲ್ಲಿದ್ದ ಕೆಲವು ಶಿಕ್ಷಕರು ಮತ್ತು ಸ್ಥಳೀಯ ಪೋಷಕರು ಸೇರಿ ನವರತ್ನ ಕನ್ನಡ ನರ್ಸರಿ మరియు ಹಿರಿಯ ಪ್ರಾಥಮಿಕ ಪೋಷಕರ ಶಾಲೆ ಮತ್ತು ಶಿಕ್ಷಣ ಸಂಘ ಈಗಿರುವ ವಿಳಾಸದಲ್ಲಿ ಶಾಲೆಯನ್ನು ನಡೆಸುತ್ತಾರೆ. ಈ ಸ್ಥಳಾಂತರಕ್ಕೆ ಸರ್ಕಾರ ಇಲಾಖೆಯಿಂದ ಪೂರ್ವಾನುಮತಿ ಪಡೆದಿರುವುದು. ಈ ಕಾರಣದಿಂದ ಕೆಲವು ತಿಂಗಳಿಂದ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ವಲಯ 1ರ ಕ್ಷೇತ್ರ ವಿದ್ಯಾಧಿಕಾರಿಗಳು ಶಾಲೆಯಲ್ಲಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಶಿಕ್ಷಕರ ವೇತನವನ್ನು ನಿಲ್ಲಿಸಿರುತ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಪಾಯಿಂಟ್, ಸಂದರ್ಶಕರ ಅಭಿಪ್ರಾಯ, ಶಾಲೆಯನ್ನು ಈಗ ನಡೆಸಿರುವ ಶಿಕ್ಷಕರ ಮತ್ತು ಪೋಷಕರ ಸಂಘ ಇಲಾಖೆಯು ಸರ್ಕಾರ ಮಾನ್ಯತೆಯನ್ನು ನೀಡಿರುವುದು. ಆಮೇಲೆ ಶಾಲೆಯು ನಡೆಸಲು ಯೋಗ್ಯವಿರುವುದು. ಥರ್ಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್, ಮೇಲ್ಕಂಡಂತೆ ಸದರಿ ಶಾಲೆ ಎಲ್ಲಾ ರೀತಿಯ ನ್ಯೂನತೆಗಳಿರುವುದರಿಂದ ಶಾಲೆಯನ್ನು ಮುಚ್ಚುವ ಬಗ್ಗೆ ಈಗಿರುವ ಆಡಳಿತ ಮಂಡಳಿ ಕೂಡಲೇ ನಿಯಮಿತ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿ ಶಾಲೆಯಲ್ಲಿ ಈಗ
ಆಯ್ತ್ರಿ, ಅದಕ್ಕೋಸ್ಕರನೇ ಅವ್ರನ್ನ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಕ್ಕೆ
ಕಂಡಕ್ಟೆಡ್ ಕೌನ್ಸಿಲಿಂಗ್ ಹೇಳಿದೀವಿ ನಾವು. ಈ ಕಾರ್ಯದಲ್ಲಿ ಹೇಳಿದ್ವಿ, ವ್ಯಾಸಂಗ ಮಾಡಿರುವ ವಿದ್ಯಾರ್ಥಿಗಳ ವಾರ್ಷಿಕ ಪರೀಕ್ಷೆ ನಂತರ ಅವರುಗಳ ಫಲಿತಾಂಶವನ್ನು ಪ್ರಕಟಿಸಿ ಎಲ್ಲಾ ಮಕ್ಕಳಿಗೆ ವರ್ಗಾವಣೆ ಪತ್ರ ನೀಡಿ ಅವರುಗಳು ಸಮೀಪದ ಅಧಿಕೃತ ಸರ್ಕಾರಿ ಖಾಸಗಿ ಶಾಲೆಗಳಿಗೆ ದಾಖಲು ಮಾಡಿಸುವ ಸೂಕ್ತ ಕ್ರಮ.
ಆಯ್ತ್ರಿ, ಅದಾಯ್ತು, ಅದನ್ನ ಯಾಕೆ ಓದ್ತೀರಾ? ಅದಾದ್ಮೇಲೆ ಎಕ್ಸಸ್ ಟೀಚರ್ ಅಂತ ಟ್ರೀಟ್ ಮಾಡಿರೋದು.
ಕಂಡಕ್ಟೆಡ್ ಕೌನ್ಸಿಲಿಂಗ್
ಎಲ್ಲಿ?
annexure R2 man, page number 10 man. She is not participated in the counseling.
ಎಲ್ಲಿದೆ ಕೌನ್ಸಿಲಿಂಗ್? ಈಗ ಇವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಕೌನ್ಸಿಲಿಂಗ್?
annexure R2 man.
ಹೇಳಿ.
ಮೇಲ್ಕಂಡ
ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಸರ್ಕಾರ ಸೂಚನೆ ಹೆಚ್ಚುವರಿ ಶಿಕ್ಷಕರು ಗುರುತಿಸಿ ನಿಮ್ಮ ಆಡಳಿತ ಮಂಡಳಿ ಈಗಾಗಲೇ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿ
ನಿಯಮ 10 ಮತ್ತು 11
ಸಭಾ ಸೇವಾ ಕೆಲಸದಲ್ಲಿ ಕಿರಿಯರು ಎಂದು
ನಿಮ್ಮ ಆಡಳಿತ ಮಂಡಳಿ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿ ಶಾಲಾ ಸಿವಿಲಿಟಿ ಆಕ್ಟ್ ಕಿರಿಯರು ಲಭ್ಯವಿರುವ ದಾಖಲೆಗಳನ್ನು ಕಂಡು ಬಂದಿರುವ ಮೇಲ್ಕಂಡ ನಿಯಮಗಳ ಪ್ರಕಾರ ನಿಮ್ಮನ್ನು ಹೆಚ್ಚುವರಿ ಎಂದು ಗುರುತಿಸಿ ಉಲ್ಲೇಖ 2 ಮತ್ತು 3ರ ಆದೇಶ ಸರ್ಕಾರಿ ಪ್ರಾಥಮಿಕ ಶಾಲಾ ರಿಕ್ತ ಸ್ಥಾನಗಳಿಗೆ ತಾತ್ಕಾಲಿಕ ಒಪ್ಪಂದದ ಆಧಾರದ ಮೇಲೆ ಮರು ಹೊಂದಣೆ ಮಾಡುವ ಈ ಕೆಳಗಡೆ ದಿನಾಂಕಗಳಲ್ಲಿ ಕೌನ್ಸಿಲಿಂಗ್ ನಡೆಸಲಾಗಿದೆ. The counseling date fixed on 29/10/2025. And may not, she is not at all participated. That we will find in.
ಆಯ್ತ್ರಿ, ನೀವು ಅರ್ಲಿಯರ್ ರಿಪಿಟೇಷನ್ ಅಲ್ಲಿ ಮತ್ತೆ ಅದನ್ನ ಯಾಕೆ ಹೇಳಲಿಲ್ಲ? ಮತ್ತೆ ನಾವು ಅವ್ರ ಕೌನ್ಸಿಲಿಂಗ್ ಬಂದಿದ್ದು ಬರ್ಲಿಲ್ಲ ಅಂತ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ ವಾಟ್ ಇಸ್ ದಿಸ್? Why you have not produced this in that earlier writ petition, Mr.? It is 2005.
ಅದರಲ್ಲಿ ಹೇಳಿಲ್ಲ ಸರ್, ಬಟ್ ಇದರಲ್ಲಿ we have stated that plus is not participated in the counseling. Therefore it declares as no work, no pay. ಆಮೇಲೆ page number 13 ಅಲ್ಲಿ we have mentioned.
ಆಯ್ತು, ಈಗ what is your age, Mr.?
Lord, now, my lord, she has retired now. But thing is, my lord, we are entitled, my lord, I am entitled for the salary, my lord, which during that period.
See,
Government order ಇದೆ ಅದಕ್ಕೆ.
Allala, when you have been treated as an excess teacher?
Lord, in 2000, my lord.
2000?
2000 ಅಲ್ಲೇ. Annexure D, my lord. 1906-2000.
1906-2000.
Annexure D, page 29. ನಿಮ್ಮ ಆಡಳಿತ ಮಂಡಳಿ ಅಧೀನದಲ್ಲಿ ನಡೆಸುವ ಶಾಲೆಗಳಲ್ಲಿ ಬರುವ ಹೆಚ್ಚುವರಿ ಶಿಕ್ಷಕರ ಬಗ್ಗೆ, ಬಿಕಾಸ್ ಮೈ ಪೋಸ್ಟ್ ಇಸ್ ದ ಗ್ರಾಂಟಿನೇಟ್ ಪೋಸ್ಟ್.
ಆಯ್ತು, ಗ್ರಾಂಟಿನೇಟ್ ಪೋಸ್ಟ್
ಇದ್ರೆ ಮಾತ್ರ
2005 ಅಲ್ಲಿ ಪ್ಲೇಸಿಂಗ್ ಕೊಡ್ತೀವಿ ಅಂದ್ರೆ ನೀವು ಬರ್ಲಿಲ್ಲ.
ಇಲ್ಲ, we have attended. In fact, kindly see, my lord, paragraph 14 of my petition, my lord. I clearly said.
You have attended.
ಹೌದು. Please turn, my lord, paragraph 14 of my petition, my lord.
Yes.
Readings ಅಲ್ಲಿ. It is submitted that the statements made in the communication dated 27/7/2017 void annexure Q about the absence of the petitioner at the time of counseling is totally incorrect, as the petitioner had in fact attended the counseling held on 29/10/2005.
Page, para
14, page 10 in page.
Yes.
Communication is totally incorrect, as the petitioner has in fact attended the counseling held on 29/10/2005. Pursuant to the counseling order dated 24/10/2005, issued by her, a copy is, in fact, copy also I have produced, and requested to transfer her to the Sujata Kannada Higher Primary School, Ullal, Upanagara, Bangalore, where there was a vacancy for which she was informed that she would be transferred to the said school, and the order would be communicated to her. Immediately thereafter, a petition by representation dated 30/10/2005, submitted on 5/11/2005, requested the second respondent to inform her to whom the charge has to be given in the event of her transfer, as she continued to work as headmistress of Navaratna Higher Primary School. She was working as headmistress. She was considered as excess teacher. She had to hand over. Then, my lord, they are requested. In fact, the Navaratna school, my lord, there was a, I mean, in
ಆಯ್ತ್ರಿ, ನೀವು ಕೌನ್ಸಿಲಿಂಗ್ ಹೋಗಿದ್ದಕ್ಕೆ ಏನಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್? Have you produced any documents for that counseling?
ಅಲ್ಲ, ನಾನು ಕೌನ್ಸಿಲಿಂಗ್ ನೋಟಿಸ್ ಬಂದಿದ್ದ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು.
ನೋಟಿಸ್, ಅದನ್ನೇ ನೋಟಿಸ್ ಅವರು ಕೊಡ್ತಾ ಇರೋದು. ಅವ್ರ ಅನೆಕ್ಷರ್ R2 ಅಂತ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಅಲ್ಲ, ನಾನೇ ಅನೆಕ್ಷರ್ S ಅಂತ ನಾನೇ ಮಾಡಿದ್ದೆ ಮುಂಚೆನೆ.
ಅನೆಕ್ಷರ್ S.
ಹೌದು.
ಇಲಾಖೆಯ ಮುಂದಿನ ಕ್ರಮ ಜರುಗಿಸಲು ಮುಂದಿನ ಸೋ ಅದನ್ನ ಅವ್ರು R2 ಅಂತ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಹೌದು.
Annexure R3 ನಲ್ಲಿ we have conducted the counseling, and all the two teachers, they participated in the counseling. They acted a particular place, my lord. Whereas, my lord, in respect of petition is concerned, she is offline, my lord, therefore her name is not.
ಎಲ್ಲಿದೆ?
R3 ನಲ್ಲಿ. R3 2006, my lord. There are two teachers, my lord.
No, annexure
R3, my lord.
Page
number 16, my lord.
I do not have a copy of the objections, my lord. I will just
ಕಾಪಿ ಕೊಡಿ ಅವರಿಗೆ.
copy ಕೊಡಿ.
You verify, Mr.
Yes, my lord.
True, then it cannot, yes. At the request of petitioner, leave this matter.
Short date may kindly become, because it is the knowledge ಇದು.
Yes.
Next week, my lord, end date.
12th.
Next week ಅಲ್ಲ.
Next week full ಇದೆ. Let us see on 12th. We are giving date on 16th ಗೆ ಹೋಗಿದ್ದೀವಿ. Yes.
Serial number 26, Narayana Bhatt M for petitioner. Take Rajendra.
Yes.
For the petitioner.
For respondent, my lord, in this case.
Ready?
I am ready. I find my objections, but in this case also, my lord, he has retired from service, from the university services.
Idರಲ್ಲಿ I was compulsorily retired. My lord, there was an interim order. I continued till retirement. My lord, my gratuity and my lord, commutation of pension, that has been withheld.
No, that compulsory retirement, you are entitled for all pensionary benefit also.
I am entitled to, but I completed, my lord, I had a normal retirement by virtue of the interim order.
Yes.
Charge ಏನಂದ್ರೆ ಗವರ್ಮೆಂಟ್ ಇಂದ SC/ST ಗಳಿಗೆ ಸ್ವಲ್ಪ ದುಡ್ಡು ಬರಬೇಕಾಗಿತ್ತು. ಅದನ್ನು ನಾನು ಕ್ಲೈಮ್ ಮಾಡಲಿಲ್ಲ ಆಸ್ ಎ ಅಸಿಸ್ಟೆಂಟ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಅಂತ. ನನ್ನ ಮೊದಲಿನ ಪ್ರೆಡಿಸಿಸರು ಕ್ಲೈಮ್ ಮಾಡಿ ಅದು ಸಿಕ್ಲಿಲ್ಲ, ನನಗೂ ಸಿಕ್ಲಿಲ್ಲ. ಗವರ್ಮೆಂಟ್ ಕಮ್ಯುನಿಕೇಟೆಡ್ ದಟ್, ಮೈ ಲಾರ್ಡ್, ದೇ ಹ್ಯಾವ್ ಸ್ಟಾಪ್ಡ್ ಫ್ರಮ್.
Now what is the challenging is that imposing that penalty.
Imposing penalty. ಗವರ್ಮೆಂಟ್ ಇಂದ ಬರ್ಬೇಕಾದ ದುಡ್ಡಿಗೆ ನಾನ್ ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಅಂತ ನನ್ನಿಂದ 7.5 ಲಕ್ಷ ಹಿಡಿದಿಟ್ಟಿದ್ದಾರೆ. My lord, the government said we have stopped it from 2003 to 4. Thereafter, no reimbursement to the university ಅಂತ ಗವರ್ಮೆಂಟ್ ನವರೇ ಉತ್ತರ ಬರೆದಿದ್ದಾರೆ. ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು ಕೂಡ ಈ ಎಂಕ್ವೈರಿ ಆಫೀಸರ್ ಇದ್ಯಾವುದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡದೆ I am held liable, my lord.
This is based on the inquiry, my lord, by the retired district judge.
ರಿಟೈರ್ಡ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಆದ್ರೆ
Also, if his writ petition is dismissed, he has retired as a compulsory retirement, he is entitled for all benefit. Only during that period of this thing, till that retirement date,
Recovery no ಇದೆ, about 7 lakhs and I think.
recovery is the order is there.
ರಿಕವರಿ 7.5 ಲಕ್ಷ ರಿಕವರಿ ಅಂತ ಹಾಕಿದ್ರು.
Recovery ಇದೆ.
Yes,
Because
we have to be clear that matter. We'll hear, when do you want?
Any date, my lord, next week.
Yes. Lead this matter on 12th. Yes.
Serial number 27, K. Srinivasa for petitioner, government advocate.
Yes.
27, K. Srinivasa.
For direction filed by the petitioner, yes, none appear for the petitioner. Leave this matter after 3 weeks.
Serial number 28, Saravana S for petitioner, Vijaya Havanur.
Respondent.
Yes,
The petitioners are employees of the first respondent.
yes.
The first respondent is an autonomous body. It is established under the Ministry of Human Resources and is fully funded by the central government. Not the petitioners, they fall under the
Who is contesting? You or?
I am first respondent. Not in fact, not last time what happened, the first respondent appeared, but the court wanted not the respondent number 3 to be present. That is the reason not the, after hearing the matter, the case got adjourned. Not the DSG was directed to be present in the matter. Because what happened, even initially they filed a representation to the Ministry of Human Resources seeking for extension of this GPF benefit. Not they said because of the financial implication, not the respondent step back.
That's not true, my lord. That in fact happened before the coordinate bench, before your lordship matter has not been argued. Let my learned friend argue it, my lord. I'm ready.
Senior
I am the
argue-
contesting
not-
respondent.
not- Because
I am the contesting respondent, DSG secondary.
No,
My lord,
last
the
time-
point is whether a government notification will apply to an autonomous body, one. Second, when a benefit specifically mentions for a benefit to be given as a one-time measure, can that be availed
I will
by way
argue,
of
but last time
representation?
kindly
can
see
be
the
seen?
order sheet. DSG presents ಅವರು ಬೇಕು ಅಂತಾನೆ ಹೇಳಿ ಮತ್ತೆ after hearing the matter.
When,
got
which date?
adjourned. Not sir, previous date, not sir.
Previous date, they
Previous
took time, my
date,
lord.
before the coordinate bench.
Huh?
Before the coordinate bench, not.
Before the coordinate bench, at the request, release this matter on 112.
Stay.
But this was the fact which transpired before the court.
In fact, my lord, I have not argued the matter. My learned friend, the
I
senior.
will hear when do you
Well,
want?
your lordship may hear it, my lord. I'm
Yes.
ready to argue.
If I find that it is
Please.
required, then we'll direct.
Very well.
Because there is no order on that.
I am the employer, I am the contesting respondent.
17th.
Very well.
Yes, release this matter on 17th.
17th March, my lord.
Yes, yes.
Lord, could it be taken up earlier, my lord?
No, this,
How pending for a
now I
long
am
time.
giving date in 23rd, mister. Every day 50 memos are moving. I have to give in a date,
But in
otherwise
the case, some
one
50
day it will be the
50 employees are there. That is
Sir,
the
we'll
reason.
take
we
a
are
chance
insisting.
if a little earlier.
10th.
Please, my lord.
Yes.
Great.
Serial number 29, Shrikant MP for petitioner, Vyas Sab BG.
Yes, at the request of government advocate, 2 weeks time is granted to file objection as a final.
Date may be fixed.
Yes, 11th. Yes.
Serial number 30, Muralidhar KB for petitioner, Nagarale Santosh.
Appear for.
I appear for
petition
R3, my
is-
lord. I have not been served with the copy of the writ
Copy
petition.
ಕೊಟ್ಟಿಲ್ಲ ಅಂತಲ್ರಿ ಬೆಳಿಗ್ಗೆ they has asked the time I said
I'll serve a copy.
you are appearing for whom, mister?
R3, Kuempu University, my lord.
Yes, learned counsel for the petitioner is directed to serve one set of copies on counsel appearing for R3. Yes, when do you want
Dismissed.
2 weeks, my lord.
Date.
this matter on 18th?
I'll serve.
Yes.
31, serial number 31, Asheshwara PN for petitioner, Kashinath JD.
Appearing for respondent, my lord.
Password.
Ready, my lord. Password.
Password. Yes.
Obliged.
Password or next week, mister?
Password. my lord. Password.
Senior will make.
Yes, password.
Serial number 32, Rajeshwara PN for petitioner,
It may be passed over, my lords. There is an
Password.
urgency.
Yes.
serial number 33, Vaishali Hegde for petitioner,
Your lordship,
Abhishek Kumar.
please pass over the matter, your lordship.
Password.
For the respondent.
Password. Yes.
Serial number 34, Narayana Bhatt M for petitioner,
My lord, I appear for the respondent, my lord. My lord, in this matter, my lord,
Petition
statement of objections are ready, my lord. We will serve a copy on the other side, my lord, and file it by tomorrow, please, my lord.
What is that you are seeking, Mr.
My lord, this is petition for Mandamus, my lord, directing the respondent. The respondent company, limited company is constituted and under the management of Minister of Defence, my lord. Under the petitioners who are all the employees of the respondent company, my lord. 2 FIRs were registered. Subsequently, after trial, my lord, all the petitioners, the 2 cases which were registered against the petitioners were acquitted, my lord. My prayer before my lordship is, my lord, during the period of existing the trial, during the time of a criminal case, pendency of criminal case, all the service benefits were upheld and withdrawn, my lord. They were not released. My prayer before my lordship is to direct the respondent to release the service benefits of the petitioners, my lord.
If my learned friends arguing on merits, my lord, my lord, my preliminary objection is, my lord, he is a workman. Lord, there are 2 categories of employees in HAL. One is officers and workmen are scale 1 to 10. He's admittedly a workman. Whether I have rightly, my lord, stopped payment or not, what happened was, my lord, there was a strike. My lord, that strike, my lord, according to us was
Then he
illegal.
has to go to the
Industrial
labor
disputes, my lord, labor commissioner had initiated proceedings, negotiations were going on over there. My lord, meanwhile, all those people who had participated in that illegal strike, in fact, it went to the extent of damaging properties and all that. We took action against them, filed police complaint, and then, my lord, disciplinary proceedings were initiated. And then eventually, my lord, that disciplinary proceedings also culminated in certain orders. Now, my lord, if my lords, the petitioner wants to challenge those orders, or my lord,
Challenging
my
any
lord,
order.
even if it is for mandamus, my lord, if it is to be considered.
No, that what has happened to that departmental inquiry? ಏನಾಯ್ತು departmental inquiry?
Absolutely, we have no any information, no any
Where is that
departmental
Lord,
inquiry, my lord. So far,
Get information on the departmental inquiry, my lord. But what is sought to be challenged here is, my lord, the promotion that were withheld pursuant to a criminal proceedings initiated in those this thing. My lord,
criminal proceedings are squashed.
Lord,
He
I'll-
said that
Lord,
consider
I
representation.
will- Lord,
if he is
if-
eligible, you give it. Otherwise, give an endorsement.
my lord, even there is a circular to that extent after acquittal.
Lords may make it in accordance with law, my lord.
That's what that. Even if it is not said, it cannot
Lord,
be done.
keeping all contentions open, because what happens is, my lord, there are more than 10,000 workmen in HAL.
Yes.
My lord, one person comes before the Honorable High Court invoking 226 jurisdictions. Everybody starts coming.
No.
Lord, that's a big problem.
No,
Earlier
for
also happened.
mandamus, they cannot maintain.
Lord, they cannot maintain even mandamus, my lord, 226, because they are workmen.
No, even workmen.
Lord, if I have wrongly, my lord, not granted them promotion, my lord, the representation at the end of the day is about promotion. My lord, if I have not,
if they are rejected that, then they have to go before that.
my lord, that is their case. The representation, that's what it
They
says.
are not said. You are not rejected. You have held up earlier because departmental inquiry, the department criminal case. Now it is over.
Lord, the representation has been considered, my lord. In
Those
fact,
2
in my
cases
statement
were
of
ended in
objections,
acquittal, my lord.
in my statement of objections, I was going to produce that copy of the reply also.
If it is considered, then it is
My lord, I have in fact enclosed those in my statement of. I will place it on record, my lord.
Love will see. That is
Lord,
the case.
I
Let
have.
him go and challenge
I
that.
only have the draft, my lord. Annexures idralilla. Lord, I have said it over here.
What is that?
Lord, may I read it out, my lord?
Yes.
I'll just read it out. Meanwhile, during the pendency of aforesaid cases against the petitioner, respondent number 1, White Circular dated 21/3/2018 issued circular regarding promotion of workmen against whom criminal proceedings are pending contemplated. Pursuant to the orders of acquittal dated 7/10/2021 and 7/1/22, respondent company-wide circular dated 30/12/2021 directed the divisions that in respect of criminal cases 53087 of 16 and 51769 of 2015, having disposed of by orders dated 7/10/2021, the divisions are requested to process the withheld promotions, if any, under TSP, CPS, as the case may be, in respect of the petitioner with attended seniority, subject to meeting all other prescribed conditions. It was clarified that financial benefits will accrue only from the actual date of assumption of charge in the higher scale of pay. A copy of circular dated so and so is produced herewith. Subsequently, petitioner number 9, by letter dated 5/3/2022, requested for grant of financial benefit with effect from earlier date, that is 1/1/2019. To the said letter, the respondents might reply My lord, this is the response. 16/3/2022 informed the petitioner number 9 that promotions and financial benefits have been granted to him in line with the guidelines issued by him time to time, and hence his request for grant for financial benefits from effective date of promotion was not considered positively. Thereafter, petitioners through the union have now made another representation.
You don't have that copy?
My lord, I'll produce it, my lord. My lords may have it, my lord,
Just
next
to
week.
drag
I'll
on the
place it on
proceedings, my
record.
lord. My lord, even in their circular itself, they are admitted, my lord, clearly admitted.
If they have already taken a decision,
So he has to
no
challenge that.
use in that to directed him to do it again. Then either you have to challenge before the appropriate forum, or we have to.
Lord, what had happened is this, my lord, petitioner submitted representation. That representation was answered, communicated also.
No,
My
if
lord, rejected.
then cannot be by.
Now through union, they are
Sir,
raising one
they
more
have not
representation.
even given any endorsement, any
Not
reply, my lord.
communicated.
Lord, I have communicated, my lord. In fact, petitioner has produced that communication also.
ಅವ್ರಿಗೆ copy
Before your
ಕೊಡು.
lord.
Yes.
My lord, even in their circular itself, they have
81.
clearly admitted, my lord. After.
Page 81.
ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟ ಮೇಲೆ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿರೋ ಸರಿನೋ ಇಲ್ಲ ಅಂತ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದಾಗ ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಕೋರ್ಟ್ ವಿಲ್ ಡಿಸೈಡ್ ವೆದರ್ ಇಟ್ ಇಸ್ ಕರೆಕ್ಟ್ ಆರ್ ನಾಟ್. Now
Page
your
81
case
is
is
the
that only consider. If they are already consider, what directions can be issued, Mr.
So far, we have no any intimation,
ಅವ್ರು
information,
Page
my lord.
81, he has only produced the endorsement, my lord. Page 81 of writ petition. Annexure H. Cannot be considered ಅಂತ endorsement ಕೊಟ್ಟಿದೆ.
Please inform the order of the consequential benefit thereupon except the abeyance as the extent rules of the company never denied. The promotions are notified only after the disposal of that case issued to you line with guidelines issued time in this regard. So your request for grant financial benefit from the effect of date of the promotion cannot be considered. Reject ಮಾಡಿದ್ರಲ್ಲ ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಲ್ಲ ನೀವು.
My lord,
ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ, ಬರೀ mandamus ಕೇಳಿದ್ದಾರೆ.
my lord, my
Subsequent
prayer
to
is
this,
to
my lord, a
consider
representation from
to
union
release
is
financial benefits.
ಆಗಲ್ಲ ಅಂತ ಅವ್ರು
Promotions
ಹೇಳಿದ್ದಾರೆ.
promotions ಎಲ್ಲ ಅವಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ, ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಆಯ್ತ್ರಿ, ಅದಕ್ಕೆ your request for grant of financial benefit from the effect of date of the promotion cannot be considered ಅಂತ ಅವ್ರು ಹೇಳಿದಾರಲ್ಲ. ಇನ್ನೇನ್ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಡೋದು ಅವರಿಗೆ? ಅವ್ರು ಹೇಳಿರೋದು ತಪ್ಪೋ ರೈಟೋ ಅಂತ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ that will be examined by appropriate court.
My lord, one short date may be given, my lord. I will clarify.
You have produced ಮಾಡಿದ್ರ 2022 ಅಲ್ಲಿ ಮಿಸ್ಟರ್.
ಇಲ್ಲ ಸ್ವಾಮಿ.
Now what is that? They have to go to that.
But they have to go before the labor court because you're all
Or
workmen.
labor court, Mr. 2022, it's already late.
They have only admitted that they are workmen, my lord. They have only admitted in their petition that they are workmen.
Workman, any order of that company, you have to be challenged in that labor court.
My lord, my prayer is to just to during the pendency and during the withdrawal period and suspension of my service benefits, to that extent I am restricting my prayer, my lord. There I am not insisting on the from the date of promotion, my lord.
Where is your representation? No, Mr.
My lord, annexure A and B, my lord. My representation.
What is the date of representation?
It is annexure A and B, my lord.
Tell me
And
that.
that is dated 4/3/22 and another representation 1/12/2022, my lord.
4/3/2022 ನೇ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಅದಾದ್ಮೇಲೆ ಯೂನಿಯನ್ ಇಂದ ಒಂದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಡ್ಸಿ.
4/3/2022 requesting for financial benefit with effect from 1/1/2019 date of promotion. That itself has been considered and rejected, Mr. Yes, that's all.
My lord.
No, you want to withdraw and go before that, or I will pass an order that.
One short date may be given, my lord.
Not
I
short
will
date, Mr. I heard
Next
that.
week, any date, my lord.
Not next week. That is the only point. Yes.
I mean, direction may be issued, my lord, to approach the appropriate forum.
If law
Find
permits,
it.
you can go. In this writ petition, petitioner sought following relief. Learned counsel appearing for the respondent has submitted that pursuant to their representation dated 4/3/2022, respondent has issued a communication with annexure
H page 81.
with page 81 dated 16/3/2022. If petitioner has agreed, since he was a workman, he has to approach
Industrial court. Industrial tribunal.
Industrial tribunal. In view of the above, without expressing any opinion on the merit of the case, the above writ petition is disposed of, reserving liberty to the petitioner to approach appropriate court in accordance with law, if law permits. Yes.
Wait.
Number 35, MS Chandrasekhar Babu for petitioner, government advocate.
So, my lord, sir, recollect.
What is this?
Arguments were heard, my lord, in this case.
What is this matter?
This is in the writ of Mandamus, my lord. In the light of the writ petition in annexure M, my lord, sir. Pensionary benefit, interest on pensionary benefits, my lord. Lordship posed the question that in the KAT, there was an order, it is there, my lords, in page number 118, in the judgment of the application number 118 to 112, that's in the last 118, my lords, last para.
Statement of objection hakidira.
On last occasion, this honorable court has, it was heard for some time, and this I have not narrated, my lords. Your lordship kindly look at
Ellide adu?
judgment copy, annexure, idu copy ಕೊಟ್ಟಿದ್ದೀನಿ sir.
ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಾ?
I filed it before the court, my lords.
ಇದು ಅವ್ರದ್ದು objection.
200 pages ಇದೆ.
ಇದಾ? Yes. Last time bari operative portions.
Operative portions.
Where is that?
118, my lords. Page number 118.
118. 118 internal page ಆ?
ಹೌದು ಸರ್.
ಫೈನಲ್ ಆರ್ಡರ್ ಫೈನಲ್ ಪೇಜ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
ಹೌದು, ಲಾಸ್ಟ್ ಇದರ 118 ಪ್ಯಾರಾ 23 ಮಿನಿಟ್ಸ್. ದೇವಾನಿ ನಂದನ್ ಪ್ರಸಾದ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್
118. ಏನು ಇಷ್ಟು ದೊಡ್ಡದು ಇದೆಯಲ್ಲ, ಏನು ಬೇರೆ ಬೇರೆ ಇದೆಯಾ?
ದಿಸ್ ಐ ವಿಲ್ ಗಿವ್ ಇಟ್.
ಏನಿದೆ 118?
ಮಾರ್ಕ್ ಮಾಡಿ. ಲಾಸ್ಟ್ ಪ್ಯಾರಾ ಆಪರೇಟಿವ್
118. ಪ್ಯಾರಾ 8.
ಹೌದು ಸರ್, ಲಾಸ್ಟ್ ಲೈನ್.
ಕೊಡಿ ಅವ್ರು ಕೊಡಿ.
Last term, in these cases, over a period of 10 years, as on the date of the government order dated.
ಇದ್ಯಾವ್ದು ಬೇರೆ ರೀ, ಇದ್ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೀರಿ? ಇಲ್ಲಿ 118 ಬೇರೆ ಇದೆಯಲ್ರಿ?
ಹೌದಾ? ಅದೇ, that's what I do this.
ತೋರ್ಸ್ರಿ. ಇದೆಯಾ? Now what you want to refer, mister?
No, KAT application only, there was a direction to pay interest on 12%.
KAT na EAT?
KAT order.
KAT ಇಲ್ಲಿ ಏನಾಗಿದೆ? The applicant should be awarded 12% interest per annum from the date of retirement and terminating their service till the date of. ಇದು ಯಾರ್ದಿದು?
The applicants before this honorable court.
Why you have entered KAT?
Writ petition was filed, writ petition was dismissed, and contempt was filed. Contempt was what had happened. Contempt was in view of the fact that compliance was not done.
In case of period of years and so on, the government without any explanation avoid the liability to grant a pension to deemed village accountants. Thereafter come up with a 91 which constitutes the total negotiation. Applicant should be awarded 12% of interest. ಆಯ್ತು, ಇದ್ರ ಮೇಲ್ಗಡೆ ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ್ರೆ? ಅಲ್ಲ,
writ petition was filed by the state that came to be dismissed, and subsequently contempt was filed for non-compliance of the non-implementation of the order. That due to they have produced some document, and in view of the fact that bench there was there is no sitting in the quotal number 1, my lords. In the quotal number 2, compliance, the contempt was dropped, my lords. Therefore, I am before this honorable court. Annexure M, my lords.
ಮತ್ ಕೇಟಿಗೆ ಹೋಗಿ, ಅವಾಗ ಕೇಟಿಗೆ ಹೋಗ್ಬಿಟ್ಟು ಈಗ ಹೆಂಗ್ ಹೈಕೋರ್ಟಿಗೆ ಬರ್ತೀರಾ?
ಅಲ್ಲ, KAT ಇಲ್ಲಾಗಿ in the writ petition, your lordship kindly look at annexure K, my lords. In view of this honorable court has passed the order and check was issued, my lords. In the similar circumstances of the case, my lords, I only argued in the year 2015, my lords. This was the order, my lords. In the para 50, in page number 50, my lords, para 2, my lords. The additional deputy commissioner has endorsed that though in the affidavit it is not specified that the interest.
No, mister.
Alla, ee para, this is important, my lords.
No,
additional deputy commissioner himself.
There is no binding on this court regarding the jurisdiction is concerned.
Please.
Very same petitioner you are approached the KAT. Now, how can you come here, mister?
Alla, KIT ಆದ್ಮೇಲೆ there was a writ petition which was challenged, that was dismissed.
No, that is different forum and different provision, Mr.
ಹೌದು.
It is not writ, it is under KT order 227 petition has been filed before the division bench.
ಅಲ್ಲ
Now again, how can you come to here? You have to go to that KT.
ಅಲ್ಲ KIT
It's
ಆದ್ಮೇಲೆ
nothing but bench hunting.
ಅಲ್ಲ writ petition was dismissed, subsequent writ petition was filed, that writ petition was allowed and check was issued, my lords. Your lordship kindly look at
No, Mr.
annexure K, my lords.
That is not correct. That order is not binding on me. If you are asked to approach the KT, you have to go to the KT. You cannot file an writ.
ಅಲ್ಲ ಆರ್ಡರ್ ಆಗೋಗಿದೆ. In view of the fact that there was a conditional order in the KIT that has been challenged by the state, that was dismissed. Contempt was filed, challenging the validity of the order in view of the disposal of
Then
the.
you go and file in a review in the contempt or a Supreme Court. Again, what is that? Your KT is already
writ
directed.
petition ಅಲ್ಲಿ in the writ petition, my lord, earlier contempt was filed. Writ petition file ಮಾಡಿದ್ರೆ it was a disposal of the dispose ಮಾಡಿ check was issued, my lords.
No, Mr.
Annexure K for a moment, my
You
lords.
don't rely on that, all these orders, Mr. See, KT is already granted in a relief.
Not this.
It is confirmed by the division bench.
No, not it was dismissed in the division bench, my lord. State approached, that was dismissed, my lords.
That means to what, Mr.?
Endorsement ಇದಾಗಿದೆ.
ಅಲ್ರಿ ನಾನ್ ಹೇಳಿದೇನ್ರಿ ಕನ್ನಡ ಅರ್ಥ ಆಗುತ್ತೇನ್ರಿ?
ಹೌದು ಹೌದು.
It is confirmed by that order of the KT ಅಂತ ಅಂದ್ರೆ writ petition dismissed ಅಂದ್ರೆ ಎರಡು ಒಂದೇ ಅಲ್ಲ ಅನ್ರಿ?
ಹೌದು.
ಮತ್ತೆ dismissed ಆದ್ಮೇಲೆ ಮತ್ತೆ ಇನ್ನೊಂದು writ ಯಾಕೆ?
ಅಲ್ಲ ಕಂಟೆಂಪ್ಟ್ ಆಯ್ತು ಸರ್.
ಕಂಟೆಂಪ್ಟ್ ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ ನೀವು ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ತಗೊಂಡೋಗ್ಬೇಕು, ಇಲ್ಲ ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ ತಪ್ಪು ಆದ್ರೆ ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ ರಿವೈವ್ ಹಾಕ್ಬೇಕು. ಮತ್ತೆ KT ಆರ್ಡರ್ ರಿಟ್ ಪಿಟಿಷನ್ ಅನ್ನ ಇಲ್ಲಿ ಡೈರೆಕ್ಷನ್ಸ್ ಕೇಳ್ತೀರಾ?
ಅಲ್ಲ in the similarly situated circumstances, my lord, you also kindly look at annexure K, my lord.
No, that's true. That is not applicable.
ಅಲ್ಲ
No, I will say that, Mr. You have to be enforce that order by filing in a contempt itself. You can't file in one more writ petition.
Additional deputy commissioner came up before the court and
ಆಯ್ತ್ರಿ,
has
ಅದ್ರಲ್ಲಿ
given
ಮಾಡಿರ್ಬೋದ್ರಿ.
endorsement and saying that interest on
Mr.
pension.
Counsel, in that case, it can be done it. That is not the case, you can be filed. It is not proper, I will say that.
That is binding on
Otherwise,
this honorable court, my lord.
No, I will say that. It is not binding. You have to go to that either KT or that you have to file in a contempt.
There were two contempts filed, my lords.
Yes, I will
Checks
pass an
were
order. You
issued,
take
my
it that.
lords. Alla, I request, in view of the fact that your lordship kindly look at.
No, you said binding. I will say why it is not binding.
ನನ್ನ bona fides ಗೋಸ್ಕರ contempt
Not
ಅಲ್ಲಿ.
bind. You file in a contempt if that order of the KT is confirmed by the division bench, it is not complied. You cannot come before me and say that division bench is not, it is not in a contempt, Mr.
ಅಲ್ಲ, for a moment, my lords, contempt though ಒಂದು ಆರ್ಡರ್ ಇದೆ sir. ಅದನ್ನ I request your lordship to look at.
No, I will say that, Mr.
Annexure N, my lords. ಅಲ್ಲ, annexure N ನಲ್ಲಿ chief justice has endorsed saying that in view of the fact they are in the fag end of the age, 85 years, 78 years, 79 years, positive order is to be passed. That's what the condition, annexure N, my lords.
Where is that?
56, my lords.
Yes.
In this, my lords, 58, my lords. Further, the learned counsel for the complainant made a oral prayer for amending the cause title of the contempt petition to array the respondent number 5 as the party. Considering the page number 58, my lords.
Yes.
Last idರಲ್ಲಿ V. Sheshadri, learned counsel for the government advocate, appears take notice. Considering the facts that complainants before this honorable court are in their advanced age and their age ranging from 73 to 82 years, we expect the respondent number 5 would file a positive response. In this case, what had happened?
ಆಮೇಲೆ ಏನಾಯ್ತು?
ಅದೇ contempt ಅಲ್ಲಿ in view of the ಇಲ್ಲಿ ಇದಾಗಿತ್ತು, there is no sitting in the quotal number 1, my lords. In the quotal number 2, the government advocates made a compliance was done, the contempt was dropped.
Mister, you go on making an allegation against the court. If
quotal.
quotal number 1 is not sitting, quotal number 2 order is not an order of the court.
Order of the court.
Then why you are making that quotal number 1 is not sitting? Quotal number.
No, I am sorry, my lords. I am
But
saying.
don't make all this, Mister. You are making an allegation that
I am
on
saying.
that day quotal number 1 is not sitting. Matter was posted before 2 as dismissed.
I was not heard. That is the.
You make submission that in contempt it is not heard. How many years you have put in that submission?
ಅದು ಮಾಡಿಲ್ಲ. I was not heard. That is my submission.
What is the submission you are making? What is that impression you are drawing that? Since it has posted before the other bench, they have not considered in accordance with law.
No. The government advocate has made submission compliance was done. By taking into consideration his, without hearing me,
I
the order was passed, is my
It
submission.
should be that, why you have said that on that day first court is not sitting when second court, is it then in law on that?
I
point?
wanted to, I wanted
Is
to
that you are
highlight
making that?
this is the situation, the
No,
contempt was
you
dropped.
have to say situation, what is happening that. You can't say that since matter has been posted before that other court, this order has been passed.
No, that is not the interpretation. my lord.
Still number 36. Javed
See, you are straight away making an a,
No, I am sorry, my lord. No, I wanted to interpret.
which has passed an
ಇಲ್ಲ
order.
ಇಲ್ಲ ಇಲ್ಲ ಅಲ್ಲ I was not heard is my submission.
ನೀವ್ ಹೇಳೋದೇನು ಅಂತಂದ್ರೆ
ಇಲ್ಲ, ಇಲ್ಲ.
ಫಸ್ಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅವತ್ತು ಇದ್ದಿದ್ರೆ ನನ್ ಕೇಸ್ ಆಗ್ತಾ ಇತ್ತು,
ಹೌದು.
ಇನ್ನೊಂದ್ ಕೇಸಿಗೆ ಬಂದಿರೋದ್ರಿಂದ.
In view of the fact that annexure M, there was a conditional order.
If you say yes, you will face a consequence. Yes.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲ ಈ annexure M ಅಲ್ಲಿ ಮಾಡಿದಾರಲ್ಲ.
After 4 weeks.
Still number 36.
I am sorry.
Javed as
Yes.
per petitioner.
In this case, I appear for the respondent 2 and 3. Kindly pray for,
Yes.
kindly pass over the
Appearing for
matter.
the petitioner, my lord.
Kindly pass over the matter.
Appearing for petitioner, my lord.
Yes, what is this
I am for
matter?
the
My
respondent
lord,
2 and
petitioner was appointed as a driver, my lord.
My lord, kindly
The
pass
respondent
over.
number 2, my
My
lord.
senior will appear.
Pass over.
kindly pass.
Yes, yes.
Serial number 37.
Yes.
Vijay Shetty B for petitioner. MN Kumar.
My lord,
She has challenged the selection process. I would like to file a statement of objections. I have received the instructions yesterday. I may be granted some time, I will file objections. Because
sufficient
factual
time has
disputes
been
are
taken
there.
in this matter.
Yes, Mr. He wants to file objection. that is
Yes,
fine.
Yes,
because
my
there
lord.
are disputed facts are there. Selection process, she did not qualify according to our records. I will place all the records as well as the file
21.
statement.
21.
After 10 days, yesterday night they have sent it.
Yes, leave this matter on 16th
16 March. Apply.
to, at the request of respondent number 1 to 4 to
Apply.
file objection.
Still number 38. Nagendra Naik R for petitioner.
Yes.
Hello, sir. We have sought a writ of Mandamus in this.
ಆಯ್ತು ನೋಡಂತ ತಡೀರಿ ಏನ್ ಮ್ಯಾಟರ್.
Hello, sir.
Somewhat today is little bit cool in my court. Let us see that. I don't know, in the middle he has raised some irrelevant objections. Yes.
Manoj, shall I continue, Manoj?
Yes, yes.
Manoj, we have sought a writ in the nature of Mandamus, directing the respondents to regulate the period of suspension of the petitioner from the period 1/6/1994 to 22/11/1996.
That the departmental inquiry is not initiated.
Not initiated, and we were reinstated. We had filed an educational appeal before the district judge Chikmagalur, and we were reinstated. That order is as per Annexure C, my lords, page number 29, page number 25 to 29. The operative portion of the order is at page number 27, my lords.
Yes. What is that order
having
you have
regard-
challenged before that?
We had been dismissed from our service, my
You are challenged before the EAT.
EAT, my lords.
Yes.
We had challenged our dismissal order, suspension order, sorry, not dismissal, suspension order before the EAT. We were reinstated by the EAT, and the operative portion of the said order is at page number 27, my lords.
No,
Having
is it,
regard to the submission,
suspension order can be challenged before the EAT. Is it maintainable?
my lords, we had filed the educational appeal before the district court Chikmagalur under section 8 of the Karnataka Private Educational Institutions.
No, this is before that 93 Act came into the force.
93,
Yes.
1975. my lords.
Yes. Then what has happened?
My lords, after we were reinstated, we reported to duty on 23/11/1996, and respondent number 1, who is DDPI, has also advised the respondent number 3, which is the Kannada Sangha, which manages the school.
Yes.
Respondent number 4 school, to to consider our period spent on suspension,
Hmm.
that is 2 years, 4 months and 27
Who is
days.
appearing for
as
that institution?
Appearing for institution is Shrikant sir.
Shrikant MP. You are there, Mr.
Yes, there is some confusion. I checked my notes in the daily list. Name of Shrikant Patil notes appears notes in the.
ನೋಡ್ರಿ ಒಕ್ಕಲಾಟ
ಶ್ರೀಕಾಂತ್ ಪಾಟೀಲ್.
notice ವಕಾಲತ್ ಹಾಕಿದಾರ. We'll show his name because now we have to be decide whether it is a management has to pay or the government has to. According to you, who has to pay?
Manoj, respondent number 3, respondent number 1 and 2 has to pay.
No, according to you that.
Sir, I have taken specific contention. That second respondent has written a letter to third respondent. The requisition the third respondent release the benefit of the petitioner and also send the necessary record pertaining to the service of the petitioner. But the respondent number 3 has not sent any record pertaining to the service of the petitioner. There is inordinate delay on part of the third respondent.
No, that then you have to pay. Only that record is not submitted. Then if they submit a record, you pay it. Delay will not make, they are not seeking that whatever the period they have been under suspension, they have to be. Yes, office is
Also,
direct.
Manoj, our time bound increments on completion of 10, 20 and 30 years of service has not been
That is
paid.
not that your prayer, Mr. Here. You are only for the suspension period.
No, Manoj, we have to grant the.
But who has to grant that? What about that? Is there any such rule for granting in a time bound promotion for these teachers, Mr.? Under which provision you are entitled for that, Mr.?
I'll seek instructions with regard to.
Yes. Office
Manoj,
is directed to
one more submission, Manoj.
show the name of another Shrikant Patil. Shrikant Patil K for respondent number 3 and delete the name of Shrikant MP. Yes.
Manoj, one more submission. Manoj, on 16/2/2026, we received the letter.
Patil, now he is a age.
Huh?
Shrikant Patil, now he is a age.
Shrikant Patil.
Now he is a age.
Shrikant Patil ಏನ್ ಇನ್ಸಿಯಲ್ಲ? K. Shrikant Patil K na? ಆಯ್ತು, anyhow, let us see, let it be his name. He has to come and tell something, no?
Shrikant Patil came.
Same. Let his name shows, then he will may ask his colleagues to be appear. But he is not the council who is appearing. Yes.
Manoj, one date may be given.
Yes, leave this matter on 16th.
Much obliged.
Bill number 39, Shrikant MP for petitioner.
For seventh respondent, my lords.
Yes, Mr. Somsekhar.
Petitioner.
Ready?
Yes, my lords. In fact, there is no relief sought against me at all.
Yes.
I'm the
Then
seventh
who is
respondent. In the writ petition,
government is the contesting.
Draft reply is ready, mirror. Sign marks.
There is an improvement from last month to this month. Now he is ready in draft. Last month he is just seeking time. Now he is ready with the draft. Some improvement is there. Yes. When will you file, Mr.? Yes, at the request of government advocate. Week's time is granted to file objection. Leave this matter and 12th. Yes.
Bill number 40, Raghupati MJ for petitioner, connected matter, Subramania Bhatt M.
Yes, Mr.
Three, my lord, in the first matter and petitioner's counsel first.
Let the petitioner is my lord. Gram Sahai. That matter is
yes.
The last question heard in the lengthy.
Yes. Now you just give that brief facts.
Please.
We'll finish it up this matter.
Please.
Repeatedly it's coming. Yes. Unless any.
And Annexure B, my lord, the petitioner was appointed as Gram Sahayak. Dated 15/2/2017.
15/2/2017. 15/2/2017.
Please, my lord.
Grama Sevakana.
Please, my lord.
Government advocate ready diralri.
They filed affidavit for that, my lord.
in the last previous case, what this honorable
ಆ
court.
ಗ್ರಾಮ ಸೇವಕ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇದ್ರದ್ದು ಒಂದು ಸರ್ಕ್ಯುಲರ್ ಇದೆಯಲ್ಲ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ?
There is no dispute, my lord. There is no dispute with respect to his appointment. The impugned order, my lord, is on the ground that his appointment is secured based on the falsified records.
That's what that somebody has filed a produce that
Affidavit,
records.
Please, that's
And then, yes, we'll come to that, yes.
But before his confirmation of appointment, he was working in that place since 31/5/2010, my lord.
Before that also you are working.
Please, my lord.
That is immaterial, only after your appointment, yes.
Madam, while we are in the resident of that medical circle, you obtained the residency certificate on 16/4/2016. That is the crucial issue. My lord, before that, he was obtained the residence certificate from the date of appointment. My lord, thereafter, my lord.
Where is that residential certificate?
Please. Annexure Y, my lord.
Page?
Y.
Page, Mr.
Page 77 to 79, my lord.
77
to. That is caste and income and residence certificates also. Page number 79 is the annexure Z. Is the residence certificate of Mandikal village, my lord.
What is the dispute? Your age?
Age, there is no dispute of the age. I am belongs to the particular family. So I am residing that particular circle.
ಆಯ್ತು, ಇಂಪ್ಯೂನ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
Impugned order, my lord, page number
83, my lord.
83, annexure AB.
What is that impugned order? Read.
This is the second round litigation earlier on, my lord. He was dismissal from the service without holding an inquiry, alleging that the petitioner has remained unauthorized absent last 2 years. And against that post, the third respondent is working. Thereby terminated me and appointed against my vacant post to the third respondent. This honorable court has terminated the appointment of the third respondent and termination of the petitioner also. Thereby, my lord, the petitioner has continued in the present place. Against the writ petition order, the third respondent approached the writ appeal. Writ appeal is also dismissed. Now, subsequently, as per the direction of
Round of litigation, my lord. Litigation was without inquiry. This court held, my lord, that we'll have to hold inquiry. Therefore, he has been restored to the post.
Yes,
Now, an inquiry is held and our impugned order is passed.
Yes.
My lord, earlier termination is alleging that I am remaining unauthorized absent, my lord. Now, my lord, the authorities issued the SOCAS notice to furnish my testimonials. That is, my lord, SSLC certificate, caste certificate, income certificate, and other certificate, my lord. I produced that certificate. Now the respondent has given a pass on the impugned order. Page number 85, my lord, I permitted to read from last paragraph.
Yes.
KV ರಮೇಶ್ ಕುಮಾರ್ ಸಲ್ಲಿಸಿರುವ ಜಾತಿ ಮತ್ತು ಆದಾಯ ಪ್ರಮಾಣ ಪತ್ರ ವಾಸ ಪ್ರಮಾಣ ಪತ್ರ 2016 ಸಾಲಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದಾಗಿರುತ್ತದೆ. ರಮೇಶ್ ಕುಮಾರ್ ವಾಸವಾಗಿರುವ ಪರಿಶೀಲಿಸಾಗಿ 16/8/2019 ನಂದಿ ಹೋಬಳಿ ಉಪತಹಸೀಲ್ದಾರ್ ಕಚೇರಿಯಲ್ಲಿ ಆರ್ಡಿ ನಂಬರ್ ಸೋನ್ಸೋರಂತೆ ಜಾತಿ ಮತ್ತು ಆದಾಯ ಪ್ರಮಾಣ ಪತ್ರ ಹಾಗೂ ವಾಸಸ್ಥಳ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ನಂದಿ ಹೋಬಳಿ ಕಣಿತಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಿರುವುದು ಪಡೆದಿರುತ್ತಾರೆ. ಆದ ಕಾರಣ KV ರಮೇಶ್ ಮಂಡಿಕಲ್ ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಿಲ್ಲ ಎಂಬುದಾಗಿ ಸ್ಪಷ್ಟವಾಗಿ ಕಂಡುಬರುತ್ತದೆ. That is the main allegation. Remaining, my lord, while he was working, the applicant has obtained the elections in the Mandikal and his ರೇಷನ್ ಕಾರ್ಡ್.
ಗ್ರಾಮ ಸೇವಕವಾಗಿ ಯಾವ ವಿಲೇಜ್ ಗೆ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದು?
ಮಂಡಿಕಲ್, my lord.
ಮಂಡಿಕಲ್.
Please, my lord.
What is the rule says you should be resident of that
place? Please, my lord.
Yes.
I fulfill that before my appointment, my lord.
Yes.
My lord, based on this
ಏನಂತ ಹೇಳ್ತಾರೆ, 19ರಂದು ನಂದಿ ಹೋಬಳಿ ತಹಸೀಲ್ದಾರ್ ಕಚೇರಿಯಿಂದ ಆಡಿ ಜಾತಿ ಮತ್ತು ಆದಾಯ ಪ್ರಮಾಣ ಪತ್ರ ವಾಸಸ್ಥಳ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ನಂದಿ ಹೋಬಳಿ ಕುಣಿತಲೆ ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಿರುವುದಾಗಿ ಪಡೆದಿರುತ್ತಾರೆ.
Please, my lord. For that, my lord, I request that the residence certificate from the second respondent, as per annexure AD, page number 90, they are issued the endorsement stating that those certificate are already invalid. There is no necessity for issuing this another certificate, my lord, page number 90.
Page number 19.
90, my lord.
90.
Please, my lord.
ಏನಿದು?
What is alleged in the impugned order, I was residing that Kanitali village, that is already cancelled prior to that matter. That is the statement of in the endorsement statement, matter. KV ರಮೇಶ್ ಕುಮಾರ್ ಬಿನ್ ವೆಂಕಟೇಶಪ್ಪ ಮಂಡಿಕಲಾದ ನೀವು ಉಲ್ಲೇಖದ ಅನ್ವಯ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ OTC ಯಲ್ಲಿ ಪಡೆದಿದ್ದ ಜಾತಿ ಮತ್ತು ಆದಾಯ ಪ್ರಮಾಣ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋಂಸರಂದು ಅಸಿಂಧುಗಳಾಗಿಸಲಾಗಿದ್ದು ಆ ಅಸಿಂಧುಗೊಳಿಸಿರುವ ಬಗ್ಗೆ ದೃಢೀಕರಣ ಪತ್ರ ನೀಡಲು ಕೋರಿರುವುದು ಸರಿಯಷ್ಟೇ. ಆದರೆ ಸದರಿ ಪ್ರಮಾಣ ಪತ್ರಗಳು ಸಕಾಲ ತಂತ್ರದಲ್ಲಿ ಈಗಾಗಲೇ ಅಸಿಂಧುಗೊಳಿಸಲಾಗಿರುವುದರಿಂದ ಅಸಿಂಧುಗೊಳಿಸಿರುವ ಬಗ್ಗೆ ಮತ್ತೊಮ್ಮೆ ದೃಢೀಕರಣ ಪತ್ರ ನೀಡಲು ಸಾಧ್ಯವಿರುವುದಿಲ್ಲ ಎಂಬ ಅಂಶವನ್ನು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ.
ಏನಕ್ಕೆ ತಗೊಂಡಿದ್ರಿ ಇದನ್ನ 20/11/2019
ಅಲ್ಲ 20/11/2019 ಅಲ್ಲ. While he was resident of the Kanitali village, the caste and income certificates attached to the ration card. For that, this honorable court has directed the respondent to file an affidavit. For that, the Tahsildar has filed an affidavit.
No, I will come to that.
Please, my lord.
When you are appointed in 2017.
Please, my lord.
Where you are residing?
My lord, Mandikal.
Mandikal. What is the document you have produced?
Please, my lord. Annexure Y, my lord. Sorry, Annexure Z.
Annexure J.
Z, my lord. 79. ವಾಸಸ್ಥಳ ದೃಢೀಕರಣ ಪತ್ರ. ಮಂಡಿಕಲ್ ಸರ್ಕಲ್ ಕೊಟ್ಟಿರುವಂತದ್ದು.
Now, what is their finding that you are not a resident of Mandikal?
Please, my lord. Before my appointment, I obtained the residence certificate with particular circle. Based on that, I have been appointed. The first instance, I have been terminated, alleging that I have been on the remaining unauthorized absent. That has been set aside. Second thing, the liberty has given to this honorable
Now,
court.
there is no allegation that you are unauthorized.
No. They are issuing notice that you furnish your residence certificate. Though we have obtained the valid residence certificate, they are alleging that
ರಮೇಶ್ ಕುಮಾರ್ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ವಾಸಸ್ಥಳ ಪ್ರಮಾಣ ಪತ್ರ ಸಲ್ಲಿಸಿ ಸಂಬಂಧಪಟ್ಟಂತೆ ರಮೇಶ್ ಕುಮಾರ್ ಅವರು ವಾಸವಿರುವ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಲಾಗಿ ದಿನಾಂಕ 16/8/19 ನಂದಿ ಹೋಬಳಿ ತಹಸೀಲ್ದಾರ್ ಕಚೇರಿಯಿಂದ ಆಡಿ ಜಾತಿ ಮತ್ತು ಆದಾಯ ಪ್ರಮಾಣ ಪತ್ರ ವಾಸಸ್ಥಳ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ನಂದಿ ಹೋಬಳಿ ಕುಣಿತಲ್ ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಿರುವುದಾಗಿ ಪಡೆದಿರುತ್ತಾರೆ. ಆದ ಕಾರಣ ರಮೇಶ್ ಕುಮಾರ್ ಮಂಡಿಕಲ್ ವಾಸದಲ್ಲಿ ಸ್ಪಷ್ಟವಾಗಿ ಕಂಡು ಬರುತ್ತದೆ.
For that, my lord, the Tahsildar has filed an affidavit as per the direction of this honorable court, my lord, on 29/20/25, my lord.
ಕೊಡಿ. ಏನ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ?
Please, my lord. I am permitted to read from para 3, my lord.
Yes.
The petitioner had submitted the application within at the Nada Kacheri office, Mandikal Obli, Mandikal village, Chikbalapura Taluk, seeking residence certificate along with Aadhaar card, ration card, so on so on. So the village administrative officer, revenue inspector conducted the spot inspection, verified that the applicant resided in the said village and submitted the report to the deputy Tahsil. Based on the report, revenue inspector certified that bearing survey number, the RD number was issued to the petitioner on 11/4/2016. Verify the residence certificate issued by the petitioner on 16/2/2016 bearing number so and so. It was found that when the petitioner applied for the ration card at Mandikal Hobli, Mandikal village, the residence certificate was generated through E-Keshwa Center OTS software. Even though no supporting document were submitted to the residence certificate was automatically approved on 16/8/2019. But as on the data was linked, the existing ration card in the databases, which was the address of the Kanitali village, Nandi Hobli, and hence the residence certificate which was given in the OTC in the 2019, say Kanitali village.
ಏನಂತದ? What is that clarification?
Clarification ಮೇಲೆ 2016 ಅಲ್ಲಿ ಇವರು ಅಪ್ಲೈ ಮಾಡಿದ್ದು ರೆಸಿಡೆನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್. ಆ ರೇಷನ್ ಕಾರ್ಡ್ ಅಲ್ಲಿ ಹಂಗೆ ಉಳ್ಕೊಂಡ್ಬಿಟ್ಟಿದೆ ಅದು. ಇವ್ರು 2019 ಅಲ್ಲಿ ಮತ್ತೆ ಅಪ್ಲೈ ಮಾಡಿದ್ದಾರೆ, ಅದು ನಂಬರ್ ಅಷ್ಟೇ ಬೇಕಾಗಿದೆ. There is no supporting document in the which is
2016 ಅಲ್ಲಿ ನೀವು ಅಪ್ಲೈ ಮಾಡ್ಬಿಟ್ಟು you have taken that Mandikal ಇದು.
Where I was working in the Kanitali circle, my lord. So it was my residence certificate attached to the ration card. ಅದು ಹಂಗೆ ಉಳ್ಕೊಂಡ್ಬಿಟ್ಟಿದೆ, ಅದನ್ನ ಹೇಳ್ತಾ ಇರುವಂತದ್ದು.
ನೀವು ಅಲ್ಲಿ ಕನಿತಲ್ ಅಲ್ಲಿ ಮೊದಲು ವರ್ಕ್ ಮಾಡ್ತಿದ್ರಾ?
ಅಲ್ಲ, ಕನಿತಲ್ಲಿ ವರ್ಕ್ ಮಾಡ್ತಿಲ್ಲ. ಡೈರೆಕ್ಟ್ಲಿ ಅಪಾಯಿಂಟೆಡ್ ಇನ್ ದಿ ಮಂಡಿಕಲ್ ಸರ್ಕಲ್. ಮೈ ರೆಸಿಡೆಂಟ್ ಇನ್ ದಿ ಕನಿತಳ್ಳಿ ವಿಲೇಜ್.
ಯು ಆರ್ ರೆಸಿಡೆಂಟ್ ಆಫ್ ಕನಿತಳ್ಳಿ
ವಿಲೇಜ್. ಸೊ ಕನಿತಳ್ಳಿ ವಿಲೇಜ್ ಅಲ್ಲಿ ಉಳ್ಕೊಂಡು ಅದು ಡಿಲೀಟ್ ಆಗಿಲ್ಲ, ಹಂಗೆ ಉಳ್ಕೊಂಡ್ಬಿಟ್ಟಿದೆ ಅದು. ಐ ಆಮ್ ನಾಟ್ ಅಪ್ಲೈಡ್ ಫಾರ್ 2019 ಫಾರ್ ಫ್ರೆಶ್ ರೆಸಿಡೆನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್.
ಆಯ್ತು, ನೀವು ಅಪ್ಲೈ ಮಾಡೋದ್ ಬೇಡ. ಯು ಆರ್ ರೆಸಿಡೆಂಟ್ ಆಫ್ ಕನಿತಳ್ಳಿ ವಿಲೇಜ್ ಆರ್
ಮಂಡಿಕಲ್. ಆಸ್ ಆನ್ ದ ಡೇಟ್ ಆಫ್ ಮೈ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಐ ಆಮ್ ಇನ್ ಮಂಡಿಕಲ್ ವಿಲೇಜ್.
ದೆನ್ ವೈ ಯು ಅಪ್ಲೈಡ್ ಫಾರ್ ಕನಿತಳ್ಳಿ ವಿಲೇಜ್?
That is the clarification, my lord.
ಅಲ್ಲ, ನೀವ್ ಯಾಕೆ ಅಪ್ಲೈ ಮಾಡಿದ್ರಿ?
ನಾನು ಅಪ್ಲೈ ಮಾಡಿಲ್ಲ, ಆಟೋಮೆಟಿಕಲಿ ಜನರೇಟ್ ಅಂತ ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಇಲ್ಲಿದೆ ರೆಸಿಡೆಂಟ್ ವಾಸ್ ಆಟೋಮೆಟಿಕಲಿ ಅಪ್ರೂವ್ಡ್ on 16/8/2019, but as the data was linked to the existing ration card, in the databases which has the address of
ಏನು
the-
ಎಕ್ಸಿಸ್ಟಿಂಗ್ ರೇಷನ್ ಕಾರ್ಡ್ ಅಂದ್ರೆ ರೇಷನ್ ಕಾರ್ಡ್ ಅಲ್ಲಿ ಏನಿತ್ತ
ಅದಿನ್ನ ರೇಷನ್ ಕಾರ್ಡ್ ಹಂಗೆ ಉಳ್ಕೊಂಡಿರ್ತದಲ್ಲ ಸ್ವಾಮಿ, ರೇಷನ್ ಕಾರ್ಡ್ ಕ್ಯಾನ್ಸಲ್ ಆಗಿರೋದಿಲ್ಲ
ಯಾವ್ದ್ರದ್ದು?
ನಮ್ ಪೇರೆಂಟ್ಸ್.
No, earlier you were in a Kanital village resident.
Please my lord.
When you have shifted to that Mandikal?
2010 my lord.
2010.
My my appointment it is clearly says that.
Now why you have shifted to Mandikal?
Mandikal because of the employment I filed an application. So I as per the criteria in the selection.
No, you should be resident of that, or you have to be applied and go and settle there.
No. You have to, my lord, from 2010 I am working in this circle. 2010 I am
No,
working.
what is that circular says? Yes. No, whenever that application is filed, you will go and apply and they will settle,
No,
or
no,
you
no.
should be in a
No.
resident of that village.
2010 I have been working that place, my lord.
ಅದೆಲ್ಲ ಇದ್ರದಿತ್ತಲ್ರಿ ಗ್ರಾಮ ಸೇವಕ. Not that, mister. When you are filing an application to be eligible,
Please, my lord.
you should be a resident of that village.
Certainly, my lord. My lord, I am working in the Mandikal circle from 2010.
No, but you are in a resident of that Kanital.
Kanidali, my lord.
No, if it is in a temporary employment, they might have been given. But you are resident of Kanital, can be applied for that Mandikal.
I have obtained the residence certificate by virtue of the working and resident.
No, resident certificate, how it has to be given?
By virtue of resident.
No, you are saying that you are resident of Kanital.
Mandikal, from 2010 I am a resident of Mandikal.
You are shifted there.
Please, my lord. That's why the residence certificate has been issued.
Yes, mister. He was to issue residential certificate. What is the criteria? How many years you have to be resident of that village?
5 years.
Huh? 5 years. No, what are that documents other than that you have resident of Mandikal? Voters list and all is in Mandikal.
Everything is there, my lord.
Before the lords may see the entire impugned order, my lord, we just read one paragraph.
My
Lords, may kindly
my
come to
election.
page 85, my lord. I'm
Yes.
sorry, I'm interrupting. Just for the clarity, my lord.
Yes.
Lords, may kindly come to page 86, my lord.
Yes.
ಅವರೇ ಓದ್ಬಿಡ್ಲಿ.
ಇಲ್ಲ, 86 ಅಲ್ಲಿ ಇದೆ.
Just explain, my lord. 6 instances are considered where it is proved that the documents that he produces are fake and fabricated. Not one, 6 instances.
No, that
ವೋಟರ್ ಐ ಡಿ
Mandikal-
ತಪ್ಪು, ಎಲ್ಲೇ ಇದು ರೆಸಿಡೆನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ತಪ್ಪು, ಇನ್ಕಮ್ ಸರ್ಟಿಫಿಕೇಟ್ ತಪ್ಪು, ಮತ್ತೆ ಪಡಿತರ ಚೀಟಿ ತಪ್ಪು.
No, all that Mandikal.
Everything is fake. Even the document
Fake created by him.
created by him.
No, that then you have not registered any
ಕ್ರಿಮಿನಲ್
criminal
ಕೇಸ್
complaint.
ಹಾಕಿಲ್ಲ, ವಜಾ ಮಾಡಿದ್ರು, ಅದ್ರ ಮೇಲೆ ರಿಟ್ ಹಾಕೊಂಡಿದ್ದಾರೆ. So until this get
Criminal
decided,
case has been initiated.
ಇನ್ನೂ ಹಾಕಿಲ್ಲ, ಈ ರಿಟ್ ಡಿಸ್ಪೋಸ್ ಆದ್ಮೇಲೆ ಹಾಕಬೇಕು.
Yes, where is that file?
Page 86, madam.
What?
KV Melots, I think he read page 85 till the last line, so I'll start with 86.
Yes.
KV ರಮೇಶ್ ಕುಮಾರ್ ಅವರು ಆರ್ಡಿ ನಂಬರ್ 4 ಅಂತ ಮತ್ತೊಮ್ಮೆ ವಾಸಸ್ಥಳ ಪ್ರಮಾಣ ಪತ್ರ ಕೋರಿ ಸಲ್ಲಿಸಿರುವ ದಾಖಲೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಅರ್ಜಿದಾರರು ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಿರುವರೆಂದು ದಿನಾಂಕ 7/11/23 ವಜಾ ಆಗಿರುವ ಇಂಬರ ಪ್ರತಿಯೊಂದು ಕಂಡುಬರುತ್ತದೆ. KV ರವಿಕುಮಾರ್ ಅವರು ನೇಮಕಾತಿ ಸಮಯದಲ್ಲಿ ನೀಡುವ ಪಡಿತರ ಚೀಟಿಯಲ್ಲಿ ಈತನ ತಂದೆಯ ಹೆಸರು ಕದ್ರಿಯಪ್ಪ ಎಂದು ನಮೂದಾಗಿ ಅದರ ದಿನಾಂಕ 6/11/2023 ವಿಚಾರಣೆ ವೇಳೆಯಲ್ಲಿ ಸಲ್ಲಿಸಿರುವ ಪಡಿತರ ಚೀಟಿಯಲ್ಲಿ ಇವರ ತಂದೆಯ ಹೆಸರು ಎಂ ವೆಂಕಟೇಶಪ್ಪ ಎಂದು ನಮೂದಿಸಲಾಗಿ ಇದರಿಂದ ಇವರ ನೇಮಕಾತಿ ಸಮಯದಲ್ಲಿ ತಪ್ಪು ಮಾಹಿತಿ ನೀಡಿ ಗ್ರಾಮ ಸಹಾಯಕರಾಗಿ ನೇಮಕಾತಿ ಪಡೆದಿರುವುದು ಸ್ಪಷ್ಟವಾಗಿ ಕಂಡುಬರುತ್ತದೆ.
What is his father name?
ವೆಂಕಟೇಶಪ್ಪ.
ವೆಂಕಟೇಶಪ್ಪ. ಅವರು ಇದರಲ್ಲಿ ಅರ್ಜಿಲಿ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
ಕದ್ರಪ್ಪ.
ವೆಂಕಟೇಶಪ್ಪನ ಸರ್.
ಕದ್ರಪ್ಪ.
No, ವೆಂಕಟೇಶಪ್ಪನ.
What is that record says?
I'll also point out, my lord. My lords, may first see now, my lord, page number, just for an instance, page 52, my lord, annexure N, which he produces, my lord, that his elections ID card.
Yes.
My lords would have the number, my lord, on the left hand side and Mandikal.
Yes.
Now, my lords may take my statement of objections, my lord, at page.
His father name is Venkateshwara.
Venkateshwara. Now, my lords may take my statement of objections.
ಪಡಿತರ ಚೀಟಿಯಲ್ಲಿ ತಂದೆ ಹೆಸರು ಕದಿರಪ್ಪ ಎಂದ ನಮೂದು ಆದರೆ 99 ವೇಳೆಯಲ್ಲಿ ತಂದೆ ಹೆಸರು ಎಂ ಕದಿರಪ್ಪ ಎಂದು ನಮೂದಾಗಿರುತ್ತದೆ. ನೀಡಿರುವ ಪಡಿತರ ಚೀಟಿಯಲ್ಲಿ ಕದಿರಪ್ಪ ಎಂದು ನಮೂದಿರ್ತಾರೆ. ಯಾವುದು ಪಡಿತರ ಚೀಟಿ? ರಮೇಶ್ ಕುಮಾರ್ ನೇಮಕಾತಿ ಸಮಯದಲ್ಲಿ ನೀಡಿರುವ ಪಡಿತರ ಚೀಟಿಯಲ್ಲಿ ಈ ತರ ತಂದೆ ಹೆಸರು ಯಾವ್ದದು? ನೇಮಕಾತಿಯಲ್ಲಿ ಪಡಿತರ ಚೀಟಿ ಯಾವ್ದ್ರಿ ಅದು?
My lords may kindly come to page 85, first paragraph. ಅದರಂತೆ ದಿನಾಂಕ 6/11/2023 ಶ್ರೀ KV ಗುಂಪಿನ ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಿ ಲಿಖಿತ ನಿವೇದನೆ ಸಲ್ಲಿಸಿದ್ದು ಹಾಗೂ ಸದರಿ ನಿವೇದನದೊಂದಿಗೆ ಈ ಕೆಳಕಂಡ ದಾಖಲೆಗಳ ಪ್ರತಿಗಳನ್ನು ಹಾಜರುಪಡಿಸಿರುತ್ತಾರೆ. ಐಟಮ್ ನಂಬರ್ 6 ಪಡಿತರ ಚೀಟಿ. The documents that he had produced along with the appointment, my lord, he produces same. This is what the inquiry officer holds to be one which does not tally with his actual name.
No, this is, it has been produced that at the time of that. Now he said, ನೇಮಕಾತಿ ಸಮಯದಲ್ಲಿ ನೀಡಿರುವ ಪರಿತೀರಿದ ಚೀಟಿಯಲ್ಲಿ ಈತನ ತಂದೆ ಹೆಸರು ಕದ್ರಪ್ಪ, ಅದೆಲ್ಲ ಐತೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಐತ್ರಿ.
But sorry, madam, page number 20 annexer B, my father name is Sosis Venkateshappa.
ಆಯ್ತ್ರಿ, ಇದು ಯಾವ್ದು ಇದು ಕದ್ರಪ್ಪ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕೊಟ್ಟಿದ್ರಲ್ಲ ಯಾವ್ದದು?
It is residential ಯಾವ್ದು ಪಡಿತರ ಚೀಟಿ ಹೇಳ್ತಿದಾರಲ್ಲ ಸ್ವಾಮಿ.
ಪಡಿತರ ಚೀಟಿಯಲ್ಲಿ ಕದ್ರಪ್ಪ
ಅದು one of his relative family attached with the ration card. Because of the ration card.
ಎಲ್ಲಿದೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀರಾ?
Annexer M page number 51. Subsequently that has been cancelled.
No, it can be cancelled.
Please, madam.
It cannot be. Yes, where is that? ಏನಿದೆ?
Page number 51.
What is your name, Mr.
KV Ramesh Kumar. Ramesh Kumar, KV Ramesh Kumar.
ಎಲ್ಲಿದೆ ಇದರಲ್ಲಿ? Ramesh Kumar.
Last ಇದೆ.
See, Gangamma is the mother.
ಕದ್ರಪ್ಪ ಗಂಗಮ್ಮ.
ಅಲ್ಲಿ ಹೆಂಗ್ರಿ ನೀವು ಅವ್ರ ಮಕ್ಕಳು ಆಗ್ತೀರಾ?
ಮೊಮ್ಮಗ ಅಂತ ಬಂದಿದೆ ಸರ್ ಮೆಸ್ಟ್ ಅಲ್ಲಿ.
ಎಲ್ಲಿ?
ಇದು ಕ್ರಿಯೇಟೆಡ್
ಒರಿಜಿನಲ್ ಇದಾರಲ್ಲ ಗಂಗಮ್ಮ. ಗಂಗಮ್ಮ ಇಸ್ ದ ಓನರ್ ಆಫ್ ದ ರೆಸಿಡೆನ್ಸಿಯಲ್ ರೇಷನ್ ಕಾರ್ಡ್ ಹೋಲ್ಡರ್. ಅಲ್ಲಿ ಮೊಮ್ಮಗ ಅಂತ ಬಂದಿದೆ ಅದು.
ಯಾರು?
ರಮೇಶ್ ಕುಮಾರ್.
ಅಲ್ಲಿ ನಿಮ್ ತಂದೆ ಹೆಸರು ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
ತಂದೆ ಹೆಸರು ಬಂದಿಲ್ಲ ಅಲ್ಲಿ.
ಎಲ್ಲಿದ್ದಾರೆ? ತಂದೆ ಹೆಸರು ಇರಲ್ಲನ್ರಿ?
ಬಂದಿಲ್ಲ ಮಲ್ಲಾಡ ದ ರೆಸಿಡೆನ್ಸಿಯಲ್ಸ್ ರೇಷನ್ ಕಾರ್ಡ್.
ವೇಟ್ ರೀ, ಪ್ಲೀಸ್ ವೇಟ್. ವೇರ್ ಇಸ್ ದಟ್ ಫಾದರ್ ನೇಮ್ ಮಿಸ್ಟರ್?
ಫಾದರ್ ನೇಮ್ ಬಂದಿಲ್ಲ ಸರ್.
ಇದನ್ನ ನಾವು ಕ್ರಿಯೇಟೆಡ್ ಅಂತ ಹೇಳ್ತೀವಿ.
ಅಪ್ಪ ಅದಿರ್ಲಪ್ಪ, ನೀವು ಆರ್ಡರ್ ಹೇಳಿದೀರಾ ಇದ್ರಲ್ಲಿ ಅವ್ರ ತಂದೆ ನೇಮು ಕದ್ರಪ್ಪ ಅಂತಿದೆ ಅಂತ ಎಲ್ಲಿ ತೋರ್ಸ್ರಿ?
ಗಂಗಮ್ಮನ ಹೆಂಡತಿ ಕದ್ರಪ್ಪ ಆಗ್ತಾರೆ. ಇದು ಮೊದಲನೇ ಮಗ, ಇದು ಕೊನೆ ಮಗ, ಇದು ಅವನ ಮಗ, ಇದು ಇವನು ಬ್ರದರ್. Not missing, I don't have the complete list.
ಕಂಪ್ಲೀಟ್ ಇಲ್ಲ ಇಲ್ಲಿ.
Complete list.
ಇದನ್ನೇ ಸರ್.
ಗಂಗಮ್ಮ ವೈಫ್ ಆಫ್ ಕದ್ರಪ್ಪ ಅಂತ ಇದೆಯಾ?
ಪೇಜ್ ನಂಬರ್ 86 ಅಲ್ಲಿ ಪ್ಯಾರಾ ಸೆಕೆಂಡ್ ಅಲ್ಲಿ.
ವೇಟ್ ಮಿಸ್ಟರ್. ಪೇಜ್ 51 ಅಲ್ಲಿ
51 ನೋಡಿ, 51 ಆಗ್ತಾರೆ ಸರ್.
ಎಲ್ಲಿದ್ದಾರೆ ಕದ್ರಪ್ಪ ಅಂತ? ಗಂಗಮ್ಮ ವೈಫ್ ಆಫ್ ಕದ್ರಪ್ಪ ಅಂತ. ಅದೇನ್ ಪೂರ್ತಿ ಎಲ್ಲಿದ್ದಾರೆ ಅದು? ಇಟ್ ಇಸ್ ಗ್ರ್ಯಾಂಡ್ ಸನ್ ಆರ್ ಸನ್ ಮಿಸ್ಟರ್?
ಗ್ರ್ಯಾಂಡ್ ಸನ್.
ಎಲ್ಲಿದೆ ಆತರ ಗ್ರ್ಯಾಂಡ್ ಸನ್ ಅಂತ ಎಲ್ಲಿದೆ?
ಇಲ್ಲಿ ಮೊಮ್ಮಗ ಅಂತ ಇದೆ ನೋಡಿ ಕೆಳಗಡೆ. ಮೊಮ್ಮಗ ಅಂತ ಇದೆ.
ಕದ್ರಪ್ಪಂಗೆ ನೋಡಿ, ಕದ್ರಪ್ಪಂಗೆ ಮಗ ಇದೆ 47.
ಯಾವ್ದ್ರಲ್ಲಿ ಓದ್ತಾ ಇದೀರಾ?
ಸೇಮ್ ಪೇಜ್ 51 ಅಲ್ಲಿ ಫಸ್ಟ್ ಕಾಲಮ್ ಮೇಲೆ ಸುಡ್ಸಿ ಮೇಲೆ ಕದಿರಪ್ಪ ಇಸ್ ಮಗ, ಗೌರಮ್ಮ ಇಸ್ ಸೊಸೆ.
ಅಲ್ಲ, ಎಲ್ಲಿ ಓದ್ತಾ ಇದೀರಾ? ಫಸ್ಟ್ ಅಲ್ಲಿ ಕದ್ರಪ್ಪ.
ಗಂಗಮ್ಮಂಗೆ ಮಗ ಕದ್ರಪ್ಪ, ಅವಳು ಸೊಸೆ ಗೌರಮ್ಮ. ಮೊಮ್ಮಗ ಮಗ, ಇದು ಮೊಮ್ಮಗ.
ಕದ್ರಮ್ಮಗೆ ಮೊಮ್ಮಗ, ಇವ್ರಿಗೆ ಕದ್ರಪ್ಪಗೆ
ಮಗ ಆಗ್ತಾರೆ. That is why he holds. Now my lords, may kindly come to page 51, the next page, my lord.
Yes.
This, my lord, is the election ID card that he produces. Kindly see where his address is showed, my lord. Mandikal.
Yes, ಯಾವುದು?
Page 51, my lord, 52, my lord. Election ID. Address is shown as Mandikal. Now, my lords, may take my statement of objections, my lord, at page 45.
Yes.
Now, this is part of annexure R35 series, my lord.
45.
Third column, my lord, on the top. First one.
KV Ramesh.
ವಿಲೇಜ್ ನೇಮ್ ನೋಡಿ ಮೇಲ್ಗಡೆ ಬರ್ತಿದ್ದಾರೆ. ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ ಟಾಪ್ ವಿಭಾಗದ
ಕಣಿತನಹಳ್ಳಿ.
My lords, in my statement of objections, I have also extracted, my lord, that his appointment as on 13/2/2015. My lord, from 2014, he gets a domicile certificate, my lord. My lords, may kindly come to page 4 of my statement of objections, para 5. For the sake of convenience, my lord, I'm just pointing out the chart that I have prepared. Page 4 of my statement of objections, my lord, para 5. There's a tabular column, my lord, that I have prepared.
Yes.
Lord, his appointment, my lord, is admitted on 13/2/2015. Lord, my 7/3/2014, he gets a domicile certificate showing his residence as Kantihalli. In 19, my lord, he is shown as Kantihalli. Next page, my lord. Caste certificate is issued in 19. His place of residence is shown as Kantihalli. Domicile certificate of 19, Kantihalli, Tahsildar.
Yes.
Then the order passed by the AC, my lord, registration also shows his residence in voters list in Kantihalli. Now, with respect to the endorsement, my lord, that the document certificate with respect to has been rejected on the ground so and so. And the last, these documents, my lord, I was produced as R32 series. My lord, may take it, my lord, it starts at page 20.
Even after appointment also, he has obtained.
Obtained there on. It starts, my lord, at page 34.
For the appointment, he has created the documents, has given. That is what the case.
Now, I'll just read the next of the paragraphs, my lord, small paragraphs. Go ahead.
Yes.
Third paragraph, my lord, ದಿನಾಂಕ 6/11/23 ವಿಚಾರಣೆ ವೇಳೆ ಮನೆ ಬಾಡಿಗೆ ಕರಾರ ಪತ್ರ ಪ್ರತಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು ಸದರಿ ಕರಾರ ಪತ್ರದಲ್ಲಿ ದಿನಾಂಕ 13/10/23 ತಯಾರಿಸಲಾಗಿದೆ. ಕೆ.ವಿ. ರವಿಕುಮಾರ್ ಅವರು ವಿಚಾರಣೆ ವೇಳೆಯಲ್ಲಿ ನೀಡಿರುವ ಚುನಾವಣೆ ಗುರುತಿನ ಚೀಟಿ ಪರಿಶೀಲಿಸಲಾಗಿ ನಂದಿ ಹೋಬಳಿ ಕಣ್ಣಿತಳ್ಳಿ ಗ್ರಾಮದ 23 ಚಾಲ್ತಿಯಲ್ಲಿರುವ ಮತದಾರ ಪಟ್ಟಿಯನ್ನು ಸಂಖ್ಯೆ 2ರಲ್ಲಿ ಅವರ ಹೆಸರು ನಮೂದಾಗಿರುತ್ತದೆ. ಕೆ. ರಮೇಶ್ ಕುಮಾರ್ ಅವರು ಮಂಡಿಕಲ್ ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಾಗಿರುವ ಬಗ್ಗೆ ಸಲ್ಲಿಸಿರುವ ಚುನಾವಣೆ ಗುರುತಿನ ಚೀಟಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಸ್ವಯಂಸೋ ಚುನಾವಣೆ ಗುರುತಿನ ಚೀಟಿ ವಜಾ ಆಗಿರುತ್ತದೆ ಕಂಡುಬರುತ್ತದೆ. ಆದರೆ ಹಾಲಿ ರಮೇಶ್ ಕುಮಾರ್ ಅವರು ಸ್ವಯಂಸೋ ಕತ್ತಿನಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ವಿಳಾಸವಾಗಿರುವ ಮತದಾರ ಪಟ್ಟಿಯಲ್ಲಿ ಕ್ರಮ ಸಂಖ್ಯೆ 2ರ ಪ್ರತಿ ಎಂದು ಕಂಡುಬರುತ್ತದೆ. ಮುಂದುವರೆದು ಸದರಿ ಅವರು ದಿನಾಂಕ 8/11/23 ಪಟ್ಟಿಯಲ್ಲಿ ಹೆಸರನ್ನು ಮಂಡಿಕಲ್ ಗ್ರಾಮಕ್ಕೆ ವರ್ಗಾವಣೆ ಮಾಡಲು ಕೋರಿರುವ ಮೇರೆಗೆ ಮಾನ್ಯ ಉಪವಿಭಾಗ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಪತ್ರ ಸಂಖ್ಯೆ ಸ್ವಯಂಸೋ ಕೆ.ವಿ. ರಮೇಶ್ ಕುಮಾರ್ ಅವರು 6 ತಿಂಗಳಿಗಿಂತ ಕಡಿಮೆ ವಾಸವಾಗಿರುವ ಕಂಡು ಬರುವುದರಿಂದ ಸದರಿ ಅವರು ಸಲ್ಲಿಸುವ ನಮೂನೆ 8ಅನ್ನು ಪರಿಗಣಿಸಲು ಅವಕಾಶವಿಲ್ಲವೆಂದು ಅರ್ಜಿಯನ್ನು ತಿರಸ್ಕರಿಸಲು ಆದೇಶಿಸಲಾಗಿದೆ. ಆದೇಶದ ಪ್ರತಿಯನ್ನು ಕಂಡು ಬರುತ್ತದೆ. ಅದರಿಂದ 12/23 ನೇಮಕ 8ಅನ್ನು ವಜಾ ಆಗಿರುತ್ತದೆ. ಕೆ.ವಿ. ರಮೇಶ್ ಕುಮಾರ್ ಅವರು ಸಲ್ಲಿಸುವ ಮನೆ ಬಾಡಿಗೆ ಕರಾರ ಪತ್ರ ಪರಿಶೀಲಿಸಲಾಗಿ ಸದರಿ ಪತ್ರದಲ್ಲಿ ಮಂಡಿಕಲ್ ಗ್ರಾಮದ ಹೌಸ್ ಲಿಸ್ಟ್ ನಂಬರ್ 106 ಮನೆಯನ್ನು ದಿನಾಂಕ 1/10/2023 ಸ್ವಾಧೀನಕ್ಕೆ ಪಡೆದುಕೊಂಡಿರುವುದಾಗಿ ನಮೂದಾಗಿ ಹಾಗೂ ಸದರಿ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ದಿನಾಂಕ 13/10/23 ನೋಟರಿ ಮಾಡಿಸಿರುವ ಕಂಡುಬರುತ್ತದೆ. SSLC ಅಂಕಪಟ್ಟಿಯಲ್ಲಿ ಸಹ ಕೆ.ವಿ. ರವಿಕುಮಾರ್ ಬಿನ್ ವೆಂಕಟೇಶಪ್ಪ ನಂದಿ ಹೋಬಳಿ ಕತ್ತಳ್ಳಿ ಗ್ರಾಮಕ್ಕೆ ಸಂಬಂಧವೆಂದು ಕಂಡುಬರುತ್ತದೆ. ದಿನಾಂಕ 6/11/23 ವಿಚಾರಣೆ ಹಾಜರಾದ ಸಂದರ್ಭದಲ್ಲಿ ಕೆ.ವಿ. ರವೀಶ್ ಕುಮಾರ್ ಅವರು ಕೆ.ವಿ. ಜನರಲ್ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ವೈದ್ಯಕೀಯ ಪ್ರಮಾಣ ಪತ್ರ ಸಲ್ಲಿಸಿರುವುದನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ದಿನಾಂಕ 8/8/19 ಪಡೆದ ಹೊರರೋಗಿ ದಾಖಲೆ ಔಟ್ ಪೇಷಂಟ್ಸ್ ರೆಕಾರ್ಡ್ ಆಗಿದ್ದು ಇದು ವೈದ್ಯಕೀಯ ದೃಢೀಕರಣ ಪತ್ರವಾಗಿರುವುದಿಲ್ಲ. ಸದರಿ ಅವರು ನೀಡಿರುವ ಲಿಖಿತ ಹೇಳಿಕೆಯಲ್ಲಿ ಕೇವಲ 8/8/19, 9/8/19, 31/8 ಅನಾರೋಗ್ಯ ನಿಮಿತ್ತ ಕರ್ತವ್ಯ ಸಮಯದಲ್ಲಿ KC ಜನರಲ್ ಆಸ್ಪತ್ರೆ ಬೆಂಗಳೂರಲ್ಲಿಗೆ ಹೋಗಿ ಬಂದು ತಿಳಿಯುತ್ತದೆ. ವಿಚಾರಣೆ ವೇಳೆ ಸಲ್ಲಿಸಿರುವ ದಾಖಲೆಗಳನ್ನು ಮತ್ತು ಲಿಖಿತ ಹೇಳಿಕೆಯನ್ನು ಉಲ್ಲೇಖ 4ರಿಂದ ಗ್ರಾಮಸ್ಥರ ಈ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಿರುವ ದೂರು ಮತ್ತು ಉಲ್ಲೇಖ 5 ರಾಜಸ್ವ ನಿರೀಕ್ಷೆವರೆಗೆ ಸ್ಪಷ್ಟವಾಗಿ ಕಂಡುಬರುವುದು. ಗ್ರಾಮಸ್ಥರ ದೂರು ರಾಜಸ್ವ ನಿರ್ದೇಶಕರು
Yes, he is not resident.
Yes, may clarify that in respect of voter ID, my lord. I get clarification from the BLO, annexure ACC, my lord, page number 88.
Yes.
Page number 89, my lord. Typed copy.
Yes.
ವಿಷಯ 2016ರಿಂದ 2020 ತನಕ ಮತದಾರ ಪಟ್ಟಿಯಲ್ಲಿ ಹೆಸರು ನಮೂದಾಗಿರೋ ಬಗ್ಗೆ ಕೋರಿರೋ ಬಗ್ಗೆ. Let's got it, my lord.
Yes.
Page number 89.
Yes.
Typed copy. ಕೆ.ವಿ. ರಮೇಶ್ ಕುಮಾರ್ ಬಿನ್ ವೆಂಕಟೇಶಪ್ಪ, my lord.
Yes.
2016ರಿಂದ 2021 ವರೆಗೆ ಮತದಾರ ಪಟ್ಟಿಯಲ್ಲಿ ಹೆಸರು ನಮೂದಾಗಿರೋ ಬಗ್ಗೆ ಕೋರಿರುವ ಬಗ್ಗೆ. ಈ ಮೇಲ್ಕಟ್ಟ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿ ಕೆ.ವಿ. ರಮೇಶ್ ಕುಮಾರ್ ಬಿನ್ ವೆಂಕಟೇಶಪ್ಪ ಮಂಡಿಕಲ್ ಇವರು ಕಣಿತಳ್ಳಿ ಗ್ರಾಮದ ಮೂಲ ನಿವಾಸಿಯಾಗಿದ್ದು ಪ್ರಸ್ತುತ ಮಂಡಿಕಲ್ಲಲ್ಲಿ ವಾಸವಾಗಿರುತ್ತಾರೆ. ಇವರು ಕಣಿತಳ್ಳಿ ಗ್ರಾಮದ ಮತದಾರ ಪಟ್ಟಿ 2016ರಿಂದ 2020 ಇವರ ಹೆಸರು ಮತದಾರ ಪಟ್ಟಿಯಲ್ಲಿ ನಮೂದಾಗಿದೆಯೇ ಅಥವಾ ಇಲ್ಲವೇ ಎಂಬುದರ ಮಾಹಿತಿ ಕೋರಿದ್ದು ಅದರಂತೆ ಪರಿಶೀಲಿಸಲಾಗಿದ್ದು 2016ರಿಂದ 2021 ಮತದಾರ ಪಟ್ಟಿಯಲ್ಲಿ ಇವರ ಹೆಸರು ನಮೂದಾಗಿರುವುದಿಲ್ಲ ಮತ್ತು 2000 ನಂತರ 21 ಮತದಾರ ಪಟ್ಟಿಯಲ್ಲಿ ಹೆಸರು ಸೇರ್ಪಡೆಯಾಗಿರುತ್ತದೆ. ಈ ಬಗ್ಗೆ ಕೆ.ವಿ. ರಮೇಶ್ ಕುಮಾರ್ ಮತದಾರ ಪಟ್ಟಿಯಲ್ಲಿ ತಮ್ಮ ಹೆಸರು ಸೇರ್ಪಡೆಗೊಳಿಸಲು ಯಾವುದೇ ಅರ್ಜಿ ನೀಡಿರುವುದಿಲ್ಲ. ಆದರೂ ಇವರು ಹೆಸರು ಮತದಾರ ಪಟ್ಟಿಯಲ್ಲಿ ಸೇರ್ಪಡೆಯಾಗಿರುತ್ತದೆ ಎಂದು ಈ ಮೂಲಕ ದೃಢಪಡಿಸಿರುತ್ತೇವೆ.
Yes.
My lord, I am residing in the Mandikalli circle only. I am not residing in the Kanitalli village. My lord, earlier litigation, the petitioner has dismissal from service alleging that without holding an inquiry and is remaining unauthorized absent.
Yes.
My lord,
No, that is true. That may be.
Please.
Now that there is no bar for them to take an action for you to.
Please, my lord.
Intention may be something different. They
Please.
wants to give an appointment to them.
Please, my lord.
Taking a reason that you are unauthorized absent, you have been removed.
Please, my lord.
ನೀವು ಕೋರ್ಟಿಗೆ ಬಂದ್ರಿ.
Please, my lord.
ಅವಾಗ ಏನ್ ಮಾಡಿದ್ರು ಇನ್ನೂ ರಿಸರ್ಚ್ ಮಾಡಕ್ ಹೋದ್ರು ನಿಮ್ ಬಗ್ಗೆ ಇವ್ನ ಏನಾರ ಮಾಡಿ ತೆಗೆದ್ಬಿಟ್ಟು ಬೇರೆ ಅವಾಗ ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ನಿಮ್ದು ಏನ್ ತಪ್ಪಿದೆ ಅದು ಸಿಕ್ಕಾಕೊಂಡ್ಬಿಡಿ.
So far, my lord, the document is shows that I am not resident of the Kaditalli village.
Yes.
My lord, they are asked for my document which I am residing in the Mandikal village.
Yes.
My lord, I produced that certificate. My lord, the certificate shows that ಇಲ್ಲಿ ನಾನು ಕಣಿತಳ್ಳಿ ವಿಲೇಜ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಅದು ವಾಸ ದೃಢೀಕರಣ ಪತ್ರ ಕ್ಯಾನ್ಸಲ್ ಆಗಿದೆ ಅಂತ ವೆರಿ ಸೇಮ್ ತಹಸೀಲ್ದಾರ್ ಎಂಡೋಸ್ಮೆಂಟ್.
Yes.
ನಾವು ಇನ್ ದ ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ನೀವಲ್ಲಿ ಆ ವಾಸವಾಗಿದ್ದೀರಿ ಅಂದ್ಬಿಟ್ಟು ವಾಸಸ್ಥಳ ದೃಢೀಕರಣ ಪತ್ರ ಇದೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
Yes.
They contradicted their own statement. Right? It is required for wording enquiry.
One thing is that.
Please, my lord.
You are a resident of Kanitallu village.
Please, my lord.
To get in a job, you shifted there.
No, my lord. My lord.
Now,
I am not getting the job, my lord. 2010, I am resident that.
2010, you are shifted there.
Please, my lord.
After that, they have filed an application. By the time you got all documents.
But by virtue of
thereafterwards, after appointment, again you have taken a, other residential certificate in that Kanitallu village.
No, my lord.
Because he wants that.
No. I have not obtained any residence certificate in Kanitalli. I am not enter my voter list in the Kanitalli.
Yes.
The BLY itself has cleared that.
Yes.
Right, that is the annexure. BLY is clarified that, my lord. Annexure AC 89 is, my lord, BLY statement, and annexure AD.
Oh, what is this? Your income certificate?
Right, income is less. Annexure.
No. Income certificate. What is your resident has been shown?
Please, my lord. At the time of my appointment, my lord, I produced that residence certificate. Mandikal, my lord.
Huh?
Mandikal.
No, in 2019 income certificate, what is that resident here has been shown?
But that is the clarification given by the affidavit filed by the Tahsildar. ನಮ್ದು OTC ನಲ್ಲಿ ಎಂಟ್ರಿ ಆಗಿರ್ತದಲ್ಲ, ಆಟೋಮೆಟಿಕ್ ಆಗಿ ಎಂಟ್ರಿ ಆಗುತ್ತೆ ಅದು ಡೇಟ್ ವಿತೌಟ್ ಎನಿ ಸಪೋರ್ಟಿಂಗ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದಾರೆ.
In respect of income certificate or
my lord, ಈ certificate attached to the ration card databases, my lord. But when you apply for if you go for databases, it's automatically generated.
That's so Administrative Office, Revenue Inspector conducts spots and verify whether that applicant resident report to that Tahsildar based upon the report resident certificate issued so and so. In verifying the resident certificate issued to the respondent, it was found that when the petitioner applied for a ration card at village,
no supporting document, my lord,
was generated through the e-Khata. Even though no supporting documents were submitted, the resident certificate was technically approved, but its data was linked to that existing ration card in that database, which is addressed Kanitallu village, unfavorably, and hence the resident certificate which is given. He is stated only in respect of residential certificate.
Please, my lord, everything is, my lord. Page number 5, my lord. In the affidavit, kindly pay, my lord. Please, my lord. Page number para 5.
Yes, my lord.
One nimsha, sir. Please, I will come to that.
Yes.
Para 5, my lord. Page number 2. Upon further inquiry with the Sakala coordinator, Chikballapura district, regarding the residence certificate printed on 16/8/2019, it was clarified that the certificate printed through the OTC software are automatically generated. As evidence, it was stated that if the residence certificate number bearing number.
No, that is only in respect of residential certificate.
Please, my lord.
Not in respect of that income certificate.
Income certificate illa. Income certificate is pertaining to Mandikal.
2019.
Please, my lord. 19 they are produced ಹೇಳಿರುವಂತದವರು. 19 the residence certificate ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. In the impugned order. In the impugned order says that.
No, where is that 2019 income certificate and cash certificate?
See the ordinance.
Wait.
Let's take, my lord, statement of objections, annexure R2 series, my lord, R3.
This is what that Pandit
R3, page 34, my lord. Vasa sthala dೃಢೀಕರಣ ಪತ್ರ.
Then how can be that Kadrappa is your father, Mr.
My lord, one fact they will that is my lord. Let's may take annexure B, my lord, at page 20, is appointment order. Annexure B at page 20.
In
writ petition. Let's may see the subject, my lord.
Annexure A.
Annexure B, my lord, page 2020. Subject.
Annexure
ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ಮಂಡಿಕಲ್ಲು ಹೋಬಳಿ ಮಂಡಿಕಲ್ ಕಂದಾಯ ವೃತ್ತದ ಗ್ರಾಮ ಸಹಾಯಕ ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಮಾಡಲು ಕೋರಿ ಶ್ರೀ KV ರಮೇಶ್ ಕುಮಾರ್ ಬಿನ್ ವೆಂಕಟೇಶಪ್ಪ ಕಣ್ಣಿತಹಳ್ಳಿ ಗ್ರಾಮ ಅವರು ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿ. This application he files it when he is there. When he gets the post, he shifts here. Now, my lords, may now come back to page 38, my lord, of my statement of objections. There is an order rejecting his request for transfer of domicile certificate from Kantihalli to this village. That order is not challenged till date.
Then how can that issued?
Then everything else goes. That's why, my lord, page 38, annexure 11/12/2013.
Page 30?
38, my lord. Annexure R3, 2E. Notes may see the operating portion of the order.
38 in your objection.
Statement of objections.
Yes.
ಆದುದರಿಂದ ತಹಸೀಲ್ದಾರ್ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಅವರ ವರದಿ ಆಧರಿಸಿ ಕೆ.ವಿ. ರಮೇಶ್ ಕುಮಾರ್ ಬಿನ್ ವೆಂಕಟೇಶಪ್ಪನವರು ಮಂಡಿಕಲ್ ಗ್ರಾಮದಲ್ಲಿ 6 ತಿಂಗಳಕ್ಕಿಂತ ಕಡಿಮೆ ವಾಸವಿರುವ ಕಂಡು ಬರುತ್ತದೆ. ಆದ್ದರಿಂದ ಸದರಿ ಅವರು ಸಲ್ಲಿಸಿರುವ ನಮೂನೆ 8 ಪರಿಗಣಿಸಲು ಅವಶ್ಯಕ. ಆದ್ದರಿಂದ
Now why namuni ent has been
for
given?
cancel transfer of his OSHA election ID from that village to this village.
From which village to which village?
From Kantihalli to Mandikal.
Why you have given, Mr.? You are already in a Mandikal village. Why you have?
Mandikal village, I was terminated in the 2019, my lord. When I terminated, I am shifted to my native place.
You are
Not he had any writ petition.
My lord, please, my lord.
No, you better be there in Kantikal, Mr.
Allah, please, my lord, please, my lord.
Place, yes.
Please, my lord, my lord.
Earlier round there was an
My
interim
lord,
order. He
what my
continued
lord,
in the
what
same
my
place.
lord, my learner friend says that the residence certificate reject ಮಾಡಿದ್ದಾರೆ. My lord, kindly take my memo, my lord, page number. Subsequently, they are issued in a residence certificate
Yes.
by virtue of my residence, my lord.
Yes, yes, I heard you, Mr. I will consider.
Please,
Your application itself stated that you are in a resident of Kanitahalli village. How they have appointed, I don't know that.
Please, my lord, page, my lord, my memo dated, my lord, 23.
I heard.
Allah, my lord, subsequently, they are issued them a residence certificate to me. Please, my lord, page number dated, my 23/6/2024, my lord.
Which is that? Yes. Where is that memo?
Memo, my lord, dated 23/6/2024, my lord. My lord,
Kodi, copy kodi.
Connected matter.
Huh?
ಯಾವ matter? Main matter.
ಇದರನ್ನೆಲ್ಲ
Connected matter ಏನದು?
Connected matter is filed by me, my lord, for a mandamus that to implement the order and to allot me the post. If this get disposed of, my lord, that becomes a problem.
What is this, Mr.?
The residence certificate issued by the Tahsildar, Mandikal village.
2025.
Please, my lord. Because of my the virtue of residence, my learned says that they rejected your application for issuing residence certificate.
Yes, ಮಾಡ್ತೀರಿ ನೀವು?
That's it. It's required for holding enquiry, my lord.
No.
But in the-
I will consider, Mr.
In the moreover, my lord, in the reply statement, my lord, in the previous occasion, I will show that, my lord. On what basis they are terminated me?
No, that is true.
Please, without what is not on the absence.
Yes.
My lords may see the memo itself, my lord, which he has filed. My lords may see the last line. ಸುಮಾರು 1 ವರ್ಷ 6 ತಿಂಗಳಿಂದ ವಾಸವಾಗಿರುತ್ತಾರೆ.
Please,
ಎಲ್ಲಿ ಯಾವ ಮೆಮೊ?
Same the memo that he filed. The certificate that is issued. My lords may see the first paragraph, last line, my lord. ಇವರು ಈ ವಿಳಾಸದಲ್ಲಿ ಸುಮಾರು 1 ವರ್ಷ 6 ತಿಂಗಳಿಂದ ವಾಸವಾಗಿರುತ್ತದೆ ದೃಢೀಕರಿಸಿದರು.
ಅದು 25 ಅಲ್ಲಿ.
25. 2017 he had established, my lord, from the date of his appointment.
Yes. The residency certificate is issued based on the resident, my lord. If I have resident that place more than 6 months, I am eligible for obtaining the residence certificate.
Yes.
My lord, I am obtaining a residence certificate by virtue of residing that circle, my lord. My lord, there is no irregularity in my appointment, my lord. As on the date of my recruitment, my lord, I possess the requisite residence certificate.
Yes.
Moreover, my lord, at the time of my lord, the appointment, the third respondents approach the authority. Cancellation of my appointment, they are issued endorsement. The third respondent is not eligible. Page number 47, annexure K, my lord.
Yes.
Page number 47, annexure K. May I permitted to read from second para, my lord. ಆದ್ದರಿಂದ ಕಚೇರಿಯಲ್ಲಿ ಪರಿಶೀಲಿಸಲು ಮಂಡಿಕಲ್ ಕಂದಾಯ ವೃತ್ತದ ಗ್ರಾಮ ಸಹಾಯಕರ ಹುದ್ದೆಯಲ್ಲಿ ನೇಮಕಾತಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ಯಾವುದೇ ಪ್ರಕರಣ ಹೊರಡಿಸಿರುವುದಿಲ್ಲ. ಹಾಲಿ ಅರ್ಜಿದಾರ ಶ್ರೀ ಕೆ.ವಿ. ರಮೇಶ್ ಕುಮಾರ್ ಬಿನ್ ವೆಂಕಟೇಶಪ್ಪನವರು ನೇಮಕ ಮಾಡಿಕೊಳ್ಳಲು 19/1/2016 ಪ್ರಾಸ್ತಾವನೆ ಸಲ್ಲಿಸಿದ ನಂತರ ಮಂಡಿಕಲ್ ಕಂದಾಯ ವೃತ್ತದ ಸಹಾಯಕರ ಹುದ್ದೆಗೆ ಒಟ್ಟು 6 ಜನ ಅರ್ಜಿ ನೀಡಿರುತ್ತಾರೆ. ಈ ಪೈಕಿ ಮೊದಲನೇದಾಗಿ ಗಜೇಂದ್ರ ಡಿ ವೆಂಕಟೇಶಪ್ಪ ಅವರು ತರಬಾರು ಗ್ರಾಮದ ವಾಸಿಯಾಗಿದ್ದು ದ್ವಿತೀಯ PUC ಉತ್ತೀರ್ಣರಾಗಿರುತ್ತಾರೆ ಹಾಗೂ ಗಣಕೀಕರಣ ಪೂರ್ಣಗೊಂಡಿರುವುದಿಲ್ಲ. ಬಾರಬಾರದಾರರ ವಂಶಸ್ಥರಾಗಿರುವುದಿಲ್ಲ. ಎರಡನೇದಾಗಿ KM ನರಸಿಂಹಮೂರ್ತಿ ಬಿನ್ ಕದಿರಪ್ಪನವರು ಸಹ PUC ಉತ್ತೀರ್ಣರಾಗಿರೋ ಅವಧಿನ 25. There is no notification, my lord. By virtue of my appointment, working in this 2010, they are appointed me. ಇಲ್ಲ ಹೇಳ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ ಇಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾದಲ್ಲಿ.
ಇದ್ರದ್ದು ಗ್ರಾಮ ಸೇವಕ ದಟ್ ಇದೆಲ್ರಿ ಸರ್ಕ್ಯುಲರ್. ಇದೇನಿದೆ ಎರಡು ಒಂದೇನಾ ಸೇಮ್? ಇಲ್ಲಿ ವೇತನ ಆಧಾರದ ಮೇಲೆ ಮಾಡಲ್ಪಟ್ಟಿರುವ ಗ್ರಾಮ ಸೇವಕ.
ನಾನು ಕೆಲಸ ಮಾಡ್ತಾ ಇರೋದು ನನಗೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಕೊಟ್ಟರು ಸ್ವಾಮಿ ಅದು.
Yes, yes.
2010 they are stated that.
Yes. The intention of the government is to restrict that scope of the recruitment of the Grama Sevaka. It is the member of the family of the village servant who are working as such during the previous year. The Deputy Commissioner of all that district are therefore requested to issue necessary instruction to the procedure mentioned in the annexure to the GO dated also cited above in selections of the candidate for the appointment of the newly created post in several villages as group of villages. The selection to the sector should be confined to the member of the order of also consider such candidates. You know, your family was in a Barwarda.
ಅವರು ಸೇರಿಲ್ಲ ಅಂತ ಸರ್. ಅವರು ಬರೋದಿಲ್ಲ. ಯಾರು ಥರ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್?
The eligibility member of the such a family of that village or villages of that revenue circle of that village account intervene in group by the Tahsildar at the given time and select the best among them of the qualification mentioned in the annexure. No deviation shall be made. The Associates Commission will be strive such selections. Where is that this thing, Mr.? The method of Tahsildar Revenue Talaks general order of the state district may appoint an Grama Sevaka on a temporary basis for a period not exceeding among who are traditionally discharging the duties of the inferior village office age of 25 years but not attained 65. Gramaka shall be fixed to some nation. Grama Sevaka help the village accountant in collecting so-and-so. Someone carry a village staff, assistant of village accountant. Do such other duties related to the government work. Where is that? He should be a resident of that village, Mr.
It's not in dispute, even they don't dispute, but it's a notification.
No, there's notification. There is not first. It's all that person who has families of the Gram Sevaka, the village officers. They have to be appointed.
First notification.
Your family members are. Then what about you, Mr.?
I'll also explain that. First, my notes may take.
It's not belong to that one.
You see that circular, Mr.
My notes may take, my lord, page 25 statement of objections. My lord, the 79 circular is there. Notes may see condition number 2.
70 in statement of objection. Yes, page
26, my lord.
26.
25, it starts at 25 typed copy, notes may come to 20.
26.
Second item, my lord. The eligible members of such families of the village or the villages of the revenue will be intervened as group of time to select among.
Among them has to be appointed.
First village alli irbeku. The province is the resident.
Nimdenide. What is your?
I also become the member of the family. But that, my lord, I have explained in my written.
Where is that?
The first instance, my lord,
wait, Mr. Please. Nobody is arguing on basic. What is that required under law? Yes. Where is that, Mr.?
Just a few seconds.
Yes. We verify. Sumne waste time ಮಾಡ್ತದೆ. Yes. Leave this matter.
Tomorrow only. Tomorrow only.
Not tomorrow, Mr. Yes. Next week, yes.
Serial number.
41.
Yes.
Temporary for
Next week, some
petitioner.
date, Manoj.
Well,
Yes, I appear for R7, my lords.
Yes.
Copy ಕೊಟ್ಟಿಲ್ಲ ಸುಮ್ಮನೆ ರಿಟ್ ಪೆಟಿಷನ್ ಎಂಟರ್ ಸೆಟ್ ಓನ್ಲಿ ಬರೀ ಪೇಪರ್ಸ್ ಎಡಿಟ್ ಆಗಿದೆ ಅಷ್ಟೇ.
ಅವ್ರಿಗೆ ಸೆಕ್ರೆಟರಿ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಆಮೇಲೆ ಈಗ ಅಪಿಯರೆನ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಇಟ್ ಮೇ ನಾಟ್ ಬಿ ಪ್ರಾಪರ್. In fact, the institution was
So the name was Sanjay, learned counsel for respondent to release this matter and so on so.
ಅವ್ರಿಗೆ ಅಪಿಯರ್ ಆಗಿರ್ಲಿಲ್ಲ, ಯಾವಾಗ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಯ್ತು ಅವಾಗ ಅಪಿಯರೆನ್ಸ್.
Present before this office is directed to communicate this order to secretary. Yes, Mr. Where is your secretary, Mr.?
Lords, I'll keep him present next week, Manoj. Let him serve a copy of the writ petition. I have only the writ papers, that's what. Documents.
No, as he, copy is not served to him by through that post.
Only writ petition is only served. No documents has been received by me, Lords. I have only writ papers, that's all.
Served not, they did not appear before the court.
No, these are all that so many complaints are coming. We will verify from the office how they will identify. See, when you are give only a petition, they will not see that what are the annexures are there. They will send it like that only.
All were served. It was being listed.
No, not only your case. In so many cases, they will come and say that copy is not produced. How that office will verify? We will see register judicial. Yes.
They did not appear until notice was issued in this case to personal.
No. Notice will go. In some cases, they will
send. Cases I can understand. Yes, you are.
Not very notice ಕಳಿಸ್ತಾರೆ.
ಹೌದು, that does happen.
That has been objected when I was an advocate saying that very notice has been sent. Petition copy is ದಪ್ಪ ಇದೆ. ಅವರು ಕೋರ್ಟ್ ಇಂದ ಬಂದಿರತಕ್ಕಂತ ಪೋಸ್ಟಲ್ ಕವರ್ ನು ಇಟ್ಕೊಂಡಿದ್ದು, ಕವರ್ ಅಲ್ಲಿ ಆ ಪಿಟಿಷನ್ ಕಾಪಿ ಹಾಕಕ್ಕೆ ಆಗೋದಿಲ್ಲ. This is the cover which has been shown. Only that notice has been sent. Today I will verify from that registry.
Yes. The
whether they will verify along with that original petition or they will send it as it is.
In fact,
anyhow you serve a copy to him.
No, I'll ensure, Melody, if he wants a copy, there is no difficulty at all. But to say that it is not sent.
No, that if there is any such lacuna, we have to be rectified that. It should not be there in the future. Yes. Yes, you, when do you want, Mr.? No, last week itself I said you serve a copy, Mr.
No, in fact,
12-2. And 12-2 he has appeared.
Please,
the matter was
he has appeared
evening.
through
He appeared in the evening. I mean, matter was called in the evening. I made a submission. In fact, it was my adjournment was taken in the morning. I made a submission and I requested for my lords the name be shown.
Yes, Mr. You serve a copy to him.
I'll ensure that it is done today itself. There's no difficulty.
Any date may begin next week.
I'm out of employment, my lords. They have not.
26 minutes. 26 minutes.
Is this matter on 5th, Mr. 5th?
Please.
Yes. 26th. Our namige free irvekalla. Yes.
Number 42. Tejasvi KV for petitioner, government advocate.
I appear, my lord, I appear on behalf of the petitioner, my lord.
Serial number 42.
Appear. Matter relates to approval of the appointment for grant. Petitioner was appointed as a lecturer in English in the year 1994. Continued from time to time, approval was sent from time to time for approval appointment, my lord. Belatedly in 2013, approval has been given, but without grant, my lord. Page number 93, annexure X. Page number 93, my lord.
Mr. Government Advocate, ready?
Reply,
ಏನಕ್ಕೆ objection ಹಾಕಿಲ್ವಾ?
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಬೇಕು. For the department.
No, objection ಹಾಕಬೇಕಾದ್ರೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಾಣಲ್ವಾ?
ಎಲ್ಲ ಡೀಟೇಲ್ಡ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ.
What is this, Mr.
94 ಅಲ್ಲಿ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದು, my lord, belatedly in 2015 they approved the appointment, annexure X, my lord, that too without grant. Page number 93, my lord.
Annexure X.
X, my lord.
Yes.
ಭಾರತಿ ಸಂಯುಕ್ತ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಮುರುಗೋಡು ಮಡಿಕೇರಿ ತಾಲೂಕು ಕೊಡಗು ಜಿಲ್ಲೆ ಸಂಸ್ಥೆ HK ಸುಜೇಶ್ ಇಂಗ್ಲಿಷ್ ಉಪನ್ಯಾಸಕರ
When they send in a proposal, Mr. Rangnath, when they send a proposal.
they have sent proposals right from the date of appointment. First proposal is annexure, annexure F, my lord. Sorry,
No, that
annexure
similar
G.
matter was there in the, Srikanth, what has happened that granting aid has been admitted from the date of that order, not from the date of that appointment. You also argued that one matter, what has happened there?
Here approval itself is not given. That in this case, approval itself, the grant kotte illa. Adrolage question ಏನು ಬರುತ್ತೆ ಅಂದ್ರೆ, from what dates the service benefits have to be granted for purpose of time bound promotion anta. Division bench allowed on 2 occasions, but they made a rule. That rule was also quashed by the court, and thereafter matter is.
No, Mr. Not time bound. Wait. No. No, it is, he has been appointed after due process of law. Then there is a delay of, there is, you have, yes, administrative, this thing.
94 appointment
where is that appointment order?
Appointment order, my lord. Notification is my lord, annexure B is the notification issued, my lord, page number 26. In pursuance of the notification issued in the newspaper, applications are invited from eligible candidate for the post of lecturer English, post is fully temporary. So that was the notification in pursuance of which was appointed annexure C.
Yes.
Page number 27. So from 1994, I have been continuously working. Initially, my lord, annexure F in the same college, other persons approval appointment were. Now, ಇವಾಗ ಏನಿಲ್ಲ. ನಾನ್ ಸ್ಪೀಕಿಂಗ್ ಆರ್ಡರ್ my lord, ತಾತ್ಕಾಲಿಕ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದು ಇನ್ನು ಯಾಕೆ ಗೊತ್ತಿಲ್ಲ, ತಾತ್ಕಾಲಿಕ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Then, my lord, now what I have challenged in the present petition is annexure A25. ಈಗ 94 ಆದ್ಮೇಲೆ ಈಗ ಸ್ಟೂಡೆಂಟ್ ಸ್ಟ್ರೆಂತ್ ಇಲ್ಲ ಅಪ್ರೂವ್. ಪೇಜ್ 25 my lord. MK ಸುಜಯ್ ಆಂಗ್ಲ ಭಾಷಾ ಉಪನ್ಯಾಸಕರು ಅವರನ್ನು ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಬಗ್ಗೆ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಭಾರತೀಯ ಸಂಯುಕ್ತ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಮುರುಗೋಡು ಕೊಡಗು ಜಿಲ್ಲೆ ಈ ಕಾಲೇಜಿನ ಆಂಗ್ಲ ಭಾಷಾ ಉಪನ್ಯಾಸಕರ ಹುದ್ದೆಯನ್ನು ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಬಗ್ಗೆ ಸಲ್ಲಿಸಲಾಗಿರುವ ಉಲ್ಲೇಖಿತ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಸದರಿ ಕಾಲೇಜಿನಲ್ಲಿ ಮತ್ತು ಕಾರ್ಯಭಾರ ಸಲ್ಲಿಸಿರುವ ಸಂಪಾಜೆ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಇವರಿಗೆ ಕನಿಷ್ಠ ನಿಗದಿತ ವಿದ್ಯಾರ್ಥಿಗಳ ದಾಖಲಾತಿ ಇಷ್ಟು ವರ್ಷ ಆದ್ಮೇಲೆ ಈಗ ಈ ಪ್ರೆಸೆಂಟ್ ಇಯರ್ ಅಲ್ಲಿ ಸ್ಟೂಡೆಂಟ್ ಸ್ಟ್ರೆಂತ್ ಇಲ್ಲ ಅಂತ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಆನ್ ದಿ ಕಾಂಟ್ರರಿ my lord, this proposal which was sent in that it is clearly stated by the management. Your lordship may kindly see a proposal for the moment, my lord, at page number 133 my lord, 133 last page annexure ZK. ಪ್ರಪೋಸಲ್ ಅಲ್ಲಿ ಎಲ್ಲ ಡೀಟೇಲ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ, ಕ್ವಾಲಿಫೈಡ್ ಇವ್ರು ಇದ್ದಾರೆ ಅಂತ. ಪೇಜ್ ನಂಬರ್ 106 133 ZK ಭಾರತಿ ಪ್ರಪೋಸಲ್ ಕಳಿಸಿರೋದು ಇದನ್ನೇ ಅವರು ಬೈ ನಾನ್ ಸ್ಪೀಕಿಂಗ್ ಆರ್ಡರ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ZK my lord, ಭಾರತ ಸಂಯುಕ್ತ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಮಡಿಕೇರಿ ಇಲ್ಲಿ ಇಂಗ್ಲಿಷ್ ವಿಷಯದ ಹುದ್ದೆಯನ್ನು ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಬಗ್ಗೆ ರೆಫರೆನ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ಟು ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಭಾರತೀಯ ಸಂಯುಕ್ತ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಮಡಿಕೇರಿಯಲ್ಲಿ ಅನುದಾನಿತ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಇರುತ್ತದೆ. ಸದರಿ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು 93ರಿಂದ ಸರ್ಕಾರದ ನೇರ ವೇತನ ಅನುದಾನಕ್ಕೆ ಪಡೆದಿರುತ್ತದೆ. ಪ್ರಸ್ತುತ ಈ ಕಾಲೇಜಿನ ಕನ್ನಡ, ಇತಿಹಾಸ, ಅರ್ಥಶಾಸ್ತ್ರ, ರಾಜ್ಯಶಾಸ್ತ್ರ, ಸಮಾಜಶಾಸ್ತ್ರ ಅನುದಾನಕ್ಕೆ ಒಳಪಟ್ಟಿರುತ್ತಾರೆ. ಇಂಗ್ಲಿಷ್ ವಿಷಯದ ಬಗ್ಗೆ MK ಸುಜಯ್ ಅವರ ನೇಮಕಾತಿಯನ್ನು ಜಿಲ್ಲಾ ತ್ರಿಸದಸ್ಯ ಸಮಿತಿ ಸಭಾ ನಡವಳಿಕೆಯಲ್ಲಿ ವಿಷಯದ ಬಗ್ಗೆ MK ಸುಜಯ್ ಅವರ ನೇಮಕಾತಿಯನ್ನು ಜಿಲ್ಲಾ ತ್ರಿಸದಸ್ಯ ಸಮಿತಿ ನಡವಳಿಕೆಯಲ್ಲಿ ಸರ್ಕಾರದ ಸಹಾಯದಾನಕ್ಕೆ ಒಳಪಡಿಸಲು ಶಿಫಾರಸು ಮಾಡುವಂತೆ ತೀರ್ಮಾನಿಸಿರು. ಅಂದ್ರೆ there was a committee constituted that recommended that his name should be considered for grant. ಈ ಕಚೇರಿ ಜ್ಞಾಪನ ಸಂಖ್ಯೆ 16/11/15ರಲ್ಲಿ ಅನುದಾನ ರಹಿತವಾಗಿ.
Which page you are reading, Mr.?
Page number 134, my lord. It starts from 133. It is the proposal by the deputy director of the department, my lord. In that he has clearly stated that the 3-member committee has recommended for the grant, my lord. That was what I was reading. Page number 134, my lord. Top portion. MK ಸುಜಯ್ ಅವರ ನೇಮಕಾತಿಯನ್ನು ಜಿಲ್ಲಾ ತ್ರಿಸದಸ್ಯ ಸಮಿತಿಯ ಸಭಾ ನಡವಳಿಕೆಯಲ್ಲಿ ಸರ್ಕಾರಕ್ಕೆ ಸಹಾಯ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸಲು ಶಿಫಾರಸು ಮಾಡುವಂತೆ ತೀರ್ಮಾನಿಸುವುದರಿಂದ ಈ ಕಚೇರಿ ಜ್ಞಾಪನ ಸಂಖ್ಯೆ 16/11/2015ರಲ್ಲಿ ಅನುದಾನ ರಹಿತವಾಗಿ ಅನುಮೋದಿಸಿ ವೇತನ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸಲು ಉಲ್ಲೇಖ 2 ಪ್ರಸ್ತಾವನೆಯನ್ನು ಕಳಿಸಲಾಗಿತ್ತು. ಉಲ್ಲೇಖ 3ರಲ್ಲಿ ಸದರಿ ಹುದ್ದೆಯನ್ನು ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ದಾಖಲೆ ಮಾಹಿತಿ
See that annexure A. No
Non-speaking
reasoning has been
order.
put. Yes. You
ಈಗ
reconsider
ಪ್ರೆಸೆಂಟ್
that.
ಅಟೆಂಡೆನ್ಸ್ ಇಲ್ಲ, ಪ್ರೆಸೆಂಟ್ ಸ್ಟೂಡೆಂಟ್ ಸ್ಟ್ರೆಂತ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಪ್ರಪೋಸಲ್ ನ ರಿಜೆಕ್ಟ್ ಮಾಡಬಹುದಾ ಆಫ್ಟರ್ 20
Oh, they have sent the proposal in long back in that year 2000. When you have sent that proposal, Mr.
15 2015. The proposal is relatable to 2015. The proposal sent is of 2015. That reference has been made. That was what just I was reading.
Huh?
Page number 20.
No, proposal has been sent when, Mr.
16/11/2015. 134 16/11/2015 ಅನುದಾನ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಕಳಿಸಲಾಗಿತ್ತು. ಪೇಜ್ ನಂಬರ್ 134 ಲೈನ್ ನಂಬರ್ 3. ಈ ಕಚೇರಿ ಜ್ಞಾಪನ ಸಂಖ್ಯೆ 16/11/2015 ಅನುದಾನ ರಹಿತವಾಗಿ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸಲು ಉಲ್ಲೇಖ 2ರ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಕಳಿಸಲಾಗಿತ್ತು. ಉಲ್ಲೇಖ 3ರಲ್ಲಿ ಸದರಿ ಹುದ್ದೆಯನ್ನು ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಕುರಿತು ದಾಖಲೆ, ಮಾಹಿತಿ ಹಾಗೂ ಸ್ಪಷ್ಟ ಅಭಿಪ್ರಾಯದೊಂದಿಗೆ ವರದಿಸಲು ಸೂಚಿಸಿದ ಮೇರೆಗೆ ಉಲ್ಲೇಖ 4ರಲ್ಲಿ ಸಂಸ್ಥೆಯು ಕಾರ್ಯದರ್ಶಿ ಶ್ರೀ ಎಂ.ಕೆ. ಅವರ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಕುರಿತು ಈ ಕಾಲೇಜಿನಲ್ಲಿ ಆಂಗ್ಲ ಭಾಷಾ ವಿಷಯಕ್ಕೆ ವಾರದಲ್ಲಿ 10 ಗಂಟೆಗಳ ಕಾರ್ಯಭಾರ ಮಾತ್ರದಿಂದ ಸಮೀಪದ ಸಂಪಾಜೆ ಕಾಲೇಜಿನಲ್ಲಿ ಇವರಿಗೆ ವಯೋನಿವೃತ್ತಿಯಿಂದ ತೆರವಾದ ಅನುದಾನಿತ ಹುದ್ದೆಗೆ 10 ಗಂಟೆಗಳ ಕಾರ್ಯಭಾರದ ಒಪ್ಪಿಗೆಯನ್ನು ಪಡೆದು ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ದಾಖಲೆಯೊಂದಿಗೆ ಸದರಿ ನೌಕರನ್ನು ವೇತನ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವ ಸಂಬಂಧ ದಾಖಲೆ ಮತ್ತು ಮಾಹಿತಿಯನ್ನು ಈ ಪ್ರಸ್ತಾವನೆಯೊಂದಿಗೆ ಕಳಿಸಲಾಗಿತ್ತು. ಸದರಿಯಲ್ಲಿ ಈ ಹುದ್ದೆಯ ಕಾಲೇಜಿನಲ್ಲಿ ಪ್ರಥಮ ಹುದ್ದೆಯಾಗಿದ್ದು 2 ಕಾಲೇಜಿನಲ್ಲಿ 20 ಗಂಟೆ ಕಾರ್ಯಭಾರವನ್ನು ಸರಿತೂಗಿಸಿದ ವೇತನ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸಬಹುದೆಂಬ ಅಭಿಪ್ರಾಯದೊಂದಿಗೆ ಡೆಪ್ಯೂಟಿ ಡೈರೆಕ್ಟರ್ ರೆಕಮೆಂಡ್ಸ್ ಮೈ ಕೇಸ್ ಫಾರ್ ಅಪ್ರೂವಲ್. But by an impugned order, it has been rejected, saying that ಇವಾಗಿರೋ ಆ ಕಾಲೇಜಲ್ಲಿ ಕನಿಷ್ಠ ನಿಗದಿತ ವಿದ್ಯಾರ್ಥಿಗಳ ದಾಖಲೆ ಇರುವುದರಿಂದ ಅಂತ. ಈಗ 94 ಇಂದ ಕೆಲಸ ಮಾಡಿ 23 ಒಳಗೆ ಯಾವ್ದೋ ಒಂದು ಪರ್ಟಿಕ್ಯುಲರ್
earlier whether it was in a thing. Now it is not.
Instruction will come back. Monday to start.
No, what is that annexure A states? Nothing is there.
Nothing is there.
Supporting me, kindly see page number 20.
20?
20. That to annexure R7. We have stated that she did not possess the requisite qualifications.
No, you say in that. Why you have said that in endorsement saying that there is no student strength? Student strength illa anta ನೀವು ಹೇಳಿದ್ರೆ that means to say she is qualified, but because of student strength you cannot be. If she is has not qualified, if that appointment is not in terms of the law, therefore your proposal cannot be considered. That should be your endorsement, Mr. ನೀವು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಅವ್ರಿಗೆ ಹೆಲ್ಪ್ಫುಲ್ ಆಗಂಗ್ ಕೊಡ್ತೀರಾ. ಇಫ್ ಯು ಸೇ ಸ್ಟೂಡೆಂಟ್ ಸ್ಟ್ರೆಂತ್ ಇಸ್ ನಾಟ್ ದೇರ್, ದಟ್ ಮೀನ್ಸ್ ಟು ಸೇ she is eligible but strength is not there, therefore cannot be considered. That is not
ಅಪ್ರೂವಲ್ ಆಗೋಗಿದೆ. 2013 ನಲ್ಲಿ ವಿತೌಟ್ ಗ್ರಾಂಟ್ ಆಲ್ರೆಡಿ ಅಪ್ರೂವ್ ಆಗೋಗಿದೆ.
I will say in this writ petition, petitioner called in question annexure A dated 19/5/2024, whereby proposal sent by the management for approval of the appointment of the petitioner as an English teacher has been rejected.
ಅಪ್ರೂವಲ್ ಫಾರ್ ಗ್ರಾಂಟ್ ಮೇಲೆ ಅಪ್ರೂವಲ್ ಆಗೋಗಿದೆ 13ರಲ್ಲಿ ಗ್ರಾಂಟ್ ಅಪ್ರೂವಲ್ ಆಫ್ ಗ್ರಾಂಟ್.
Yes, the case of the petitioner that petitioner was appointed
1994 ಮೇಲೆ date of appointment
as a lecturer in English
on 3/7/94
college on 3/7/1994,
and appointment without grant has been approved on 16/11/51 annexure X.
that appointment was been approved without grant by order dated 18/9/1994. ನಿಮ್ದಿದೆಯಾ ಅದ್ರಲ್ಲಿ ಹೆಸರು?
ಅದ್ರೊಳಗಲ್ಲ, annexure X ಮೇಲೆ ನೋಡ. annexure X is the approval, page number 96. page number 96
annexure
X, page number 96.
ಏನದು?
That is the approval of appointment without grant.
Your name is there?
My name is there, M.K. Sujay. Nanda, it's an individual order passed in respect of me.
Void annexure X dated 16/11/2015. Appointment as approved. Appointment as approved without grant. Now we are saying that he is not qualified. How, Mr.?
Nadi, that is.
Stand, Mr. How this, your officers are working, Mr. How you can be approved, Mr. If he is not qualified?
He is qualified, Nadi. Adu munche avaga.
ಆಯ್ತು ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಏನು ಹಾಕಿದ್ದೀರಾ ನೀವು? Yes. When that institution is admitted to grant in aid, Mr.
The institution is admitted to grant in 93, madam. 28/9/93. That your lordship will find.
Before bitbidi. Thereafter, the management has sent in a proposal to admit the petitioner post to grant in aid. Same has not been considered. They have sent in a repeated proposal. What is that even? Pursuant to that proposal sent by the college, the joint director has submitted in a report void annexure ZK on 28/8/2023. Thereafter, the impugn endorsement has been issued void annexure A, thereby rejected of the request for the petitioner post for admitting the grant in aid on the ground that there is no student strength as on 2023 and 2024. Learned government advocate has submitted that has filed a statement of objection, has contended that. Where is that this thing, Mr. Annexure? ಅಲ್ಲ ಯಾವ ಪ್ಯಾರಾದಲ್ಲಿ ಹೇಳಿದಿರಾ he is not qualified ಅಂತ?
Annexure R7 ಅಲ್ಲಿ page number 20. 22nd paragraph.
R7.
Yes, sir.
ಏನಂತ ಹೇಳಿದಿರಿ?
ಅದಕ್ಕೆ ಸುಜಯ್ ಇವರು ಇಂಗ್ಲಿಷ್ ಉಪನ್ಯಾಸಕರಿಗೆ ಆಯ್ಕೆ ಮಾಡಿರ್ತಾರೆ. ದಿನಾಂಕ 24/6/90 ಪತ್ರಿಕೆ ಪ್ರಕಟಣೆ ನೀಡುತ್ತಾರೆ. ಸಂದರ್ಶನದಲ್ಲಿ ಇವರನ್ನು ಆಯ್ಕೆ ಮಾಡಿ ದಿನಾಂಕ 3/6/94ರಂದು ನೇಮಕಾತಿ ಆದೇಶ ನೀಡುತ್ತಾರೆ. ಸದರಿ ಇವರು ದಿನಾಂಕ 4/7/90ಕ್ಕೆ ಹಾಜರಾಗಿರ್ತಾರೆ. ಇವರ ಜನ್ಮ ದಿನಾಂಕ ಸೋಸೋ ಇರ್ತದೆ. ಇವರು ಇಂಗ್ಲಿಷ್ ವಿಷಯದಲ್ಲಿ ಸ್ನಾತಕೋತ್ತರ ಪದವಿಯಲ್ಲಿ ಸಾಮಾನ್ಯ ದರ್ಜೆಯಲ್ಲಿ ಪಾಸ್ ಮಾಡಿರ್ತಾರೆ. ನಿಗದಿತ ವಿದ್ಯಾರ್ಥಿ ಹೊಂದಿರದ ಕಾರಣ ಅಂದು ಇವರ ನೇಮಕಾತಿಯನ್ನು ಅನುಮೋದಿಸಿರುವುದಿಲ್ಲ.
Contended that petitioner was appointment of the petitioner was not in accordance with law and he was not qualified to appoint as an English teacher in the respondent institution. I have perused that.
But department was approved my appointment in 2015, my annexure. Yeah, this is my.
Except stating that there was no student strength in the college, therefore proposal has been rejected. In the impugn annexure A as not forthcoming regarding that eligibility or the appointment of the petitioner.
One small submission, page number 93 ಒಳಗೆ DD himself has taken.
Yes, therefore.
ಅಲ್ಲ ಈಗ ಇವರು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರಲ್ಲ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಇಲ್ಲ ಅಂತ ಅದಕ್ಕೊಂದು ಸ್ಮಾಲ್ ಉತ್ತರ annexure X ಅಲ್ಲಿ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಮಾಡಿರೋ ಆರ್ಡರ್ ಅಲ್ಲಿ annexure X.
Yes, the impugn order is passed without application of mind and it's not in a speaking order. On this ground alone, the order has to be quashed. Accordingly, impure order annexure A is quashed. The respondent is directed to reconsider that proposal sent by that management
And the
party
petitioner,
madidira.
it is open for the petitioner. It is open for the petitioner to submit the representation because qualification ಹೇಳ್ತಾರಲ್ಲ ಅದಕ್ಕೆ I am
Yes.
open to.
Matter request for reconsideration. Accordingly, impure order annexure is quashed. The petitioner is permitted to submit additional representation enclosing all necessary documents to establish his case within 2 weeks from date of receipt of the copy of this order. Thereafter, respondent who has to consider? Kala Shikshakare. Respondent number.
First respondent and second director melo. First and second respondent. First and fourth respondent.
Respondent number 3 and 4. 3 to 5 are directed to consider that proposal sent by that second respondent management and also additional representation submitted by the petitioner along with the records in accordance with law and take appropriate decision within 2 weeks from date of submitting of the additional representation to the petitioner. Yes.
Public.
Lots of small submission, my lords. Serial number 47, my lords. And for the R1 and R2, senior is not well, my lords. So short date might be fixed.
Petitioner, Lordship may kindly fix a date.
Yes, he is not well. Yes.
I'm not objecting.
Yes, yes.
Lordship may kindly fix a date.
A short date only might be fixed.
11th. At the request of respondent, leave this matter on 11th.
Still number 40, interim order to be extended.
40?
Interim order to be
Interim order to be extended, yes.
My lord, in the serial number 43, I'll take a notice for R2 in the name of Siddharth Babura.
43 ಏನಾಯ್ತು?
My lord, I am for respondent number 1 in that matter, my lord.
Who is petitioner?
Kekar Badikar.
Yes. Vijay Raghav sir, which case you have to take notice?
43.
43 for whom?
R2.
R2, nobody is appeared. You
Yes,
want
my
to
lord,
take
I'll take a notice on
Oh, what's their name?
Siddharth Babura.
Siddharth Baburao is undertake to appear for respondent number 2. Office is directed to show his name.
One submission, my lord. In R1 has been retired, my lord, and we are filing the retirement memo for the same, my lord.
Who has retired?
R1, my lord, headmaster.
Retired.
Yes, my lord. And we are also filing a memo for undertaking retirement from appearing for respondent number 1.
No, they have to. Who is that? Successor has to be come on record.
Yes, my lord, but we wanted to file retirement for that respondent number 1.
Have you filed it? You filed it in that counter?
Yes, my lord.
Yes. Show the name of so and so.
Undertake to file wakalat for R6, my lord.
You do it. But you do it. File it in that counter.
Yes, ma'am.
Yes. That this matter on 11th. Yes.
That serial number 49, my lord.
49.
49 dispatch, my lord, matter needs to be heard. I need to prepare a synopsis and list of.
What is this matter?
Guest lecturers, my lord, was working for a
Yes,
more than
21.
20 guest faculty. Though.
Yes.
So, any date may kindly be fixed, my lord.
17th madam.
Other 59 also may kindly clubbed along with 49, my lord. 59, that same matter, my lord. 19097.
59, you are there.
Yes, my lord. I am same petition, my lord.
Yes,
It has to be clubbed
59.
along with that.
59 is also called along with that 49.
Yes, my lord.
Yes.
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 And 53, my lord, time may be granted, my lord. And
I appear for petition is case.
respondent.
Yes, mister. What is this matter?
That-
You have time? Yes.
Yes.
At the request of counsel for the respondent.
Date may be-
Is this matter up to 2 weeks? 16th.
Agli, sir.
Yes.
16th March.
Now, serial number 55, my lords. Now, serial number 55, may I request for short time, my lords?
Who is the petitioner?
Matter is under consideration. I am for R4, my lords.
It is under consideration. Yes. at
Yes,
the
my
request
lords.
of-
We will file the necessary papers, my lords.
Yes, leave this matter on 11th. Yes. Yes.
11/3, my lords. Yes, I am grateful.
Yes. 55, they are under the consideration. They are under
Yes, yes,
consideration
yes.
in your favor, Mr. What is the date ಕೊಟ್ಟಿದ್ದೀರಿ?
Yes.
Yes.
I am grateful. I am grateful.
Do something and say that earlier this was not to be applied.
Hmm.
I made a representation against that, achieving for consideration of.
Now what you want now? You want? Hmm.
Your Lordship.
Yes. Who has to file? Government or? ನಿಮ್ ಪರವಾಗಿ ಅವರೇ ಕೇಳಕ್ ಶುರು ಮಾಡಿದಾರೆ, ಅವರಿಗೂ ಬೇಜಾರಾಗುತ್ತೆ. ಅಬ್ಜೆಕ್ಷನ್ ನೀವು ಹಾಕೋದಿಲ್ಲ ಅಂತ ಗೊತ್ತಾ. Don't go to the stage, mister. You should be ready in that all matter. Yes. Yes, 9th. Yes, at the request of government advocate, list this matter on 9th. Not early, mister. Yeah, let us see, they are settling that matter. Yes.
Yes, my lord. Similarly situated people are already given the pension.
Yes. 60? Hmm. You are appearing for? Petitioner. Yes, Mr. Rajendra. At the request of counsel for the petitioner, release this matter. ಅದು ಅವ್ರಿಗೆ ಬಿಟ್ಟಿದ್ದು. This is a first practice saying that petitioner is asking. We even court cannot insist them if it is necessary. Otherwise, if they are not filed, they are admitted that what is the pleading in that petition. Yes.
Your Lordship,
Is this
serial
matter-
number 51.
10th. Yes.
Your Lordship, serial number 51. Council prays time to file a statement of objections, Your Lordship.
51.
51 and 52.
Yes.
My lords, I appear for the petitioner in this case. Let them file, my lords. In the meanwhile, a date may be fixed. It's a short
Yes,
question
you
of
are-
mandamus, my lords.
It's 2 weeks of time, Your Lordships.
R5 and 6.
Yes, Your Lordships.
At the
R4
request
and
of
R5.
counsel for R5 and 6 as a last chance, 2 weeks time is granted to file objection. Release this matter on 10th. Yes.
Grateful.
ಇದೆ ಬಟ್ ಇವತ್ತಿಲ್ಲ. ಅದೇ ನಿಮ್ಮನ್ನ ನೋಡಿದ ತಕ್ಷಣ ನನಗೆ ಬೇಜಾರು. 2:30 ಬೇರೆ ಮಾಡ್ತಾರೆ ಪಾಠ. ವೇಟ್ ಮಾಡಿ ನೋಡೋಣ ಅದೇನಾದ್ರು ಸರ್. ಇಲ್ಲ ಆಗಿಲ್ಲ ಸರ್.
ಸರ್ 55 ಯಾವತ್ತು 11ನೇ ತಾರೀಕು ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್. 55
11 30 ಅದೆಲ್ಲ ಆಗ ಯಾವ ಕಾಲ ಆಯ್ತ್ರಿ? 31 32 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. ಪಾಸ್ ಓವರ್ ನೋಡೋಣ, ಮಧ್ಯಾಹ್ನ ಬೇರೆ ಇದೆ ನೋಡೋಣ. 2:30 ಹಂಗ ಗೊತ್ತಾಗಲ್ಲ. 2:30 ಇದೆ ಸರ್. 2:30 ಇವಾಗ ತೆಗಿಯೋದೇ ಕಷ್ಟ.
ನಿನ್ನೆ ಮೊನ್ನೆ ಇತ್ತು ನಿನ್ನೆ
Same year solution ಅಲ್ಲ ನೀವು ಸಿವಿಲ್ ಸರ್ವಿಸ್ ಇವ್ರು ಏನಪ್ಪ ಪ್ರೊಫೆಸರ್ಸ್ ಎಲ್ಲ ಅದು ಒಂದ್ಸಲ ಪರವಾಗಿ ಮತ್ತೆ ಮಾಡಬಾರ್ದು ಅಂತ ನಿಮ್ಗೆ ಹೇಳು ಸರ್ ಅದು ನನಗೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ ಫಸ್ಟ್ ಡ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ ಆಫ್ ಸಿವಿಲ್ ಸರ್ವೆಂಟ್ will be
ಸಿಟ್ಟಿಂಗ್ ನ್ಯೂಸ್ ಪ್ರಕಾರ ಇದು RSA ಅಪ್ ಟು 2012 ಬರುತ್ತಲ್ಲ, ಯಾವ ದಿನ ಪೋಸ್ಟ್ ಆಗುತ್ತೆ? ಎವ್ರಿ ಫ್ರೈಡೆ. ಇವಾಗ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡ್ಬೇಕಾ? ಮೂವ್ ಮಾಡಿದ್ರೆ ಥರ್ಸ್ಡೇ ಮೂವ್ ಮಾಡಿದ್ರೆ ಫ್ರೈಡೆ ಪೋಸ್ಟ್. ಮಾರ್ಚ್ 4. ಹೇಗೆ ಕೋರ್ಟ್ ಮುಂದೆ ಬರ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಇದು ಮೆಮೊ ಫೈನಲ್ ಇಯರ್. ಸೊ ಇವಾಗ ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ರೆ
Sorry, sir.
ಸರ್ ಹೇಳಿ. ಅದೇ ವೇದ ವಯಸ್ಸ ಶಣ ಹಾಕೋ ಪಾಪ ಬಂದ ಅದಕ್ಕೆ ಇದು 4-5 ದಿವಸ ಪಾಪ ಮುಖ ನೋಡಕ್ಕಾಗಲ್ಲ. ಯಾವ್ದು ರಿಪೀಟ್ ಕೊಟ್ಟಿಲ್ಲಲ್ಲ. ಒಂದು ಬೀಂಗ್ ಸ್ಪೋಕನ್ ಟು ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ರಲ್ಲ, ಆ ಮೇಡಮ್ ಕೇಳ್ಕೊಳ್ಳಿ ಏನ್ ಹೇಳಿದ್ರು ಸಾಹೇಬ್ರು ಅಂತ. ಚೇಂಬರ್ ಕರೆಕ್ಷನ್ ಆದ್ರೆ ಬೇಡ, ನಮ್ಮ ತಲೆನೋವಿಲ್ಲ. ಅದೇ ಕೆಮಿಸ್ಟ್ರಿ ಬದಲು ಎಲ್ಲ ಕಡೆ ಕೆಮಿಸ್ಟ್ರಿ ಅಂತ ಬಂದ್ಬಿಟ್ಟಿದೆ, ಬಯಾಲಜಿ ಅಂತ ಆಗ್ಬೇಕು. ಒಂದು ನೋಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. ಸಾಕಾಗುತ್ತೆ. ಅದೇ ಪಾಪ ಮಕ್ಕ ಇಷ್ಟ ಆಗೋಯ್ತು ಪಾಪ, ನನಗೆ ಬೇಜಾರಾಗುತ್ತೆ. ಮಕ್ಕ ಇಷ್ಟ ಆಗೋಯ್ತು, ನೋಡಕ್ಕಾಗ್ತಾ ಇಲ್ಲ.
ಏನ್ರಿ 1 ಗಂಟೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದಂತ ನೀವು ರಿಟ್ ನೀವು ಆರಕ್ಕಗಳು ನಡೆಸಿದ್ಮೇಲೆ ಆದ್ರೆ ಎಲ್ಲ ಆರಕ್ಕ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋರು ಇದ್ದಾರೆ ಮಾಡಿ ಎಲ್ಲ
ಶಂಕರ್ ಸರ್ ಎಂದೂ ಇಲ್ಲ.
ಹತ್ತು ಮಿನಿಟ್ ಬೇಡ ಅಂತ ಬಟ್ ನೋಡೋಣ ಆ ಕಡೆ ಈ ಕಡೆ ಆಗುತ್ತೆ. ನೀವು ಹೋಗ್ತೀರಾ ಅದು ಇವಾಗ ನೀವು
ಅಭ್ಯಂತರ ಇಲ್ಲ ರವಿಶಂಕರ್ ಸರ್ ಅಂತ. ರವಿಶಂಕರ್ ಸರ್ ನಮ್ಮ objection ಕೊಡ್ತೇವೆ. ಜಾಸ್ತಿ ಇಲ್ಲ ಬೇಗ ಬರ್ತೀರಾ?
Okay. Judgment, huh? Why are you giving this? Name is not reflected. Somebody's name is reflected. They have not followed it. At least some order that they asked. Go for the petition. Petition here. Babapura, primary, agriculture. Bank operator. 2015. We were in college. Date is given on 11/3, sir. It's the next date given. I don't know the contents of the order, sir. I'll just make a mention.
Because we should make sure that the stay is not vacated.
Yes.
So that's the senior qualified expected.
ಇದೇ ನಿಮಿಷ ನೀವು ಮತ್ತೆ ಶುರುವಾಗ್ತೀರಾ ಏನಾದ್ರು ಮಾತ್ರ ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೇ ಇಲ್ಲ, ಏನು ಸಿಗ್ಲಿಲ್ಲ ನೀವೇನಾದ್ರು ಬೇರೆ ಕೇಸ್ ಬೇಕು ಅದಕ್ಕೆ ನಾನು ಅದಕ್ಕೆ ಎಲ್ಲಿ ಕೊಡ್ತೀರ ಅಂತ ಅದನ್ನ ಅದಕ್ಕೆ
Milods, serial number 24, Milods.
Yes.
Milods, my name may kindly be reflected for the petitioners, Milods. Milods, the council.
Huh? It's already urgent. Manju Sada. 24.
Milods, the previous council, Milods, he's been designated, hence his name was not reflecting, Milods. Milods, I appeared previously. I appeared along with the senior council, Milods.
Yes.
Now it appears some orders have been passed, Milods. It may kindly be taken up on Friday, Milods. I'll keep.
What order has, you have not passed any order.
Please, Milods.
They're urgent that matter. That's all.
Please, Milods.
Somebody has represented. ಯಾರು ಮಾಡಲಿಲ್ಲ ಬಂದಿದ್ದಲ್ಲ ಯಾರು ಬಂದಿರಲಿಲ್ಲ that IA filed by the respondent is dismissed not for vacating 2015.
Please, Milods. Let's.
Yes.
Obliged.
230 matter. Serial number 75, Samir Sharma for petitioner, Sutika Raghavan.
Yes.
For the petition, on the last occasion, your lordships had directed me to place that official memorandum relied upon in the division bench judgment.
Yes.
And I'm just placing that official memorandum.
Yes.
I've placed on record the official memorandum in that case.
Yes.
Where the system of the calculation of post
Yes.
changed from vacancy based to post based.
Yes.
This was the official memorandum. Paragraph 1, they rely upon the earlier circulars.
Yes.
Where it was specifically vacancy based.
Yes.
Then by a policy decision, government issues an official memorandum in the name of the governor.
No, that's I think in the order itself there is.
Yes, that's the one.
I have an answer to both of it.
Yes, Malad, second one is the R.K. Sabharwal judgment your lordships had asked. And the last, Malad, the internal page number 14
Yes.
is the SLP that is pending against the division bench judgment of Kaikashan. Notice is issued.
Yes.
And the matter is posted for hearing.
Yes.
That's
Lords, as I can understand, my lords, there are only two contentions which has been raised
Yes.
on behalf of the petitioners.
Yes.
Lords, the first and foremost contention, as I can understand, is
Yes.
that the rules not specifically contemplating the mode or method by virtue of which the ratio has to be operated. If at all anything has to be done, it should be by means of an amendment to the rules. I is relied upon the judgment to say that the rules, if it is silent, then any clarification should also be by means of a rules, if I have understood.
They said there is no ambiguity in the rules.
Lords, so far as
In that rules, it says in that ratio has to be maintained in that
At the time of.
at the time of recruitment.
Lords,
Not
that's-
on that. That is what they are arguing.
yes, I just refer to that. Now, the amendment of the rules, in other words, an amendment of the rules is what brings about the clarification to what is otherwise contained in the rule, which we are now referring to. Lords, may I just take your lordships, my lords, to the rule.
Yes. It is marked as annexure.
Yes,
Page
number
130. 53.
page number 53.
50.
Lords, I'll just go
Yes.
to rule 7.
Yes.
Lords, because there is something which is conspicuous which I wanted to point out your.
Yes.
Lords, rule 7.
Yes.
Mode of recruitment.
Yes.
Recruitment a post or class of post shall be made by the Chief Justice as enumerated in Schedule 3 to these rules.
Yes.
Provided that for the purpose of direct recruitment to various categories in the establishment, High Court in accordance with these rules, reservation shall be provided, so on and so forth. I will not trouble your lordships.
Yes.
Promotion to post carrying minimum pay up to achieve so and so. My lords, this is also not applicable. I just read these rules and complete it.
Yes.
Then the next third proviso provided further that for the purpose of direct recruitment to various categories of posts established in the High Court accordance with these rules, then provided further that the Chief Justice shall have the powers to amend the method of recruitment from time to time by a general or a special order. Just mark that, my lords. Your lordships will see that. So, mode of recruitment and the rules
Yes.
is subject to a general or a specific order by the Chief Justice.
Yes.
If it is there, it is there, finish, it's over of it. It's the end of it, because Rule 7 gives a long hand to the Honorable Chief Justice on the administrative side, provided further that the Chief Justice shall have the powers to amend the method of recruitment from time to time by a general or a special order. That's all what is required. So to say that there is a requirement of an amendment of the rules militates against Rule 7. Schedule 3 is framed under Rule 7. Now, further provided, notwithstanding anything otherwise contained in these rules, the Chief Justice, any exigency in the High Court in the order to fill up vacancies in Group D cadre may appoint suitable. I will not trouble your lordships on this. Lords, with this, if your lordships were to go to the schedule,
Yes.
so what has been argued, my lords, is beyond the scope of what is contained in Rule 7.
Yes.
Schedule 3 commences from page number 50 as referable to Rule 7.
Yes.
That is mode of recruitment.
Yes.
Now, mode of recruitment, if your lordships were to see, in that notes, I just marked it. I'll just point out one. Your lordships may kindly come to page number 53.
Yes.
By promotion,
Yes.
on the basis of seniority come merit from the cadres of section officers and officers in the ratio of 2:1, provided that they have completed 2 years of satisfactory service in the feeder cadre.
Yes.
Lords, neither under Rule 7 nor under Clause 6 of Schedule 3,
Yes.
there is a contemplation of applicability of the roster points.
Yes. Correct.
it is not in accordance with the roster. It doesn't say that it is by means of the ratio of 2:1 in accordance with the roster. No. Lord, there are two things. If there are three things which can be said, let us assume, Lord, that this is the rule. It can say based on roster. It can say based on vacancy. It can say based on cadre strength. All the three is conspicuously absent. Mode of recruitment, if it is not based on roster, then Bhatnagar goes out. If it is not based on vacancy, Tiwari goes out. I'll just bring to your lordship's notice both these two cases dealt, Bhatnagar's case very specifically dealt with the situation of applicability of a roster only, not with reference to whether there is a power or authority in the concerned authority for the purposes of determining the mode of selection or mode of appointment. At the time when the appointment is being made was never the question which was considered. Bhatnagar's case, it so happened that 75% to the promotees and 25% to the direct recruits was all along based on the roster points. So now the question came about 3:1. That's essentially the roster. So first three roster points will come to the promotees. Fourth one will come to the direct recruit. So now if this is the kind of roster which has been applied, whether it can be modified at a later stage. That's essentially the case which came up before. But that's not the matter before your lordships. The case here is that mode of recruitment as provided in terms of Rule 7 and Clause 6 of Schedule 3 neither specifies cadre strength, nor specifies vacancy, nor specifies applicability of any roster points. It also says that this mode can always be subject to the general or special orders of the Honorable Chief Justice. Now, my lords, on facts, if I were to just take your lordships to that intimation, which is under challenge, which is at page 26.
Yes.
May I just, lordships, may kindly have a look at page 27. After that, italics.
Yes.
The said resolution of the Honorable High Court Staff Committee is approved by the Honorable Chief Justice.
Yes.
In view of the above resolution and as approved by the Honorable Chief Justice, it is notified so and so, so and so.
Yes.
Notice here, the rules are completely different from the ones which we find in the other rules because the prerogative and the plenary jurisdiction of regulating the service conditions rests in the High Court, particularly with the Chief Justice. Not like the government where there are rules framed and the rules cannot be amended because there is a requirement. We operate in a different sphere altogether. So they can't equate the principles as applicable to the government servants and the civil servants as applicable in respect of the employees of the High Court. We stand on a different footing. We have a different hierarchy altogether. And here the hierarchy is that if the Honorable Chief Justice says this should be the one, it should be the one. He is the master of the roster. He is also the master of the regulations which is required to regulate the terms and conditions of service of even the employees of the High Court. That's how we function. Now that is the reason why I read Rule 7 to your lordships, that if this is the scenario, then the rule itself provides, Rule 7 itself provides that any method of recruitment is subject to general or special order of the Honorable Chief Justice. We have placed the general or special order of the Honorable Chief Justice. And what is that? It specifically dealt with the method of recruitment of the assistant registrars from two different cadres by means of promotion as based on cadre strength. That is the general order, or rather it is the special order by virtue of which this has been clarified. Now to buttress this further, two judgments, my lords. One is the one which I have already read to your lordships. The division bench said, if the recruitment rules is silent, which is not dealt with in Bhatnagar's case, nor in Tiwari's case, if the rule is silent as to the method of recruitment, as to when it should be applied, whether it is vacancy based or cadre strength based, then it will be open for the authority concerned to ensure that this can be done by mere issuance of clarification. Because if the rule says vacancy based, clarification says it is cadre strength based, then it militates against the rule. But if the rule is silent and the clarification is given, there is nothing against which it militates. It is merely clarificatory in nature, which is not requiring any amendment to the rules, is the view taken. I have already read to that portion to your lordships, milords. I will not trouble your lordships on that. Further, milords, a question of similar kind came up before your lordships. Of course, it's in a context of a rule which was proposed to be amended, which was approved by the Honorable Chief Justice. It went to the state, and the state had not accepted it. So that was the question which came before the division bench of this Honorable Court. While referring to Vohra's case, which is milords, by 3 judges bench of the Honorable Supreme Court, may I just take your lordships, milords, to Kotidiratna. Kodi. Yes. This just amplified submission, milords. Apart from Rule 7 giving him complete powers to regulate the method of recruitment under Rule 7, the proviso which I have read to your lordships, this goes a step further. It's an amplified statement which I am making in terms of the powers of the Honorable Chief Justice. Yes. Para 26. Para 25 I'll read and then go to para 26.
Yes.
The learned government advocate, sorry, milords, I just. Milords, this is at print page number 31.
Yes.
Or a copy kotra?
Yes, yes.
The learned government advocate appearing for the contesting respondent and the state government tried to substantiate the letter or recommendation sent by the Honorable Chief Justice is only recommendatory in nature, and the same is not supported by the rules, which is required to be framed by the Honorable Chief Justice as contemplated under 229(2) of the Constitution. In the absence of the same, it is not possible for the government to recommend the same to the cabinet for acceptance. That's more or less like the statement which was made. However, we are not inclined to accept the aforesaid submission made on behalf of the state for the reason that in similar situation, the ratio laid down by the latter judgment of the Gujarat High Court, which was referring following the full bench decision of the Bombay High Court in the matter of Chandrakant Saharam, referred to supra, will have direct bearing on the facts on the hand. In that view of the matter, submission of the government advocate that recommendation sent by the Chief Justice of Karnataka on 6/1 is not accompanied by rules framed thereunder does not stand to reason. In fact, the reading of the recommendation clearly indicates that there is application of mind by the Honorable Chief Justice in sending the recommendation giving reasons for providing different pay scale to the employees of the High Court, taking into consideration the nature of work, responsibilities, long working hours rendered by them. Said letter is sufficient to be taken as a recommendation made by proper application of mind of the Honorable Chief Justice. In the light of the aforesaid two decisions of the Bombay High Court and Gujarat High Court, it is needless to say that recommendatory letter with model pay scale attached thereto by way of annexure in itself is to be taken as a rule. And the government is required to act on the same. In fact, the full bench of Apex Court in the case of Vohra reported in so and so while considering the powers as has stated the supra. Milords, that's what is reiterated, is what is observed, milords, by the Honorable Division Bench. Milords, just an amplification, milords, that this is how even the Division Bench of this Honorable Court has recognized that the moment there is such an application of mind which is apparent from the records, if that is shown before the court, that itself operates as a rule. Of course, I don't want to, milords, labor myself on that. So now what is that which is happening? It is very simple. The division bench said that it is cadre strength based, has to be applied. That's what happens in such circumstances, that because there is nothing which will be 2:1 is the ratio, nobody is challenged the rules. Now it doesn't say vacancy based, there is no applicability of roster. If these two is conspicuously absent, they cannot say that it should be applied by applying the Bhatnagar's case. That's essentially what they are telling. I'll read that portion of Bhatnagar's case. Now, if these two is not applicable, proviso specifically says that the Chief Justice is entitled to do anything with reference to this method of recruitment. Application of mind is reflected because the staff committee is consisting of the judges of this Honorable Court and have applied their mind and said this is what, and it's approved by the Honorable Chief Justice. It ends the matter. There cannot be a technical objection, official memorandum is there, amendment of a rule. Why does all these things come? That's the end of it. That's how, my lords, the law, insofar as the service regulations of this honorable court is regulated. Lords, this is number one. Can I just take your lordships to that Bhatnagar's case? What fell for consideration in Bhatnagar's case?
Yes.
Lords, para 8, questions for points for our determination.
Yes.
Question number 2. Even if the roster operates on vacancies in such a way
Yes.
that from the very inception of the roster,
Yes.
vacancies on the first 3 roster points will go to promotees and the vacancy of the 4th roster point will go to direct recruitment. Similarly, in future for further vacancies, whether the disputed 16th vacancy should go to the direct recruit or a promotee. This question no. But now there, it was more than certain that this is what they are going to do. Roster points are going to be made applicable 3:1. First 3 is made applicable only in respect of the promotees. Fourth one to the direct recruit. So 16th one should automatically come to the direct recruit. That was the question. A question never cropped up as to whether there should be a requirement of the vacancy the recruitment to be based on the cadre strength by giving them proportionate representations was never fallen for consideration. And if your lordships were to see the discussion,
Yes.
lords, at page number 341,
Yes.
placitum H, bottom of the page. Therefore,
Yes.
the roster for 3 promotees and 1 direct recruit is to be continued every time vacancy arises, and there is no question of filling up a vacancy arising out of a recruitment of a direct recruit by a direct recruit on retirement or vacancy of a promotee by a promotee. Consequently, the question of rotating the vacancies as posts or treating the posts mentioned in the rules of recruitment as necessarily referable to total posts in the cadre at a given point of time in the light of Sabharwal, therefore cannot survive for the case of quota rule between direct recruits and promotees. Same is to be judged on the touchstone of 16(1) and the statutory rules governing the recruitment to the post of professor constituting so and so, not on the basis of 16(4). Division bench in the impugned judgment, I just stop here. So the question here was framed and answered whether the 3:1 and the 16th roster to be made applicable in respect of the direct recruit is correct or not. So now at that stage they said, as and when the vacancies are arising, you will have to compute the roster points, not on the basis of the total cadre strength. That is all what was said, my lords, in Bhatnagar's case. Yes. Now your lords may kindly have a look at K.K. Tiwari's case. But I think they have given the judgment of Allahabad High Court.
Yes.
Yeah. Yeah. Lords, Allahabad High Court judgment, if your lordships is having in your lordships hands,
Yes.
kindly have a look at page number 3, which is end of paragraph number 3.
Allahabad.
K.K. Tiwari. Yeah. I'll just read this and I think I just pass on this, my lords. If
Yes.
I just for ready reference, I'll just pass on my copy, my lords, and then
Let the-
just one paragraph I want to read.
Yes, it is there. Yes.
Please. Lords, may kindly have a look at page number 3,
Yes.
which is essentially the end of paragraph number 3.
Your lordships have the Allahabad High Court.
Yes. Yes.
Correct. Other rule 7 is there.
Yes.
Future maintenance of service. The lordship gets it, my lords.
Yes.
In the beginning of the page,
Yes.
page 3.
Page
Future maintenance of the service. After the commencement of these rules, lordships may kindly mark the next phrase. The vacancies
No, where you are reading?
My lords, rule 7, my lords, can I just pass this on, my lords,
No,
immediately?
it's there.
Just above para
Para
4.
3, just above para 4.
Yes, 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 yes.
About 4 lines. After commencement of these rules, vacancies arising, excluding the vacancies for arms so and so, so and so, shall be filled in the manner provided under 2, 3 and 4. Vacancies filling up.
Yes.
So that's the reason, my lords, why I read to your lordships the manner in which our rules have been framed. It is very explicit and clear.
Yes.
Because rule 7, if it is juxtaposed with the rule 7 of Karnataka High Court rules, it is completely different. So Tiwari's case will not be of any avail to them.
Yes.
So therefore, my lords, my respectful submission is that this is a decision taken by a committee approved by the Chief Justice,
Yes.
which qualifies itself as a rule. And if the rule is silent, no roster, no cadastre, then it is always permissible to give such clarification. That's the second. What is the other argument which they have got to answer, my lords, on minutes? Because the other argument which was canvassed by them is representation which was given by the section officers has been rejected. If the section officers were aggrieved, they would have come before the court if their representations are. But what the High Court wanted was to set its house right in the manner in which the quota system of 2:1 has to be applied, which has been done. So it's the end of the matter. That's my respectful submission. Because 7 is a method of recruitment. Recruitment to a post or class of post shall be made by Chief Justice as enumerated on Schedule 3. It says that, yes. Therefore, my lords, I don't think that there is anything which requires your lordship's consideration for intelligence in the matter.
Yes.
Just 5 minutes, my lords. Let your lordships.
Can I seek your lordship's excuse?
Yes,
Since your lordships have rule 7 proviso 3, my lords.
Yes.
That's the last thing that was read out, my lords. My lords, can I just read that provision again, my lords?
Which one?
Rule 7 subclause 3, that was page 31.
That our High Court.
Yes, my lords. High Court rules. My lords, it was contended that the Chief Justice has the power, my lords.
Yes. Page?
Page 31, my lords.
Yes. Yes.
Proviso 3, that's second proviso, my lords.
Yes.
Provided further, the Chief Justice shall have powers to amend method of recruitment from time to time by a general or special order. This is under Rule 7. Rule 7 talks of method of recruitment.
Yes.
Chief Justice has the power to amend. No doubt about it, my lords. We are not questioning the power of the Chief Justice.
Yes.
But today their argument is slightly different, that this intimation amends the recruitment rules. My lords, earlier they said that please consider the submissions of the High Court, my lords.
Yes.
One, it says that this is only clarifies the position. If it is clarificatory in nature, it can't be amended. Please have a look at that. Chief Justice shall have the power to amend the method of recruitment from time to time by a general or special order. It is nobody's case, my lords, that the rules are amended. They only say, my lords, that the method of working this 2:1 we are going to change.
No, that even.
Yes.
What should be done for amending the rules? It says that only general or special order.
Method of amending the rules of recruitment.
Yes.
The rules of recruitment are not at all amended, my lords. If they said from 2:1 we are changing it to 3:1, my lords, that is an amendment of the rules of recruitment.
No, they are saying that rules of recruitment.
Yes, can be amended by the Chief Justice.
As silent about that, how it has to be operated.
Yes.
By addition of this amendment, they are saying that how it has to be.
There is no amendment.
No, that special order or a general order. Therefore, I am asking that what should be that special order or general order?
Should be. Yes, can I just read this?
When it is, I'll pass through that full court. It is in a.
Yes,
of that High Court.
Yes, it has to pass the muster of the full court placed before the Chief Justice. Chief Justice has to pass an order saying the rules. Can I just show how the rules were amended earlier, my lords?
Yes.
That would probably, my lords. Would your lordship just have the memo, my lords, additional documents which I have placed for your lordship's consideration, my lords?
Yes.
My lords, internal page number 1 was the original rules. My lords, this is an intimation today, my lords, to stretch it to say rules of recruitment are amended, my lords, is quite.
Yes.
Page number 1 of the additional memo.
Yes.
My lords, that is the original recruitment rules, my lords.
Yes.
Your lordships will find the amendment to the recruitment rules at page 43.
Yes.
of that memo, my lords. It is done by an order of the Chief Justice, published in the official gazette. Even if it is a special order, my lords, it requires to be published in the gazette of the state.
Yes.
Please have a look at page 43, my lords.
Yes.
These rules may be called as the High Court Service Conditions and Service Recruitment Amendment Rules 2009.
Yes.
This is the manner and the method in which, my lords, page 44, my lords, is insofar as Assistant Registrar Protocol.
Yes.
This is the amendment of 2009. Now, please come to the 2013 amendment rules, my lords, which your lordships will find at page number 46. My lords, 45, your lordships will see, my lords. Memo of document, just the next page.
Yes.
Page 45, your lordships will see, my lords.
Yes.
By order of the Honorable Chief Justice, so and so.
Yes.
Now, my lords, this was the amendment which was published in the official gazette.
Yes.
Now, please come to the 2013 amendment, my lords, which your lordships will find in the page 75 of the original writ petition. I'm sorry, my lord, your lordships will have to. Page 75 of the original writ petition.
Yes.
Amendment of 2013, which is standing as on today.
Yes. 75.
Yes.
Yes.
Can I read the preamble, my lords?
Yes.
In exercise of powers conferred by Article 229, 1 and 2 of the Constitution, read with Rules 7 and 8 of the High Court Service Condition, so and so Rules 1973, and Rule 4A of the High Court Administrative Expenditure Rule, so and so, and all other powers in it, the Honorable Chief Justice makes the following rules to amend the High Court of Karnataka Service Conditions of Service and Recruitment Rules 1973. Title is called as the amendment, which is published in the official gazette.
Yes.
Now, my lords, today, my lords, to contend that Chief Justice has the power, therefore, in response to the representation, the intimation given is an amendment to the recruitment rules, my lords, might be quite devastating of the rule itself, because Rule 7 specifically says the Chief Justice should amend the method of recruitment.
Yes.
Which has to be, the manner in which it has to be amended, my lords, is there in the subsequent rules, which say that the rules will have to be, draft rules will have to be published, objections called, and then, my lords, final rules published in the official gazette. Therefore, my lords, to rely upon 7th, 3rd proviso to say this is amendment, my lords, might not be the correct distinction, my lords. My lord, the second point that was raised by the learned senior counsel, my lord, was the distinction between Bhatnagar and this case.
Yes.
My lord, would your lordship just come? I'm sorry, my lord. Bhatnagar specifically did not talk about any roster point. Bhatnagar's judgment, my lord, which I have relied upon.
Yes.
My lord, Bhatnagar's judgment.
Yes.
Paragraph number 3, my lords, I have given the method of appointment.
Yes.
My lord, 75% by promotion, internal page 336.
Yes.
Internal page 336, para 3.
Yes.
Method of appointment, 75% by promotion, 25% by direct recruitment. At the end of paragraph 4,
Yes.
75-25 is calculated as 3:1.
Yes.
As in this case, 2:1.
Yes.
Now, my lords, 2:1 also operates in the same way as 3:1.
Yes.
Two section officers, one. Therefore, my lords, Bhatnagar was never dealing with roster point, but it was clarified, my lords. Would your lordships come to that? I've already read this to your lordships, but this was in distinction to R.K. Sabharwal 16.4 and 16.1, and your lordships will find the relevant portion, my lords, at internal page number 346, my lords. That is,
Yes. Yes.
I'm sorry, my lords. Can I take your lordships to 342, my lords?
Yes.
From the 341 bottom last 3 sentences.
Yes.
341 bottom onwards from Placitum H.
Yes.
Therefore, the roster for 3 promotees and 1 direct recruit is to be continued every time a vacancy arises, and there is no question of filling up vacancy arising out of retirement of a direct recruit by a direct recruit or on retirement of vacancy by a promotee by a. Consequently, question of rotating vacancies as posts
Yes.
or for treating the post method mentioned in the rules of recruitment as necessarily referable to the total posts in the cadre at a given point of time in the light of Sabharwal judgment, therefore cannot survive for in the case of quota between direct recruitees and promotees, the same to be judged on the touchstone of 16(1) and statutory rules. Well, here they specifically say the rules only said 75, 25, 3:1. There was no question of vacancy, post, so on and so forth, my lords. Therefore, my lords, the understanding, my lords, of the High Court that this was dealing with roster is completely wrong. It was never dealing with roster. For 75, 25, my lords, for easier, they said 25 was 3:1,
Yes.
which is essentially the case, which is 66, 33 in our case.
Yes.
My lords, KK Tiwari, my lords.
Issue framed there in this.
My lord, in RK Sabharwal.
Yes. No, RK.
I'm sorry, Bhatnagar.
Bhatnagar.
My lords, Bhatnagar para 8, my lords.
Yes.
Para, in the light of the aforesaid rival contentions, the following points arise for determination. Whether the interpretation of the Rule 9(1)D, which appealed to the High Court, is the correct one. My lords, Rule 9, your lordships have noticed that para 3, 75, 25. Now, my lords, the answer to that would start at point.
Even if the roster
Yes,
operates on vacancy.
even if the roster operates on vacancies in such a way that from the very inception of the roster, vacancies on the first 3 roster points will go to promotees, and the vacancy on the 4th point will go to direct recruitees, and similarly in future for further, whether the disputed 16th vacancy should go to a direct recruitee or a promotee. That is on facts, my lords.
Yes.
Now, my lords, in this case, if I'm disputing, my lords, that next post should come to a court officer or to a section officer, then I would fall within clause 2. But here, my lords, it's the interpretation of the rule itself, my lords. My lords, next was KK Tiwari, my lords. Very respectfully, the Allahabad High Court judgment, my lords, the relevant portion is not read out, my lords. Paragraph 7, my lords. Paragraph 7 onwards. But para 8 at just above para 9, my lords, of the Allahabad High Court.
Now you reading Allahabad High Court.
Allahabad High Court, because that was read to your lordships. Supreme Court judgment was not distinguished. My lords, just above para 9 of KK Tiwari, my lords. Allahabad High Court. On that page, para 9,
Yes.
top of the page, my lords.
Yes.
33% of the posts are to be filled from the grade of AEE and 33% of the posts are to be filled from the grade of AE. The expression used in the rule is post to be filled.
Yes.
It clearly means whenever any selection is made for the post of EE,
Yes.
66, that is 2/3% of the posts have to be filled in shall be from the grade of AEE, and the remaining 33, that is 1/3% of the post shall be from the grade of AE. The ratio of 2/3, 1/3% has to be maintained.
What is your answer for this Badami and Gonal Bhimappa?
Badami and Gonal Bhimappa are in my favor, my lords. They specifically say, unless by way of an official memorandum, you change it from vacancy based to post based, it is always vacancy based. Well, simple reason is that, my lords, recruitment is to a vacancy.
Yes.
My lords, whenever there is vacancy, a recruitment takes place. That is when, my lords, quota is applied. Therefore, Badami, Gonal Bhimappa are all on vacancy based. After 1975, for the first time, my lords, in 2016, state, insofar as KS junior scale, changed it to post based.
Where is that Badami's case discussion?
My lords, Badami case is cited before your lordship. In the Kaikashan's judgment, it is quoted. Could your lordship just come?
No, in that
Yes.
Badami's case, is it not that it is held that in case of
Yes.
ratio is concerned, it is only a cadre basis?
No, my lords, vacancy based. They specifically said otherwise.
No,
Can I just draw your lordship's attention to that specific paragraph?
Yes.
My lords, the first reference to Badami, your lordships would find it at internal page 44, my lords.
Yes.
Internal page 44. My lords, this was the case where petitioners were arguing against the memorandum which I placed. 2016 converted it to post-based. Against that memorandum, it was argued and reliance was placed on Badami, my lord. The Honorable Apex Court in VB Badami reported in so and so held that seniority of direct recruitees and promotee has to be reckoned on the basis of quota as applied to the arising vacancies, and that appointment in excess of the quota cannot bestow seniority on promotees. Settled. So therefore, my lords, quota in respect applied to the arising vacancies.
Yes.
Badami was. Next, my lords, your lordships will find that reference at page number 49, Gonal Beam up.
Now you have that full judgment because on the basis of that Badami and Gonal Bimappa,
yes,
division bench has held.
Yes.
That this is what is the finding of the division bench?
My lords, in this case, Kaikashan.
Yes.
Kaikashan, my lords, they approved the official memorandum of the government, changing it to post-based.
Yes.
My lords, page 49, my lords.
Enacted applying to vacancies which arises in the cadre, and the quota has to be observed by enforcing the carry forward.
Can I just read? The Apex Court held that quota rules have to be strictly enforced and applied to the vacancies which arise in the cadre.
Yes.
Therefore, my lords, Gonal Bimappa also specifically held in respect of vacancies.
Yes.
My lords,
I have cited this judgment by the respondent there.
My lords,
They have cited this.
my lords, because petitioner said Gonal Bimappa and Badami was in respect of vacancy based. Today, without overcoming the judgment, official memorandum can't be issued. That was the argument there, my lords.
Yes.
My lords, learned senior counsel and myself, my lords, defended the action of the government there, saying official memorandum can be issued. Yes. Because the earlier official memorandum of 75 was vacancy based.
Yes.
By another notification, they changed it to post based. No difficulty.
Now, why you have relied on that Gonal Bimappa?
Because Gonal Bimappa specifically it spoke about vacancy based. Petitioner's argument there was the vacancy based system has to continue, not post based system.
No, they have relied on Gonal.
They have petitioners relied upon that.
Yes.
My lords, respondents, my lords, relied upon. Would your lordships come to page 61, my lords? Your lordships will get that.
Yes.
In support of the above contention, reliance was placed by the learned senior counsel appearing for the petitioners VB Badami, Gonal Bimappa, RK Sabarwal, MSL, so on and so forth.
Yes. Why they have referred the Shabarwala then?
Like the Sabarwala was referred because of their this would touch upon 16.4 or 16.1, my lords, was also one of the disputed questions.
Yes.
My lords, your lordships will find reference to Sabarwala in the AAG's argument at page 64, my lords.
Yes.
At the bottom of internal page 64, para 6.
Yes.
Asserting that the impugned official memorandum aligns with the Honorable Apex Court's judgment in Sabarwal, which acknowledges that 30% of promotees were appointed due to delays, thus necessitating the OM to rectify administrative anomalies.
Yes.
But KK Tiwari, my lords, was not applied there, my lords. KK Tiwari, Bhatnagar, as well as the distinction between Sabarwal 16.4 and 16.1, my lords, was not argued at all.
Yes.
At any rate, my lords, this is today pending in Supreme Court, my lords, and admitted, my lords. I have passed on that order also,
yes,
admitting the matter and placing it for hearing, my lords.
Yes.
My lords, in my respectful submission, my lords, there was a policy decision. Here, my lords, there is no policy decision. Now, my lords, they say that this itself amends the rule. This itself, this intimation to kindly have a look at Annexure A. Intimation is not to all the persons, my lords, in the cadre. Intimation is to about 4 of them. Page number 28, copy 2.
Yes.
So and so, my lords.
Yes.
Copy 2. 2 section officers, my lords, and 2 court officers, my lords.
No, this is intimation to you.
To the, yes, my lords. To the
resolution of the Honorable High Court Staff Committee is approved by the Chief Justice.
Yes, my lords.
Chief Justice has passed an order that has been communicated to you.
My lord, Chief Justice has very respectfully, my lord, Chief Justice passes no order, my lord. He only approves the staff committee.
Say it is an order of the Chief Justice.
My lord, Chief Justice approves the recommendation. Yes.
Now, power is given to the Chief Justice Chief Justice will delegated that power to that committee.
Staff committee, absolutely.
Committee will recommend, Chief Justice approved means it's an order of the Chief Justice.
Yes, my lords. I'm not under, but Chief Justice has not passed an order amending the recruitment rules.
No, now whether it's an amendment or not.
Yes, my lord. Because apparently, my lords, the High Court argues saying that this intimation,
Not intimation.
my lord, this
Intimation is not, that approval of the Chief Justice
is amendment of the rules without it being published in the official gazette or anywhere, my lord.
Yes.
Which can't be, my lord. My lord, your lordships may kindly also have a look at the statement of objections, my lord. In the statement of objections, my lord, they don't say this. They only say that this intimation or the staff committee's response, which is approved by the Chief Justice, is in response to our representation. That's para 1 of the.
No, whether they have stated in that.
Yes, my lords. Kindly have a look at para 1, my lord.
Clearly stated in the statement of objection. In the rules, if it is actually it's an amendment, it will not take over that.
They don't say that. They say this is only a communication, nothing more, my lords. Please have a look at para 1 of the statement of objections.
Yes.
In rejoinder, my lords, respectfully, it can't be improved, my lords, to say that this itself is an amendment.
Yes.
Para 1, my lords, preliminary objection. At the outset, the respondent respectfully submits that the present writ petition is misconceived, premature, speculative, and not maintainable. The impugned intimation, so and so, is merely a communication of the outcome and reasoned administrative decision and does not effectuate or implement any promotion.
Yes.
It's not their case, my lords, that this is an amendment.
Yes.
My lord, then the other judgment, my lords, that was cited of the division bench was in a completely different facts and circumstances. That was a case where recommendation, my lords, for pay, higher pay scale, my lords, was made. My lords,
No, that what they say, recommendatory letter, that means to say.
under 229(2) of the Constitution, my lords. Well, pay para 29, my lords.
No, rules framed under 229. This is also rules framed under 229. This,
My lord, no, para 29, just would your lordship just
what it
have.
says ultimately,
My lord,
if Chief Justice has an issue order, it's in a rule, whether if it is notified or not. That is what
no,
that meaning.
no, very respectfully. My lord, then there was no question of notifying any rules, my lord.
Yes.
My lord, para 29, would your lordship just have a look, my lord.
Yes.
My lords, there the contention was, once the Chief Justice makes the recommendation, can the government turn down that much?
That's, see, usually it will be recommended to issue a notification.
Yes, ma'am.
Now that by
So grateful.
passing an order itself is an amendment or not. now
Yes,
it
my
has-
lord. My lord, but kindly see, my lord, and even under the High Court rules, my lord, your lordships may refer to then
No,
the
is
general
that rule
recruit
says that it has to be notified. or
by
not?
prior publication, my lord.
Where is that?
My lord, your lordships may just have a look at the rules, my lord. Additional documents.
No, in that, you have produced that rule in page.
Yes, my lord. Entire rules, my lord.
Yes. Where is that? It has
My
to be-
lord, additional documents.
No, in that rules you have produced, it is only amendment.
Let's.
No, page 75. You have produced that rules.
My lord, yes, my lord. That was the amended rules, my lord.
Where is
I have
that
shown
original rule?
original rules, my lord, is that in the additional memo of documents.
What is this in page annexure B?
Annexure B, my lord.
Hmm.
Rules, my lord. Only relevant rules, my lord. Would your lordship, I'm sorry, page 29, annexure B are the full rules.
Yes.
My lord, would your lordships come to the preamble, my lord?
Yes.
In exercise of the powers conferred under 229, 1 and 2 of the
It will
Constitution.
be framed under that one.
Yes, my lord.
No, where is that it says amendment requires to issue a notification? In that rule it says.
My lord, this is the,
Only
yes,
in service, in state rules, they will says it is in subordinate legislation, it has to be placed before that this thing and notification gazetted has to be issued.
Yes.
Is that any such condition?
my lord, that the method and manner of framing of the rules, your lordships will have to look at the Constitution itself. Rule will not say how the rules have to be amended.
No.
The parent legislation, my lords, will say how to frame the rules.
No, that's what in that act it should be there. It's
Yes,
under
this is
220.
this is under 229 of the Constitution.
Yes.
Your lordships may just have.
General Clauses Act, Rule 17. No, that will say any rules framed.
Yes,
it should be placed before that either legislators and approved by that.
Yes,
in that act it will say any amendment.
Yes,
same effect.
Let's
any amendment to that rule.
Let's 229 2 minutes.
Yes.
He is asking how the rule should be amended. 229 2 minutes.
This clause shall, so far as they relates salaries, allowance, leave, pension required governor of the state. Administrative expenses including on service in respect to officers, servants, both will be charged upon council.
Can I read minutes?
Yes.
229 2 minutes. Can I just read 2?
Yes.
Subject to the provisions of law made by the legislature of the state, the conditions of service of officers. Kindly mark, the conditions of service of officers and servants of the High Court shall be such as may be prescribed by the rules made by the Chief Justice of the Court or by some other judge or officer of the court authorized by the Chief Justice to make rules for the purpose.
Yes.
Provided that the rules made under this clause shall, so far as they relate to salary, allowances, leave or pensions, require the approval of the governor of the state.
That is, yes.
Yes. Now, the administrative expense, including all salary, allowance, pension, in respect of the
other aspect, Chief Justice can make any rule.
Yes,
without the approval of the government.
Yes.
Governor. Now, is it required notification?
My lord, yes, that's why, my lords, it was all along notified.
It is just because it is notified, you can't say that. Is it required under that?
My lord, in my respectful submission, your lordships may have to rely upon
no, general principle is it has to be notified to see that it's in public domain. Everybody has to know that what is that amendment.
My lords, yes. 21 and 23, my lords.
That Chief Justice will have a power to amend the method of
23 of the General Clauses Act, my lords. That is the enabling provision. Otherwise, draft rules calling for objection, finalization, all of that will fall under clause 23 of the General Clauses Act. General Clauses Act. General Clauses Act.
Karnataka General. Have a copy of it.
Even under the Karnataka General Clauses Act and the central government clauses, General Clauses.
Now, why they have used that word? They can say Chief Justice has a power to amend and method of recruitment time to time. Why they used by general or special order?
By a general or special order is if there is an amendment brought about to various cadre at once, then there will be one order passed. Insofar as the post of assistant registrar, protocols, secretarial services, so on and so forth, the ratio of 2:1 will be followed. It's a general order.
No, it's on general. It is not the any particular this thing.
That's a general order.
Time by general or special order.
Yes.
No, otherwise it should be
by an order
like this. The power to amend that method of recruitment time to time. Chief Justice has a power to amend that method of recruitment from time to time.
Yes.
It should be there. It should have been stopped there. By general or special order.
Can I
excluding that?
Can I persuade your lordships to look at it this way?
Yes.
If the method of recruitment had changed from promotion to direct recruitment,
this power is only given for a recruitment.
Yes, only for method of recruitment to change.
Yes.
If it is from promotion to direct recruitment, clause 3.
That any other rules, it has to be amended how? but exclusively this class has been, proviso has been inserted for recruitment from time to time
Yes.
by general or special order. Is it required for notification?
My lords, if my respectful submission is this, if it is their case, my lords, that we fall under proviso 3 of rule 7,
Yes.
it will first require the rules of the recruitment to be amended, my lords. The condition for 7.3 to apply is if the rules of recruitment are amended. Can I read 7.3 again?
Yes.
The Chief Justice shall have the powers to amend the method of recruitment.
Yes.
My lords, from promotion, if it is changed to direct recruitment.
No, even for the ratio, he said that instead of vacancy basis for the cadre basis, this is also method of recruitment.
My lords,
By general order, he can say.
may I respectful? My lords, by whether it is post based or vacancy based, the number of posts to be filled will change, my lords. The method remains the same. It is by promotion only.
Yes.
The number of posts to which promotions will take place from each of these feeder cadres will change. The quantum will change.
No. See, method of ratio of 2:1, is it not any method of recruitment? It is also.
Respectfully, my lords,
See, method of recruitment by promotion, 2:1 is also method of
my
recruitment.
lords, it will 2:1 will remain even today, my lords. Nothing changes.
No, therefore-
From vacancy based to post based, only calculation will change.
Yes.
Arithmetical calculation changes.
Yes.
But for 7 proviso 3, the entire method has to change from direct recruitment to promotion, or from promotion to deputation, or from deputation to transfer. If that method changes, this clause applies, my lords.
Power to amend the method of recruitment.
Method of recruitment. Now kindly see the recruitment rule, my lords.
From
Page
time to time by
53,
general or special order. Further provided, notwithstanding anything otherwise provided in these rules, the Chief Justice, in his exigency of the High Court, in order to fill up that vacancies in Group D cadre, appoint any suitable person that is under Group D.
Yes, would your lordship just have a look at page 50 of the
See,
page?
if you go further, fill up the vacancy in D cadre, appointing any suitable persons. Even without there is any amendment, any such rules, following the roster, Chief Justice can appoint Group D.
Yes, my lords.
Yes.
For Group D, Chief Justice has absolute power. Note.
That's why it shows that, is it required for notification?
No, my lords. That's my lords. For 7.3 to apply, there must be a change in the method of recruitment. Please have a look at page 50, my lords. Schedule 3, page 50 of the paper book.
Yes.
Column 3 talks about the method of recruitment.
Yes.
Let's first one, my lords. Registrar General. Page 50.
Yes, 50.
Registrar General.
Yes.
By selection of a person who is or has been a district judge.
Yes.
So the method of recruitment is by selection.
Yes.
Now, if you come down to page 53, my lords, the post in question.
Yes.
Class 6,
Yes.
assistant registrar.
Yes.
The third column, method of recruitment is by promotion on the basis of seniority cum merit from the cadre of SO and CO in the ratio of 2:1.
Yes.
Now, my lords, how this ratio is to be calculated is the only question. The method to fill up that vacancy is not at all changed.
Yes, method. No, that is it not that part of that method of recruitment?
Respectfully, no, my lords. Only the quantum of vacancies available to the quota
Yes.
of SO and CO will change, my lords, depending on the method of calculation, not the method of filling up the quantum of post itself.
Yes.
Therefore, my lords, to say that this is amendment method of recruitment changes, my lords, might not be correct. Even if only, my lords, today, my lords, assuming it is vacancy based, 10 of us will get promoted. If it is post based, only 5 of us. Though the number changes, the method of either filling up these 5 or 10 remains the same. It is only by promotion.
Yes.
Method does not change at all, my lords. Only the number of persons who get promoted or who don't get promoted changes. That other judgment was pertaining to 229, where government has no power to refuse the recommendation made by the Chief Justice, my lords. That is what is held, my lords, in VB Vora's case.
No, that is also on this thing.
229 for pay fixation, it has to go to the governor. Your lordships read 229 2 proviso, my lords.
That pay fixation.
Yes, my lords. 229 2 para 29 there, my lords, of that judgment. Internal page 35.
Yes.
As provided under the relevant provisions of the Constitution read with the ruling of the apex court in the matter of so and so, it is not open for respondents, government, to turn down the recommendation which are normally made by the Honorable Chief Justice in exercise of his power under 229(2). When the government itself does not have such a power, it is unfortunate that the Principal Secretary Department assumes the power of rejecting recommendation of the Honorable without even placing the same before the Cabinet. Therefore, my lords, the question was whether Principal Secretary can reject without the.
But Cabinet has power.
Cabinet, of course.
Otherwise, that approval question would not.
Yes. My lords, therefore, it has no application to this, my lords. Here, my lords, Chief Justice, of course.
No, approval of the Cabinet means it is an advice of that Chief Minister, Governor has to
Yes,
approve.
Governor. Here, my lords, it did not even go to the Chief, the Cabinet. The Principal Secretary, without placing it before the Cabinet, rejects it. Therefore, my lords, the division bench held, they have no such power. Normally, government should accept the recommendation of the Chief Justice.
Yes.
My lords, 21 of the General Clauses Act. My lords, I'm just assuming, my lords, that I understand it will go again my own argument that it is not amendment. Even assuming it is an amendment, your lordships asked, where is the necessity to publish it, my lords?
Yes.
21. Whereby any central act or regulations a power to issue notification order, rule, bylaw is conferred, then the power includes a power exercisable in the like manner and subject to the like sanction and conditions to add, amend, vary, rescind orders, rules or bylaws so issued.
Yes.
Now, my lords, if a rule is published by publishing in the official gazette, then amendment will also be in the like manner by publishing in the official gazette only.
Yes.
In the like manner, subject to the like sanction.
Yes.
That is the word used. Their own reply statement does not say it is amendment to the rules. Therefore,
Yes.
in that context, my lords, KK Tiwari is fully applicable, my lords. When it is silent, it is to the post. If they had referred to Schedule 1 of the Act rules, my lords, then it was to the post. It was post-based. They referred to Schedule 3, my lords.
Yes. That's all.
Can I place Gonal Bhimappa and the other judge, VB Badam? Lordships asked.
So which are the relevant paragraphs?
Yeah, I'll just. The first one is VB Badami, my lords. 1976.
Yes.
My lords, this matter was pertaining to fixation of seniority. Yes. If there is breach of quota, they lose seniority. It was pertaining to that.
Yes.
My lords, paragraph 5, the recruitment rules. My lords. On December 2nd, 1957, Mysore administrative rules so and so framed under 309 came into force, and under the 1950 posts were divided into two. One was senior scale post and the other. The junior scale was to be filled in the proportion of 2/3 and 1/3 by direct recruitment or by competitive examination to be held by PSC. Then, my lords, insofar as vacancies is at para 14, my lords.
Yes.
The appellants contended first that the word vacancies occurring in the 1950 means not only vacancies in permanent posts but also, and therefore the quota rule apply to vacancies in all posts whether permanent or temporary on construction of the so and so and so forth. Thereafter, my lords, the finding your lordships will come to page 23.
Yes.
Para 23 on.
Yes.
But this is where, my lords, they uphold that it has to be in terms of the vacancies only. Yes. And para 29, my lords.
Yes.
These are the principles laid down. In working out the quota rule, these principles are generally followed. First, where rule prescribes quota between direct recruiter, confirmation of substantive can only be in respect of clear vacancies in the permanent strength of the cadre. Let's para 32 and 33. 32, 33, 34. All of them refer to vacancies only.
Yes.
If your lordship sees 33, it is the next period is from so and so. The promotional vacancies became 1/3 and direct recruitment vacancies became 2/3. So it was the vacancy based. Gonal Bhimappa Malad would clear that. In Gonal Bhimappa, page 217.
Yes.
Internal page 217, that second paragraph. Two principles are established in the decision referred to. One is that quotas which are fixed are unalterable according to the exigencies of situation.
Yes.
Quotas which are fixed can only be altered by fresh determination of quotas under the relevant rule. The other is that one group cannot claim quota fixed for the other group on the ground that quotas are not filled up, or on the ground that because there has been number of filled up, or on the ground that there has been a number in excess of quota, the same should be absorbed by depriving other quota. Accordingly, my lords, para 13, they again refer to the rules. And they hold, my lords, that it is only in respect of para 23, my lords.
Yes.
Ultimate conclusion.
Yes.
The net result of the discussion above requires that the rule in Badami's case has to be given full effect, and that there will be no reversion, so on and so forth. Gonal Bhimappa essentially approves VB Badami.
Yes.
And VB Badami held it is in respect of vacancies. Grateful for a very patient case.
Reserve.
May we be permitted to file very brief written submissions, my lords, by Friday?
Yes.
By Friday, my lord, we'll file a 2 or 3 page.
Yes.
Just short. Please. Grateful for a
Reserved for us.
please. Interim order, please.
Interim order undertaken will continue till next date.
Please.
Yes.
So grateful.
Continuation of list. Serial number 44. Follow Vedava session I for
Lordship, I
petitioner.
heard this matter on the last date. Lordship, on the previous date, I had made taken the contention. This is that matter, Lordship, pertains to the backlog 2A seats. My lord. One is backlog, one is current year vacancy.
Yes.
Now, my lords, what they have done is they're supposed to fill up the backlog vacancy first. My lords have produced a Supreme Court judgment. On the previous date, submission was made that backlog need not be filled, my lords. My lords, I would want to produce a Supreme Court judgment.
Now you just give the facts, brief facts.
Yes, yes, my lords. 2022 notification is released by the Karnataka Legislative Assembly Secretariat, my lords, for various posts.
Yes.
Dalites, junior assistant, computer operator.
Yes.
My lords, for the post of computer operator, it is at page number 16, my lords.
Yes.
I am eligible under 2A category, 2A rural and GM. Though GM has no post under this week.
You have applied for
2A
and GM.
2A rural.
2A rural.
GM doesn't have any. I don't come under GM, my lords. In there are only 4 posts.
2A rural.
2A rural, my lords. My lords, may see the notification at page number 16.
Yes.
One in backlog. One is backlog. That is 2A. That is Mahila Abhyat. Women post.
Mahila. Yes. 2A.
Backlog. That is a backlog, my lords. That is not current year. It is backlog.
Yes.
Then, my lords, the next is the current year, my lords. That is at serial number 2A, Gramina.
Yes.
There are only 2 posts, my lords. I write the written examination. Select a provisional list is published on 15th of February 2023, which is at page number 36.
Yes.
I am at serial number 2.
Yes.
Ajita Kumar, my lords.
Yes.
Serial number 1 is a woman, my lord.
Hmm.
Under 2A. Instead of giving her the women, they have given it to serial number 8, my lords. Annapurna Badigan.
No, that first candidate has been given under
Rural, my lords.
Gramina, 2A grammar.
Yes, my lords. I am more meritorious than the woman who they have given it to serial number 8.
Yes.
I am more meritorious, but I have not been given the post, my lord. My lords, I had produced a judgment of the Supreme Court which says that backlog has to be filled first. Previous date, they took a contention that backlog we can fill up it. We can fill up women backlog any way we want, my lords. There's no such. My lords, the Supreme Court judgment, Rajesh Kumar Daria's case, my lords. May I produce, my lord? Which very clearly lays down how women quota horizontal reservation has to be filled up.
Yes.
The relevant portion is at starts from para 8, my lords. May I read, my lords? You can start from para 9, my lords.
Yes.
Page number 790. This may I read? The second relates to the difference between the nature of vertical reservation and horizontal reservation. Social reservations in favor of SC, STs and OBCs under Article 16(4) are vertical reservations. Special reservation in favor of physically handicapped women, etc. under Article 16(1) or 15(3) are horizontal reservations. Where a vertical reservation is made in favor of backward classes, so and so, my lords. Then, my lords, may kindly see the C marking. That line, my lord, C line. But the aforesaid principle applicable to vertical social reservations will not be applicable to horizontal special reservations. My lord, may note this. Where a special reservation for women is provided within the social reservation for, they have taken the example of scheduled caste, my lord.
Yes.
Where within the social reservation for scheduled caste, the proper procedure is first to fill up the quota for the scheduled caste in order of merit, and then find out the number of candidates among them who belong to the special reservation group of scheduled caste women.
Yes.
If the number of women in such list is equal to or more than the number of special reservation quota, then there is no need for further selection towards the special reservation quota. Only if there is any shortfall, the requisite number of scheduled caste women shall have to be taken by deleting the corresponding number of candidates from the bottom of the list relating to scheduled caste. To this extent, horizontal special reservation differs from vertical reservation. Thus, women selected on merit within the vertical reservation quota will be counted against the horizontal reservation for women. Let us illustrate by an example. If 19 posts are reserved for SCs, of which the quota for women is 4, 19 SC candidates shall have to be first listed in accordance with merit from out of the successful eligible candidates. If such list of 19 candidates contains 4 SC women candidates, then there is no need to disturb the list by including any further women SC candidate, my lords. On the other hand, if the list of 19 SC candidates contains only 2 women candidates, then the next 2 SC women candidates in accordance with merit will have to be included in the list, and corresponding number of candidates from the bottom of such list shall have to be deleted so as to ensure that the final 19 SC candidates contain 4 women SC candidates, my lords. My lords, in this case also, my lords, if my lords will see the entire list of 2A, serial number 1 is a woman.
Yes.
Serial number 2, I am a 2A rural. There ends the matter, my lords. Already serial number 1 is a woman candidate. It automatically goes to her by virtue of being a woman. For that, she doesn't need to produce any certificate. That is my respectful submission. My Supreme Court has held that in a list, if already 2, for example, in this list, there are 2A seats. One is a woman category seat, irrespective whether it's a backlog or current year. One is a 2A women category seat, one is a rural 2A. If already there's a women candidate in the first 2, the list is exhausted. There is no question of selecting the candidate at serial number 8, my lords.
Yes.
That is what the Supreme Court judgment has laid down and has been followed by the Supreme Court in Saurav Yadav's case, my lords, even in BSNL case, my lords. Several judgments, this has been followed, my lord. This judgment has been followed. That is my submission, my lords. There was no need for them to select. So what has happened is, instead of selecting 1 2A woman, they have now selected 2A women, my lord.
Yes, Mr. Please.
Let's kindly see the notification for a moment.
Yes.
Page number 16, my lords.
Yes.
Top of the page.
Yes.
ಹುದ್ದೆಯ ಹೆಸರು ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್,
Yes.
ಹುದ್ದೆಗಳ ಸಂಖ್ಯೆ 4.
Yes.
Now kindly see my lords, ಮೀಸಲಾತಿ ವರ್ಗೀಕರಣ, ಬ್ಯಾಕ್ಲಾಗ್ 2 ಹುದ್ದೆಗಳು.
Yes.
Now kindly see my lords, in that backlog what happens? ಮೀಸಲಾತಿ 2B.
Yes.
2B ಅಲ್ಲಿ ಏನಾಗಿದೆ? ಸಾಮಾನ್ಯ ಅಭ್ಯರ್ಥಿ, that is 2B others, there is 1 post.
Yes.
Then my lords, we have 2A, ಮಹಿಳೆ 1 post.
Yes.
Then my lords, kindly see below the table, ಮೀಸಲಾತಿ ವರ್ಗೀಕರಣ 2 ಹುದ್ದೆಗಳು.
Yes.
We have ಸಾಮಾನ್ಯ, that is GM.
Yes.
ಇದರಲ್ಲಿ ಮಾಜಿ ಸೈನಿಕ 1, that is ex serviceman. And 2A, ಗ್ರಾಮೀಣ ಅಭ್ಯರ್ಥಿ, we have 1 post.
Yes.
Now my lords, what happens is this: if there were now GM post here,
Yes.
since there is a horizontal reservation of ex servicemen,
Yes.
it is not GM others. My lords, what happens if it was GM others? ಇತರೆ ಅಂದ್ರೆ ಸಾಮಾನ್ಯ ಅಭ್ಯರ್ಥಿ, first ranked person had to be given GM others.
Yes.
Now in this recruitment notification, what happens is, out of the 4 posts,
Yes.
all 4 posts apart have horizontal reservation.
Yes.
Now if my lords may see, horizontal reservation works out like this. ಈಗ GM ಅಲ್ಲಿ only ಮಾಜಿ ಸೈನಿಕ can be selected, that is ex serviceman.
Yes.
2A ಅಲ್ಲಿ we have 2 posts now. 2A 1 is ಮಹಿಳೆ post is available. 2A 1 is ಗ್ರಾಮೀಣ ಅಭ್ಯರ್ಥಿ post is available.
Yes.
2 posts. 2B others is available. Now my lords, he is a person who belongs to 2A.
Yes.
Now what happens in this situation is this, my lords. My lords, if we have vertical reservation, horizontal reservation. GM amongst the vertical reservation, my lords, we have GM, SC, ST, category 1, 2A, 2B, 2B. And horizontal reservation cuts across vertical reservation. That is GM others, GM ex servicemen, GM women and other things. Same thing with other categories.
Yes.
Now if there, first thing, my lords, what has to be done when posts are notified is, you have to arrange the candidates in the order of merit. GM posts have to be filled up on merit first.
Yes.
Now, but here what happens is, GM is ex serviceman. So whoever is the ex serviceman, my lords, in that he gets that post.
Yes,
That is
yes.
clear. Then there is no dispute about it.
Yes.
Then now GM, once I fill up the ex serviceman post, because the top merited guy, whoever is ex serviceman, that is done.
Yes.
Now my lords, the rest, then we come to the vertical reservation. Now vertical reservation, separately they can be filled up, like SC will be filled up separately. Now we come to 2A.
Yes.
Now 2A, my lords, I have 2 horizontal reservations. ಒಂದು women ಇದೆ, ಒಂದು ಗ್ರಾಮೀಣ ಇದೆ.
No, but that is backlog, and how that backlog has to be filled?
No, my lords, in so far as backlog is concerned, now if it was a SC, ST backlog post, the rules itself provide, 2001 rules itself provide, that selection method itself is different, where you make a category of 29 to 41 age group,
Yes.
then 18 to 29. So that
Other than that SC, ST, there is no backlog rule.
there is no, in the sense that rule will not apply. So this is treated as part of the pool to be done on the basis of merit. Now what happens, my lord, says, if I have 2A mahile, that is horizontal reservation on post ಇದೆ,
Yes.
2A gramina, there is no hard and fast rule, my lords, that first I have to fill up women, first I have to fill up rural.
Yes.
My learned friend is relying upon that judgment. From that judgment itself, I will clarify how it has to be done.
Yes.
Now, my lords, what happens is this. What we have done is, in each of the categories, for example, 2A Gramina,
Yes.
out of all the 2A Gramina candidates who are all eligible, the top person has been given 2A Gramina.
Yes.
Out of all the 2A women, my lords, the top person has been given 2A women. Now what happens is this,
Yes.
this lady Harshita, if my lords may now kindly see the rank merit list, my lords, for a moment. Page number 36.
Yes.
Harshita is a
2A.
2A person, but for horizontal reservation, she is eligible both under women as well as under Gramina. Now what my learned friend is saying is, you should have first women ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ none, I would have got selected, is what he is saying. Now the question is, I have accommodated Harshita as a 2A rural candidate.
Yes.
2A rural, because she is eligible for both. 2A rural, my lords, I have filled up first. Then my lords, I have come to, if my lords may see page number 41, I'll quote it there, ಯಾರು ತುಂಬಿದ್ದಾರೆ, page number 41, my lords. Lords, along with 36.
Now that 2A.
Please, my lords.
Rural. No, that why you have chosen that first 2A rural? Why can't you choose that?
Millards, I can choose both. It is like this, Millards. I could have chosen to fill up women. I could have chosen to fill up. There is no hard and fast rule that I should fill up women first. I should fill up rural first.
If you done it, you could have get two top best candidates to your recruitment.
We could have, Millards. I'm putting it that way. Now, Millards, there the other person also could have come and said that if you had done it this way. The point is this, Millards.
No,
Whether
there ultimately will get when you, that there is no rule is there.
Please,
then
Millards.
you have to be adopted some method. The method you are adopted it top. The selection process will be there. That top persons has to be selected.
Please, Millards.
Top 2 has been selected.
No, Millards. Kindly see, Millards. What happens is this.
Yes.
Now, if it was a GM others post or a 2A others post,
Yes.
Millards, there are two things. There is a vertical reservation. If it is a pure GM post and horizontal reservation is not applicable at all, then now, Millards, I get it. If 2A, if I had accommodated Harshita
Yes.
as 2A rural. Now, while selecting, Millards, what I did was 2A rural. First top merit, I filled it up.
No, why top merit you have to take in Gramina? Why can't you take it in that woman?
Millards, we could, I'm telling, Millards, that's what I'm submitting.
Yes.
It can be both ways. Now, Millards, if I filled women also, it is not wrong. If I filled rural also, it's not. At the same time, the contra view also, if I fill it with rural also, it is not wrong. Not, I have not violated any procedure. Now, the question is this. Kindly see, Millards, page 41 for a moment. Page 41.
Yes. Yes.
Harshita, 2A, Millards have the table on the right side, Millards.
Yes.
Harshita,
Yes.
2A, Gramina, 58.75.
Yes.
Now, next person, Millards, is Hajar Isab Yaligar. He is 2B Samanya. 2B we are not concerned, Millards. So 2B alli yar top person idru, we have taken that.
Yes.
2A rural alli yar top person idru, we have taken that.
Yes.
Then, Millards, Guru Raja is Samanya, ex-serviceman, Millards. Whoever is the top person in that horizontal, I have taken that. Now, what happens is Harshita, I have as a top person, I have taken in Gramina. If I had taken in woman, also it would not be wrong. I have taken in Gramina, but the next woman person is selected here. Now, what my learned friend is saying is, I am not a woman. If you had accommodated Harshita as 2A woman,
For that, you should have some mechanism to say that why you have to be selected this method, why can't this? When you have two options,
please, Millards.
there should be some guiding factor. Otherwise, you like that Harshita, you will select her.
No, Harshita will get selected any which one.
No,
No,
that's what he's
candidates.
challenging now.
There are
No,
two
he is
more
not challenging
candidates above.
Harshita's. He is challenging Annapurna Badiger. Annapurna Badiger, Millards, what happens is she is selected.
Yes.
Now, in so far as my learned friend's case is this, Millards, the bottom line is
No,
this.
he's saying that Harshita can be woman.
Please, Millards.
He can be placed in that rural. Then Annapurna, see, now you are selecting person scored 36.75.
Please, Millards.
If there is no any law provided for that. When you are given an option for you, you have to select best among them.
No, Millards.
Selecting that
What, Millards?
she has scored 36.75%.
Please.
Even 54,
Millards, there are two candidates who are in 2A.
54% persons who is also eligible. according to
Anushri
you.
and Anushri is also a 2A woman, my lord. She's not been selected.
Not 54, Millards.
So what is his score?
Mine is 57.75.
57.75
Yes, my
percent
lord.
is eligible. Your selected person is 36 points.
No, Millards, he is eligible in the sense, Millards, if that is the case, in every recruitment, if I follow a different method, a different person will come.
Now, where is that you are following this method in all?
Millards, I'll point out, Millards, kindly see Rajesh Kumar Daria, what it says for a moment. I'll just point out from Rajesh Kumar Daria itself.
Yes.
Millards, before I just read that paragraph, I just wanted to point out one thing, Millards.
Yes.
In the notification, my lords have seen a table that we use in the state of Karnataka.
Yes.
In all notifications, I put the reservation roster in the form of a table. Millards, that is called compartmentalized reservation. Millards, the other way of going about is in some states, what they do is, they don't give this table in this manner. They say, GM 50 posts are there, 10 posts are there. Out of this,
Yes.
they just say 5 are women, one is rural, that is what they say. That is overall reservation. When I give a table like this, it's called compartmentalized reservation. Now kindly see, my lords, paragraph number 7 in that judgment.
Yes.
Now, my lords, this is women, rural, ex-servicemen, whatever we fill up, my lords, it is horizontal reservation.
Yes.
A provision for women made under Article 15(3) in respect of employment is a special reservation as contrasted from the social reservation under Article 16(4). The method of implementing special reservation, which is a horizontal reservation cutting across vertical reservations, was explained by this court in Anil Kumar Gupta versus State of UP thus. The proper and correct course is to first fill up the OC quota, that is GM quota, on the basis of merit, then fill up each of the social reservation quotas, that is SC, ST and backward classes. The third step would be to find out how many candidates belonging to special reservations have been selected on the above basis. If the quota fixed for horizontal reservation is already satisfied, in case it is overall reservation, no further question arises. But if it is not so satisfied, the requisite number of special reservation candidates shall have to be taken and adjusted accommodated against the respective social reservation categories by deleting the corresponding number of candidates therefrom. Kindly note in the bracket notes, if however, that is in the state, it is a case of compartmentalized horizontal reservation, then the process of verification and adjustment/accommodation as stated above should be applied separately to each of the vertical reservations. In such a case, the reservation of 15% in favor of special categories overall may be satisfied or may not be satisfied. Notice, I'll just pause here for a moment. In the statement of objections, we have stated this. In each category, the top merited person has been selected is what we have stated. Now, GM rural, whoever was the top, we have selected. Now, incidentally, also if I could have selected it under GM women also. Now, my lords are posing a specific question, my lords, to the insofar as the recruiting authority is concerned. If you had adopted the other way around, then the top merited persons could have been accommodated, my lords. My lords, insofar as this the Legislative Assembly is concerned here, what they have done is rural reservation. The special reservations were first considered. For example, GM ex-servicemen was first considered. Then, my lords, the rural reservations have been considered. Then women has been considered. Then others has been considered.
Where this method is adopted in?
My lords, this is there is no hard and fast rule, my lords, that I have to adopt this method or adopt that method.
You have followed that method in all recruitment.
Please, my lords, in respect of this recruitment also, I've stated it in the statement of objections.
Whether same principle is followed in other recruitment also?
No, my lords. Please, my lords, in other recruitments, what happens is this. My lords, kindly note, there will be one, I'll just point out one example. If suppose 2A, there was one recruitment, my lords, what had happened there was 2A others post available and 2A rural post also available. Now, my lords, we had actually selected the top merited person as rural, yes. Then we selected the other person. So what happened is, unfortunately, his rural certificate validity Barlila. It failed. Yes. He made a claim that you could have selected me under others because I anyway had the merit, yes. Then I would have been first. But, my lords, we pointed out that in terms of Rajesh Kumar Daria, state government has issued a circular. First, fill up the horizontal reservation categories. Amongst horizontal reservation, my lords, the special categories are filled up first. Then comes, my lords, the other categories like women and others. Yes. So, in the statement of objections, my lords, I have specifically avoided in one paragraph. If my lords, I'll just point out that paragraph, my lords. My lords, paragraph number 11, my lords.
Yes. Yes.
It is respectfully submitted that the petitioner applied for the post of computer operator under 2A category, which is evident from his application. During the scrutiny of the application, the petitioner was considered under 2A rural category as he had a valid rural certificate. The petitioner was called to write the exam conducted by the Karnataka Examination Authority on 6/12/2022 and accordingly secured 57.75 marks in the examination. As per the notification dated so and so, one post of computer operator was reserved for 2A rural category. The candidate who secured the highest marks in the said respective category was appointed to the post of computer operator. That's all I want to say is this. If a person who has scored less than him in a category which he is eligible, is selected, he will have a case. He cannot say you could have adopted a different procedure and I would have been selected. Otherwise, my lords, in every recruitment they can do that because it is a question of permutation and combination. First idu fill madidre now bartidvi bere tara madidre. The question is this: in the category you are eligible, has a lower merited person been accommodated? He was only eligible, my lords, for 2A rural. In 2A rural, less than him, nobody has been selected. Everybody who is selected is more than him. I have selected one person in 2A women. You are not eligible in 2A women. So you cannot have a grievance against 2A women. So my respectful submission is that if the court were to say, my lords, that if a different formula was adopted, or if I had filled up women first, then because what happens, my lords, is this: in certain recruitments it could be the other way around. Nan idu first fill madre kelobರಿಗೆ advantage agbodu. If I take the other way around, it could be advantage to somebody else. So therefore, my lords, insofar as the Legislative Assembly is concerned, there is no illegality in the recruitment. A lower merited 2A rural person has not been selected.
Yes, what is this judgment? It is, I think it is.
My lords,
central,
my lords may kindly read.
Reservation.
My lords may no, my lords.
Yeah,
In
right.
fact, this is squarely applicable. My lords may kindly read para 10 and para 11, my lords.
Yes.
May read para 10, page number 792. My lords.
Yes.
Even in this case, my lords, women are given in excess of the available reservation.
Illi example was taken, alli bare women ಬಗ್ಗೆ consider ಮಾಡಿದ್ದು. It does not talk about if there are multiple categories, women, ex-servicemen, what it just talks about when you are filling up horizontal reservation, what is the pattern. Now, my lords, the second ground, my lords, that we are taking is this, with regard to the delay, my lords. Now, my lords, in respect of the same notification, which notification, my lords, was issued on 26/4/2022.
Yes.
And my lords, the select list was published on
Yes.
on 17/4/2023, my lords.
Yes.
Writ petition, my lords, is filed on 30/9/2024. Judgment.
Yes. Appointment order is issued to the petitioner.
Please, my lords, appointment order is issued to the private
final
respondents.
List, even before the final list is issued, they issue appointment orders. That is what they have done.
Where is that?
That they have not produced, my lords, appointment orders. 1st of April, they issue appointment orders even before the final list is published, my lords. That they do not deny
No,
that.
I am only on the ground of delay. One nimsham, I'll finish. My lords, I'll just finish it.
List is issued on 7/4/2023.
Please, my lords, 7/4/2023.
1st of April, they issue final orders, my lord. Appointment orders. Appointment orders are issued way before the final list is.
My lords, that ground is, I'm just on the ground of delay, my lords.
Yes.
Now, in reply, if it takes, my lords, 7/4/2023 final list, writ petition filed on 30/9/2024.
Yes.
Now, my lords, copy. Lords, in respect of the very same recruitment.
Yes.
Anush. Very same recruitment, my lords. There was a challenge in respect of the post of junior assistant.
Yes.
Junior assistant. Kindly see first para, my lords. Same notification.
Yes.
The petitioner, an unsuccessful candidate for the post of junior assistant in respond number 2, Karnataka Legislative Assembly Secretariat, is before this court under Article 226 of the Constitution of India, challenging the order of appointment of respondents 4 to 7 under order dated 29/3/2023, bearing number so and so, and for a direction to respond number 2 to appoint the petitioner to the post of junior assistant.
Yes.
Then, my lords, the petitioner, paragraph number 4, my lords.
Yes.
The petitioner is before this court nearly 2 years from the date of the order of appointment dated 29/3/2023. No explanation whatsoever is forthcoming in the writ petition as to why there is delay in approaching the court. Respondents 4 to 7 are working for nearly 2 years as junior assistants in respond number 2 secretariat. At this length of time, it would not be appropriate for this court to go into the validity of selection and appointment of respond number 4 to 7. It is for the petitioner to approach the court immediately or within a reasonable time. In the manner of selection and appointment, short delay of even a month would be fatal. As the petitioner has slept over a right for nearly 2 years, I am of the opinion that the writ petition is liable to be dismissed only on the ground of delay.
Yes.
ಅಲ್ಲ ಇದೇನೆ ಇದು ಯಾರಿದು
You can make my submissions, my lord.
ಒಂದು ನಿಮಿಷ
Submission.
Let's let him complete. Yes.
Well, it's one more judgment. ಇದು ಯಾವ post ಇದು
Yes.
Let's paragraph number 2, my lords.
Yes.
Learned counsel for the petitioner would submit that the petitioner is before this court, para 2.
Yes.
Questioning the selection and appointment of respondent number 3 to 12 under notification bearing number so and so, and also prayed for a writ of mandamus directing the respondents to follow the procedure laid down under section 2 of the Karnataka Civil Services Procedure for Selection of Candidates during Recruitment Act 2018. Then, my lords may kindly see paragraph number 5. The petitioner was an aspirant of junior assistant in pursuance of notification dated 26/4/2022. The provisional select list of the said post was published on 15/2/2023, and thereafter appointment has taken place. The petitioner before this court is nearly 2 years thereafter. The Honorable Apex Court in the case of P. Sadashiv Swamy versus State of Tamil Nadu has held that the shortest delay also would disentitle the petitioner to relief in service matters under Article 226 of the Constitution of India. Relevant paragraph reads as under. A person aggrieved by an order of promoting a junior over his head should approach the court at least within 6 months or at the most a year of such promotion. It's not that there is any period of limitation for the courts to exercise their powers under Article 226, nor is it there can never be a case where the courts cannot interfere in matter after passage of certain length of time. But it would be sound and wise exercise of discretion for the courts to refuse to exercise their discretionary powers under Article 226 in case of persons who do not approach it expeditiously for relief and who stand by and allow things to happen and then approach the court to put forward stale claims and try to settle matters. The petitioner's petition should therefore have been dismissed in limine. Entertaining such petitions is a waste of time of the court. It clogs the work of the court and impeded work of the court in considering legitimate grievances, as also its normal. We consider the High Court was right in dismissing the appellant's portion. In the instant case, respondents 3 to 12 selected candidates are appointed as junior assistant in pursuance of the provisional select list dated so and so. Then at counsel for the petitioner's explanation that the information with regard to publication of select list was not available, and even petitioner filed application under RTI, no information was furnished. It is seen from the records that petitioner applied seeking information with regard to selection only by making application on 20/11/2024, which is replied by communication dated 26/12/24. The information sought by the petitioner itself is more than 1.5 years, and respondents have replied immediately. The petitioner is not diligent, and the petitioner slept over his right. Appointed candidates are working for nearly 2 years. Now, my lords, my respectful submission is these, my lords, the first judgment I cited was in respect of the very same notification.
Yes.
My lords, I also have to bring to the notice, my lords, in respect of the post of Dalayat, in respect of the very same notification, they had approached this court immediately. Then thereafter, my lords, the court considered it on merits by the very same learned single judge, my lords. And the very same learned single judge, in respect of a belated claim, dismissed it. But in respect of the other Dalayat post, my lords, there were some directions that were issued and matters pending before the division bench. My submission, my lords, is he has slept over his rights. In his category, less than him, nobody is selected.
Yes.
If you ask me to do some permutation combination, another candidate can come and say, if you do like this, I will be selected. So therefore, my lords, there is no merit in the petition. Grateful.
Yes, Lordship, first with respect to the fact that Annapurna Badiger is not the highest meritorious candidate in 2A women, my lords. There are two above her. One is Anushri AS and Huligawa Katti, my lord. She has actually filed a writ petition that is still pending.
Who?
Serial number 7.
Where you are?
My lords, page number 36 of the writ petition, my lords. That's the provisional list, my lords.
Yes.
Their first contention is that the candidate who has been selected in a 2A women category is the highest meritorious in 2A women category, which is not correct because
No. They are saying that
yes,
you are an aggrieved person.
Yes, my lords.
You can be aggrieved that person who is lesser than your
Yes,
category.
yes, my
has been
lords. My lords,
selected to that post.
I am just making submissions based on what they have submitted. In fact, Huligawa Katti, she has filed a writ petition which is still pending, my lords.
She is filed for what?
For the post of women category, my lords.
Yes.
That is still pending. That has not seen the light.
She has been selected to which post?
She has not been selected. She is higher, more meritorious than the one who is selected.
Who?
Annapurna Badiger.
Where?
Serial number 7. Serial number 8.
What she's maintaining. It is only under the rural quota, not Sri Lanka.
Rural quota. No,
She's particularly applied for rural quota.
no, my lords. How can somebody apply for rural quota by?
No, you are not concerned all these things.
No, my lords.
Now,
But
in
women's
case-
women quota does not require a certificate. Is what my submission is, my lords. You don't have to specifically apply for women's quota by virtue of being a woman.
Yes.
You are entitled to automatically entitled.
Yes.
So that is my first submission that Annapurna Badiger is not the only meritorious.
No, she is Annapurna Badigari in serial number
8. But the one who is above her, serial number 7, she is more meritorious under women category, 2A women category, and her writ petition is still pending.
No, we just. She has been selected.
She has not been selected.
Who has been selected?
Annapurna Badiger has been selected. Who is below her? Annapurna Badiger at serial number 8. She has been selected.
Who has filed a writ petition?
who is above her, Huligawa Katti, my lord, who's at serial number 7.
37.5.
37.5, my lord.
Why she has filed a writ petition?
Claiming women category, my lord. She has not been selected. That writ petition is pending, my lord.
Now, why she has not been selected?
Because that is what, my lords, they have not followed proper procedure. They are saying that they have given the highest.
Not under rule, my lord.
No,
She
my
applies
lords.
only under rule.
My lords may list that writ petition along with this and
No,
that.
if she,
Lord, she has
she is,
rejected only on that, she has not provided.
if she is, no, if she is succeeded, that will be decided for women quota. It is not for
Yes,
the
my lords,
rural.
I'm just making my
She
submission.
will not get any benefit.
Yes, my
That's
lords.
what-
No, I'm just making my submissions that she.
If they have made so many mistakes in that other case, that will be get. What is your case? You have to-
And secondly, my lords, may kindly see the Supreme Court judgment para 10 and 11, my lords. I just want to bring to my lords notice that para I have not read those two paras.
Yes.
Because the previous paras were read, but these are the subsequent paras which also have some importance.
Yes,
Para 10, my lords.
yes.
In this case, the number of candidates to be selected under general category open competition were 59, out of which 11 were earmarked for women. When the first 59 from among the 261 successful candidates were taken and listed as per merit, it contained 11 women candidates, which was equal to the quota for general category women. Thus, there was no need for any further selection of women candidate under the special reservation for women. But what RPSC did was to take only the first 48 candidates in the order of merit, which already contained 11 women, and thereafter fill the next 11 posts under the general category with women candidates. As a result, we find that among 59 general category candidates in all, 22 women have been selected, consisting of 11 women candidates selected on their own merit, so and so, included under reservation, and 41 of the selection list, and another 11 plus 11 included under reservation quota for general category women. This is clearly
See,
impermissible.
It is
Then,
in
my lords-
respect of the women's, they said,
Yes.
see, if that in both category, in horizontal as well as in vertical, if you filled up entirely it's a woman, then there not be a correct process. They said that if their woman is there in that horizontal.
Yes, that is my case, my lords. If already there are 2 posts and there is 1 woman already in the
No, you
selection.
cannot club that in all categories.
No, my lords.
See, suppose in respect of vertical reservation, SC, ST,
Yes.
OBC, there are only 3 seats. If all 3 candidates selected top is women, you cannot say that only a woman.
No,
will
no,
just
no. That's absolutely true. Remember, my lords may reach para 11. Para 11, if my lords reach, it will be, that's the final para I want to rely on.
Yes.
Similarly, we find that in regard to 24 posts for OBCs, 19 candidates were selected by RPSC in accordance with merit from among OBC candidates, which included 3 women candidates.
Yes.
Thereafter, another 5 women were selected under category of OBC women, instead of adding only 2, which was the shortfall. Thus, there were in all 8 women category candidates among the 24 OBC candidates found in the selection list. The proper course was to list 24 OBC candidates as per the merit, and then find out number of women candidates among them,
That is
and
again
only
that
fill.
OBC same principle.
My lords, that's what my
What
lords-
is your
my-
contention regarding the delay?
My lords, with regard to delay, first, my lords, they don't call for objections. They are first, after the provisional list is released, my lords, which is at page number 36, they don't call for objections.
No,
They
provision list
immediately.
itself is for calling an objection.
No, my lords, thereafter they have to call for objections. When the final, my lords, what the procedure has to be followed is, first provisional list is released, my lords. They, instead of calling for objection.
No, provisional list will be released to see that if anybody has an objection to file an objection.
My lords, correct. But what they do is they don't call for, no, my lords, what
No,
happens is,
you have to submit an objection.
my lords, they did not, my lords, what has happened is, even before the final list is released, my lords, they release the appointment orders, my lords. That is, appointment order is not published on the website, my lords. Thereafter, the candidates were not aware what has happened in the proceedings, my lords. That is the issue, my lord. I have made several representations, and in fact, my lords, I have received an RTI reply.
Issued on 7/4/2023.
17/4. List is released on 17/4/2023.
Where is that list? 17/4.
2023.
Where is that 17/4?
Annexure H.
Annexure.
H-man. But even before the list is released,
42, page 42.
category wise, they have not released.
No,
They were
this-
supposed to follow the category wise, my lords. They have not followed that.
No, this list shows that
It doesn't show the
in
category.
respect of from ಅಭ್ಯರ್ಥಿಗಳ ಹೆಸರು ಸಂಖ್ಯೆ ಹರ್ಷಿತಾ HR. Now that she has selected to which post you have not mentioned.
Not mentioned.
Not mentioned in the select list. This is only a Millards list, Millards, ನೇಮಕಗೊಂಡ ಅಭ್ಯರ್ಥಿಗಳ ಪಟ್ಟಿ. Computer operator 4 posts were there, Millards. I have mentioned that 4 posts have been
In
notified.
fact, according to the
Their
act,
petitioner name is not there.
Is not there. So
No,
the moment is not selected,
It is published in where?
Millards,
in fact, they have given an RTA reply that they have not published at all. My lords, may kindly see.
in the assembly website.
My lords, may kindly see the RTA reply that they have given.
You said you are not published.
My lords say RTA. This is after filing the writ petition, they reply to my RTA. My lords, may kindly see. My lords, the second page, my lord. This is dated 23 last year, my lords.
Yes.
My lords, may kindly see the reply that they.
ಇಲ್ಲೇ ಮಾಡಿ ಅಪ್ಲೋಡ್ ಮಾಡಿ.
In all the recruitments, they have followed the same wrong procedure, my lords. Every recruitment, they have first given reserved category, then they have given general merit. They have kept the candidates under dark, my lords.
No, that's
Second paragraph.
Where is which rules which says that? Yes.
Second para in that.
Yes.
ಆದರೆ ಸದರಿ ಅಧಿಸೂಚನೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಸಚಿವಾಲಯದ ವಿವಿಧ ವೃಂದಗಳಲ್ಲಿ ಹುದ್ದೆಗಳಿಗೆ ನೇಮಕಗೊಂಡ ಅಭ್ಯರ್ಥಿಗಳ ಪಟ್ಟಿಯನ್ನು ಅಂತರ್ಜಾಲ
But final
so
list
and so ವೆಬ್ಸೈಟ್ ನಲ್ಲಿ ದಿನಾಂಕ 17/4/2023 ರಂದು ಅಪ್ಲೋಡ್
Final
ಮಾಡಲಾಗಿದೆ.
list, they have not published, they have mentioned it.
This is what has been published. Annexure H was published on 17/4/2023.
Yes, they have stated that it is published. It is
My
not.
lords, but my lords, the category wise, they have not published. My lords, we don't know on what basis they have.
You
my
know
lords.
that on that day you are not selected.
Yes, my lords, I wrote representations also, my lords. I have produced the representations.
What is the use then giving a representation? We'll say consider your representation. If you consider and why you have given that, they will give that reply.
In fact, my lords,
What's the use in giving in a representation person who has not selected, Mr.
my lords, but
They
the
will reject
whole,
you.
my lords, the spirit of the judgment that I have shown to my lords is that, my lords, the entire list has to be seen in totality. If there are 2 posts,
Yes.
if one woman is already there, that report,
Mr.
that submission
That
may be.
case is in same category how women's candidate has to be operated.
Yes, my lord.
It is not that rural and that women in that what general and the SC, that in each category the women's quota should be there. How much it is either in that horizontal or in that vertical. Your is that one is rural.
Yes,
Another is that women general.
Yes, yes,
Women
ma'am.
2A.
It already post is exhausted.
In 2A, if there is any 10 post,
Yes, my lord.
if 5 post is reserved for a woman,
Yes,
if they are there already in
Yes.
that vertical
Yes.
or that, then they cannot be given for that on the basis of that merit. That's what they said.
No, my
It is
lords.
not
If-
that mixing 2A and SC or that other category, Mr.
No, my lords,
They
what
will
my-
answer that. Yes, sir. In this writ petition, petitioner challenging you are not challenging that appointment of respondent.
My lord, I challenge the list, my lord. I am not.
No.
I challenge the list.
Yes. Annexure H, the list published by the respondent number 2, the selected candidates list published by, the final selection list published by second respondent. The respondent has called for an second respondent has invited an application for recruitment for various posts in Karnataka Legislative Assembly Secretary for the year 2022. Petitioner has applied to the post of computer operator under 2A rural. Notification dated 26/4/2022. Thereafter, Void annexure E. Provisional merit list of the candidate has been issued. One Shri Harsita HR, claimed category and 2A, has secured 58.75. The petitioner has claimed under 2A rural, has secured 57.75. The out of 4 posts which is called under backlog, 4 is also no, only 2. Yes. Out of 4 posts which is called for computer operator, 2 is under backlog and 2 is under reservation. Under the backlog, 1 post is reserved for 2B general and 1 is for 2A women. In respect of reservation, out of 2, 1 is reserved for general ex-servicemen and 1 is for 2A rural. By impugn final selection list, the impugn selection list has been published on 17/4/2023, wherein petitioner name has been not placed. The writ petition was been filed on 30/9/2024, challenging that said list. Learned counsel appearing for the petitioner has contended that the impugn final selection list is not made to not made known to the public, is not published, is not made known to the public. Therefore, petitioner was not aware of that. When did you come to know this, Mr.? How did you come to know? When did you come to know?
My lords, actually, what has happened, my lords, I received this brief through an NOC. I was informed that the previous, I'd asked my client why there was a delay in filing.
You cannot ask now and tell. Is it there pleading, Mr.?
No, my lords, I am just
yes,
bringing to my notice.
No, not blaming you, Mr.
Yes, ma'am.
The thing is that it is not pleaded. It's not pleaded. No risk.
But I've been informed, my lords, is what happened was that I was the petitioner was told to first approach the KT, but there was some confusion regarding that. That's why there was some delay.
No, anyhow, you made your best effort.
Yes, my lords.
Yes, that's
Matter is reaching. Can I excuse?
You made your best effort to
yes.
Protect your interest of your client. That is what that lawyer has to do. It you have done it. Yes.
My presence may be excused.
Yes, yes.
Great.
Immediately after come to the knowledge of the petitioner, they have filed this writ petition. Secondly, he has contended that Srimati Harshita HR, she has claimed to a woman category. Instead of she has been appointed under to a woman category, her case has been considered under 2A plural. Even though petitioner is scored highest marks in 2A rural, he has not been appointed. Further contended that as per the merit list, first respondent has to be appointed. First respondent has to consider 2A woman category. Then they have to consider 2A rural. In support of his contention, he has relied on judgment of Apex Court in 2007-8 SCC 785. Per contra, Additional Advocate General appearing for the state had submitted that the final selection list has been published on 17/4/2023. Writ petition has been filed on 30/9/2024. There is a delay in filing that writ petition. In the meantime, the appointment order has been issued to all successful candidates. The appointment order issued to respondent number
7.
4 and 7 has not been called in question before this court. Secondly, he has contended that in respect of filling up a post in horizontal reservation is concerned, there is no hard and fast rules. The petitioner has claimed in support of his delay, in support of his contention, he has relied on judgment of this court in WP number 34565 of 2024, disposed of on 9 January 2025, and 5431 of 2025, disposed of on 25th February 2025. Contended that in respect of category 2A rural, none of the candidates who has scored below the petitioner marks has been appointed. Once Harshita has been appointed, she has scored more than that petitioner has scored. Again, written examination with the marks card written examination. Therefore, petitioner cannot have any grievance. Hence, he sought for, and he further contended that judgment relied upon by the petitioner in the case of Rajesh Kumar Daria is not applicable to the facts of this case. Heard the learned counsel for the parties. Peruse with paper. Second respondent has invited application for recruitment for post of for various posts in Karnataka Legislative Assembly as per notification dated 26/4/2022. In respect of computer operator is concerned, they are called 4 posts for so and so category. Either extract. The same is extracted. Petitioner has applied to the post of computer operator under 2A rural. In the merit list, he stood second and he stood first in 2A rural. The final selection list was published on 17/4/2023 in the department website. Petitioner has filed this writ petition on 30/9/2024.
He filed it on 3rd October 2024. 3rd October 2024.
3rd October
2024.
3rd October 2024. After 1.5 years of publication of final list. In the meantime, the appointment order is also issued in favor of respondent number 4 and
7.
7, and they are working as a computer operator in second respondent. In writ petition, there is no explanation has been given for delay in approaching this court. This court in similar circumstances, considering the judgment of apex court has dismissed that writ petition on the ground that in the service matter, shortest delay is also will disentitle petitioner to seek any relief under 226 of Constitution of India. The relevant paragraph, para 5. In 34563 of 2020-24, in similar circumstances, this court has dismissed that writ petition. In similar recruitment,
Yes, ma'am.
Yado,
Junior assistants.
no, Anushree, that's
Junior assistant, junior assistant.
same notification.
Same notifications. This
In
one.
respect of same notification. On the delay itself, the matter requires to be dismissed. Even have you stated any ground in the delay? Even on the merit also, for fill up the post on horizontal reservation, there is no hard and fast rules. In this case, candidate who has selected, appointed, in this case, petitioner has claimed to the post of computer operator under 2A rural. The candidate who is appointed under that category has scored 58.73%. The petitioner has scored 57.75%. Since no candidate scored lesser than the marks of the petitioner is not appointed to that post, therefore petitioner cannot have any grievance. Even the judgment relied upon by the petitioner is also not applicable to this court. On this ground, the writ petition deserves to be dismissed. Yes.
Great.
All pending applications are dismissed. Yes.
Serial number 45 adjourned, serial number 46, but Ramachandra
Appeared for the petitioner, my lord.
Yes.
Matter relates to, my lord, promotion.
My lord, need to file objection, my lord. We have issued an endorsement on the direction of the Honorable High Court, my lord. Need to file objection.
2000.
Wants to file objection.
The 2024 matter, second round, my lord, petition.
Yes.
Since 2012, my lord, they have denied me, because actually matter is like this. I've been promoted, my lord, from the post of peon to the post of bill collector.
Yes.
I was working in the village panchayat. And I have promoted in the village panchayat level only by the executive officer. I have worked as bill collector for 5 years.
Yes.
Thereafter, the village panchayat was upgraded and merged with CMC, Kapu and Udupi district.
Yes.
The deputy commissioner was requested to submit a report, recommend the persons who are eligible for being recognized as the employees of CMC.
Yes.
Now, my name was also sent along with the
the others as a bill collector only. For a moment, your lordship may kindly see page number 27, my lord.
Yes.
These are all the admitted facts, my lord.
Yes.
Page number 28, my name is shown at serial number 6. Now it is shown as Javana ಹುದ್ದೆಗೆ ನೇಮಕಾತಿಯಾಗಿದ್ದು ಪದೋನ್ನತಿ ಹೊಂದಿ ಬಿಲ್ ಕಲೆಕ್ಟರ್ ವಸೂಲಿಗ ಹುದ್ದೆಯಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದಾರೆ. Lord, this recommendation was sent. Subsequently, my lord, the second respondent has approved the list.
Yes.
But showing my name as peon only.
Yes.
And thereafter, my lord, I have given a representation. Your lordship will find page number 31, my lord.
Sir, he is not ready to answer your question.
Please.
You have instruction, Mr.
Second round, my lord, even today they say, even after the filing of the writ petition, my lord, there was a post facto approval was given by the executive officer of the Jilla Panchayat. Thereafter, even the government says, my lord, you appoint him.
Yes.
Even after this, your lordship may kindly see for a moment.
Now, what is that order now you are challenging?
My lord, the endorsement again issued saying that it is not possible to recognize me as bill collector.
Yes, Mr. You. Yes, sir. The request of government advocate.
Short date may be given, my lord.
Which sign is granted? Leave this matter on 4th, Mr. Yes.
47 adjourn, 48 Vijay Raghava Sarathi.
Yes.
48.
Leave this matter next week.
49 adjourn, serial number
Petitioner.
50, Sadashivaya KG.
Next week, any date?
Next week. Yes. Leave this.
9th.
Yes.
ಈ ಖಾತಾ ಅಂತ ಹೇಳಿ ನಮಗೆ ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
Which one? Serial number?
50, sir.
50.
Plan is also furnished and earlier old
Why it is posted here?
Now for consideration of the interim prayer.
Why that special order?
No, my lord, it's not the special order, my lord. It was
Special order is come.
course quotal number Admiral Pandit.
Service matter. Why that service matter is connected to this?
No, there is no connection.
ಇದೆಯಲ್ರಿ ನೀವು ಲಿಸ್ಟ್ ನೋಡಿಲ್ಲ ಅಲ್ರಿ ಸರಿಯಾಗಿ.
Connected matter is there. The neighbor has filed another writ petition making allegation against me. For that purpose, my lord, they have given the.
What is that service matter which is connected?
No, there is no service.
List ನೋಡ್ರಿ.
No, my lord. By mistake it has been connected, my lord.
That's you have to say. You said not connected. It is connected. 51.
Not connected to that.
50.2, 50.3 is the service matter, Mr.
There is a mistake, my lord.
ಅದನ್ನ ಹೇಳಿ ನೀವು ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರೆ ನಾನು ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ.
I have not submitted to the court by saying that it is going.
Delist this matter along with that 3194 ಏನೋ ರಾಂಗ್ ನಂಬರ್ ಕೊಟ್ಟಿದ್ರ ಅಲ್ರಿ. 31940 34756 34756 correct. 31940. Who has given this number?
Lord, we have given the number.
ಯಾವ ನಂಬರ್ ಕೊಟ್ಟಿದ್ರಿ ನೀವು?
Lord, it is in respect of approval of the plan, Lord. It is not the service matter, Lord.
ಅಲ್ರಿ ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಅಂತ ಶೇಷಗಿರಿ ರಾವ್ ಎಲ್ಲಿದ್ದಾರೆ? What is this matter, Mr.? Is it your service?
This is service matter.
That's why it
Shantalized service matter.
By mistake it is connected, Lord. By noting of the phone number. This.
ಅಲ್ಲ ನೀವೇ ಕೊಟ್ಟಿದ್ದ ನಂಬರ್ ಯಾಕೆ ಕೊಟ್ರಿ ಅಂತ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
We have submitted to the open court, Lord. By mistake they have never taken the number, Lord.
ಯಾವ ನಂಬರ್ ಕೊಟ್ಟಿದ್ರಿ ನೀವು?
Lord, another connected matter is 4144 6144 589 of 2024.
ಮತ್ತೆ ಇದು ಯಾವ್ದ್ರ this is nothing to do with this, Mr.
Please, Lord.
Yes, Mr. Sunil, this is your matter. Yes. Karnataka Council for the Parties has submitted that.
6144 and
31940 ಅಂತ ಬರ್ಕೊಂಡಿದಾರಪ್ಪ. 31940 ಎಲ್ಲಿದೆ? 31940.
3.1 sir.
ಆಮೇಲೆ 34756. 31940 LB ಕರೆಕ್ಟ್. 34756 ಸರ್ವಿಸ್ ಮ್ಯಾಟ್ರಿಗೆ ಅದಕ್ಕೆ ಇನ್ನೊಂದು ಕನೆಕ್ಟ್ ಇತ್ತು, ಅದನ್ನ ಸೆಲ್ಫ್ ಕಳ್ಸಿದ್ದಾರೆ. ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಯಾವ್ದು ಹೇಳಿದ್ರೆ 31940 ಆದ್ಮೇಲೆ
ಹೌದು ಸ್ವಾಮಿ 35756
35756 ನ 34756
That's what I said, my lord.
Yes. It's
Learned
3475.
counsel for the petitioner submits that. Instead of connecting
Number words.
3-5
35756
of
24.
6 of 2024 was wrongly mentioned as 34756 of 2024. It's service matter. In view of the above, office is directed to post WP number 6144 of 2025, 31940 of 2024, correct about correct. 3576 of 2024 before Adnodri. 35756 of 2024 LB matter nodi. LB nodrana matmu. All local board matter has to be posted before the roster bench. In respect of
Date may
33941 2024 and 34756 of 2024 service matter has to be posted before the roster boards, roster matter in
In the other two matters, Vinod. This pertains to, they are connected with each other because Vinod, it pertains to Vinod, a disciplinary inquiry which is sought to be.
ಆಯ್ತು ಅವೆರಡು ಬರುತ್ತೆ ಇವೆರಡು
ಅದೊಂದು ಡೇಟ್ ಕೊಟ್ರೆ ಸರ್.
Yes.
ಅವೆರಡು
before the roster bench on 11th. Yes.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಏಕೆಂದ್ರೆ
11 ಅಲ್ಲ I am giving in a date on 17th 18th ಇದೀವಿ every day I am giving in
27, 28. We just take a chance.
No,
27.
no, I have given date for all. Now you are giving date for 17 18. Your case is given on
At least
11th.
the first week of March, it's very short matter.
No, that will not reach. That is the problem. 9th.
Very good.
9th. Matter has to be reached and see that you are still I am in yes.
Disconnect.
Yes.
Serial number 51 adjourned, 52 Janardhan Ajay, 52.
Yes.
And regarding the second round, first round, Your Lordship, I see annexure G, page 36.
Who has to answer? Government.
Harish HV.
Not given any representation. So they are giving the representation will consider.
What is that his claim?
Lord, first round, Lord, this Honorable Court directed them to grant necessary pay scale, which has been held up because of the departmental inquiry was conducted. And Your Lordship will get it at details at the Let the kindly come to page 49.
49.
Yes.
ಸರ್ವಿಸ್ ಒಂದು ಮಾಡಿ 2 LB ಒಂದು ಮಾಡಿ 2 LB ಗೆ 2 LB ಸೇರಿಸಿ.
Lord, what happened was departmental inquiry was started for some disciplinary proceeding were initiated.
Yes.
Lord, thereafter, Lord, the kindly come to last parameter, Shara. So and so ಇಂದ ಅವರಿಗೆ ಮಾತುಗೊಳಿಸಿದ್ದು ಅವಧಿಯಲ್ಲಿ ಸಂಬಂಧ ಮಾಡಿ ಯಾವುದೇ ಹೆಸರುವುದಿಲ್ಲ. ಆಮೇಲೆ 14ರವರೆಗೆ ವೇತನವನ್ನು ವೇತನ ಮಾಡಿಸಿ then they have recommended my pay scale I am entitled for the same Lord. Kindly similar from ಹಿರಿಯ ವೇತನ ಸ್ಕೇಲಿಗೆ 5/9/2011 I am entitled. And allowed selection grade 4/9/2011. But this Honorable Court has directed to grant such a pay scale to me and consider my request. But that is the order. Lordship may kindly come to annexure G, page 36.
Yes.
Taking into consideration of the same, Lord, kindly page come to 46.
ಆಯ್ತು ಅದಾದ್ಮೇಲೆ ಏನಾಯ್ತು?
ಅಲ್ಲೇ 46 ಆದ್ಮೇಲೆ ನಮಗೆ ಪೇ ಸ್ಕೇಲ್ ಏನ್ ಕೊಡ್ಬೇಕು ಅದು ಕೊಡ್ಲಿಲ್ಲ. But from 2010 in the senior scale ಕೊಟ್ಬಿಟ್ಟು they have not paid arrears. Then selection grade they said they have not yet granted. 7th AICT pay scale they have granted, but still the arrears have not been paid.
Yes.
Now I have filed a contempt. There they said I have filed this writ petition. So only I am the contempt court honorable judge bench said at least pay arrears and the rest of the relief will be here decided.
Yes.
But as per the recommendation of the college, I am entitled for the service. Lord, they can't deny that promotion and they give. Lord, kindly see the promotion what they have given is
So
here.
you are seeking for a senior
Annexure J, Lord, yes. Lord, kindly come to annexure J,
grade
Lord.
with all financial benefit. Further, director respond on pay all
Yes.
arrears.
Yes.
Salary as per the
Yes.
said note. No,
They
this
have
is
not
already
complied with-
directed by this court.
Lord, yes. Lord, directed. Lord, kindly come to annexure J, Lord. They say they have submitted to the court. Lord, contempt court saying that they have granted. Lord, their contempt court said that you seek separate remedy. But if it is not granted, they will not consider the same in the merits matter will not be touched there. And kindly come to Annexure J, my lord. The recommendation of the college, your lordship, may kindly see page 49.
No, I am asking that
Yes.
whether that earlier order is complied.
Earlier order is not completely complied.
Oh.
Only kindly, sir, that compliance, your lordship will get it.
Have you
annexure-
filed an objection, Mr.?
Need to file. No, page number 47. This honorable court directed the petitioner to give representation to authority below. Till today he has not.
ಅಲ್ಲ ಕೊಟ್ಟು ಅದ್ರ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ರೀ ಸುಮ್ಮನೆ ಏನೇನೋ ಓದ್ಬೋದು.
Annexure J and Annexure K.
K has been passed on the basis of that
K
representation.
is also passed.
Now you have not, see, representation given, you have not considered, filed in a contempt, then you have passed this order.
Yes. Annexure J and K.
Passed in only half prior has been
Not
considered.
Annexure K also, your lordship, may kindly. Thereafter, when they notice that.
Let him take instruction. You don't know whether you have given a representation.
Not like grant little time, not a shorter time, so that.
Yes, at the request of counsel
He has
for
held up his
government
promotion,
advocate.
everything.
As a last chance, 2 weeks time is granted to file objection. This matter on 5th, Mr.
Not.
Yes.
53, 54, 55 adjourn, 56 Suvarna Lakshmi ML. 56.
Yes.
Trustee, matter request to be heard.
Master request to be hearing.
Please.
Yes. When do you want, Mr.?
That premature transfer, my lord.
Hmm.
That term has been completed now. Petitioner. That is the only ground she has urged in the petition.
Yes, madam.
My
Yes,
lords,
on the date.
as on today, the term is completed, my lords, but I have 1.5 years for retirement. I've specifically made that pleading in my grounds, and I've taken your lordships
Now,
to
who
the
is
part.
appearing for that? Now we'll post this. Why that vacating order has been posted in B group?
I'm not sure.
Is there
my
any
lords.
direction?
On its
Post
own,
this
it's come
matter.
up.
I filed that IA, my lord.
He posed this matter in orders list for consideration of IA 2 of 2025 on 25th.
Start date.
25th is the start date, Mr. What
Please.
else? Yes.
Interim order may kindly be.
Interim order granted earlier is extended till next date of hearing.
Grateful.
57 adjourn, 58 Pawan Chandra Shetty.
Yes, Mr.
Lord, the employees are, my lord, belong from the Kuke Subramania Swami temple.
Yes.
They are, my lord, promoted in the,
Opponent.
my lord, state.
Yes, ready. Tuesday. Yes.
My lord, demoted, we have promoted, my lord, in the year 2008, without notice, my lord, without any summons, without any opportunity, my lord, straight away, my lord, on the basis of somebody's, my lord, consideration, that is annexure A has been passed.
A permanent employee of that temple.
Yes, yes, my lord.
Why you have been demoted?
That is, my lord, annexure A speaks with respect to the one Mr. Suresh, my lord, who is the Bhagavati temple of the Kalburgi.
ತಕ್ಷಣ ಪೂರ್ಣ ಭಾಗವತಿ ಹಿಂಪಡೆಯಲಾಗಿದೆ. ಸದರಿ ಅವರಿಗೆ ಉತ್ತೀರ್ಣ ನೀಡಲಾದ ದಿನಾಂಕ ಹೆಚ್ಚುವರಿ ವೇತನ ಸಹ ವಾಪಸ್ ಪಡೆಯಲಾಗಿದೆ. ಎಸ್ ಮೇಡಮ್, ವಾಟ್ ಇಸ್
Kullakalli. Exactly. Exactly, my lord. On the basis of the advocate opinion, my lord.
What is the reason they are
demoted? My lord, some incorrect judgment quoted, my lord, in the annexure A, running page number 19. That is with respect to the land acquisition matter.
It is a commissioner who has passed this order. He has not.
This is absolutely wrong, my lord. Based on the advocate opinion, refer the, my lord, land acquisition matter.
25th. You ask the commissioner what is the reason. Otherwise, ask him to withdraw that. 24th.
Please, ma'am.
At the request of government advocate, leaves this matter on 24th.
Interim order is operating, my lord.
Interim order granted earlier is extended till next date.
Cell number 59 adjourn, cell number 60 Shivakumar N. Serial number 60.
Serial number 60 appearing for the petitioner in this matter.
Yes.
Lords, a short issue for your lordship's consideration is,
Yes.
Lords, the project managers who were originally appointed,
Yes.
Lords, with what is called as the Karnataka Rajya Nirmana Kendra,
Yes.
were sent on deputation to various Nirmiti Kendras. Now, they were rendering their services in a post called as project manager.
Yes.
Lords, in respect of all the Nirmiti Kendras, we have collected the documents.
Yes.
The persons who are sent on deputation
Yes.
from Karnataka Rajya Nirmana Kendra to the respective district Nirmiti Kendras, resolutions are passed,
Yes.
which itself is held as conclusive proof of absorption into the post of project manager of Nirmiti Kendra. Kudi. ಅಲ್ಲಿ ಯಾಕೆ ಹೋಗ್ತೀರಿ ಇಲ್ಲಿಂದಾನೆ ಕೊಡ್ರಿ.
Yes.
Not this, I will of course serve it on the other side and place it on record. Now, consistent with the practice which is adopted by the Nirmiti Kendras,
Yes.
the Karnataka Rajya Nirmana Kendra, I am only asking for extension of the same relief on parity. The reason being, at page number, because on the first hearing date when the matter came up before Lordships at page 52,
Yes.
there is already a resolution, and at page 54, item number 5, if your Lordships were to see page 53,
Yes.
serial number 3 is the director of Karnik,
Yes.
third respondent. So in their presence at page number 54,
Yes.
ಅದರಲ್ಲಿ 5E
Yes.
ಯೋಜನಾ ವ್ಯವಸ್ಥಾಪಕರನ್ನು ಮುಂದುವರಿಸುವ ಬಗ್ಗೆ ಸಂಸ್ಥೆಯಲ್ಲಿ ನಿರ್ಮಿತಿ ಕೇಂದ್ರಗಳ ಅಪೆಕ್ಸ್ ಸೆಂಟರ್ ಆದ ಕರ್ನಾಟಕ ರಾಜ್ಯ ನಿರ್ಮಾಣ ಕೇಂದ್ರ ಕಾರ್ನಿಕ್ ಬೆಂಗಳೂರು ಇಂದ ನಿಯೋಜನೆ ಮೇಲೆ ಯೋಜನಾ ವ್ಯವಸ್ಥಾಪಕರಾಗಿ ಮಂಜುಳಾ ಸೋನ್ಸರ್ ಅವರು ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದು, ಇವರಿಗೆ 6 ವರ್ಷಗಳ ಕಾಲ ನಿರ್ಮಿತಿ ಕೇಂದ್ರ ಹಾಗೂ 16 ವರ್ಷ ಕಾರ್ನಿಕ್ ಒಟ್ಟಾರೆ 22 ವರ್ಷ ಸೇವೆ ಅನುಭವವಿದ್ದು, ಅವರ ಕಾರ್ಯಕ್ಷಮತೆಯನ್ನು ಪರಿಗಣಿಸಿ ಇವರನ್ನು ಚಾಮರಾಜನಗರ ಜಿಲ್ಲೆ ನಿರ್ಮಿತಿ ಕೇಂದ್ರದಲ್ಲಿಯೇ ಯೋಜನಾ ವ್ಯವಸ್ಥಾಪಕರಾಗಿ ಮುಂದುವರಿಸಲು ಸಭೆಯು ತೀರ್ಮಾನಿಸಿ ಅನುಮೋದಿಸಿ ಅಂಗೀಕರಿಸಲಾಗಿತ್ತು. Same resolutions are passed pertaining to other Nirmiti Kendras. We have it pertaining to at least 4 districts. That is Bengaluru urban, Udupi, Shimaga.
Now, what is that you are challenging here?
Now, what happened was, despite this resolution, an order of repatriation of the petitioner was passed. Now, deputation feeds into insignificance. Deputation and repatriation, my lords, feeds into insignificance because now the question is as to whether, as per this resolution, I am deemed to have been appointed and absorbed into the services of Nirmiti Kendra or not. That is all. What is the question before your lordships? I will supply the copies, my lords. I understand that my learned friend will be handicapped without this.
Yes,
I asked him, but he has got this memo code pagination. It could be taken up on 25th. That is the only point, my lords. I will not take more than 5 minutes of your lordships' time.
What has happened is, my lords, she was an employee of the respondent number 4 Karnik.
Yes.
Thereafter, she was deputed to the Nirmiti Kendra.
There is no dispute that he
Yes,
can
my lords, I am just
repatriate.
coming, my lords.
Whether that resolution is amounts to absorption.
Absorption or not, stay prashne
Lordship, my kindly see the lordship's order, my lords.
You are here, you want to go through.
The documents are there.
I will hear all these things. When nobody is ready, don't argue further. I am
ready there, but ಇವರು ಹಾಕಿಲ್ಲ ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು ಮಾಡ್ತಿದ್ದೆ.
Is this matter? When do you want, Mr.
25th, 26th, my lords.
26th.
No, it's not 26th. Any date other than 26th.
27th.
4th.
ಆಗ್ಬೋದು.
Yes. Is this matter on 4th?
61 Anandaramake.
Mandamus, my lord, to consider my application. But
Respondent
I have
number
lost my land, my lord. It has been acquired by KADB.
Yes.
They have framed a scheme, my lord, at annexure H, as per which, my lord, I am entitled, my lord, for a job for my son or any of the family members. My lord, I have filed an application, annexure H scheme, my lord. Your lordship may kindly come to.
Consider that, please.
I appear for respondent number 4, MRPL, your honors.
You are for respondent number?
4.
No, who has to consider?
The KADB has to consider.
No, under the scheme, KADB has to consider,
Yes,
or that beneficiary.
KADB, my lord.
Where is that scheme?
Lord, scheme is at annexure H, my lord. I would get an employment in
Who has to
beneficiary.
give an appointment, whether that beneficiary has to pass an order or KADB has to allotted you to that. Where is that rule which says, Mr.?
My lord, the scheme is at annexure H.
Which is that?
Idralli, your lordship may kindly come to page number 51.
Yes. ಎಲ್ಲಿದೆ?
My lord, 12 ಅಲ್ಲಿ ಇದೆ. 12 ಯೋಜನಾ ನಿರ್ವಸತಿ ಕುಟುಂಬಗಳ ನಾಮನಿರ್ದೇಶಿತರಿಗೆ ತರಬೇತಿ ಅಥವಾ ಇಲ್ಲದ ಉದ್ಯೋಗ ಯೋಜನಾ ಸಂತ್ರಸ್ತ ಕುಟುಂಬದಲ್ಲಿ ಸೂಕ್ತ ಅಧಿಕಾರವನ್ನು ಹೊಂದಿರುವ ಸಂತ್ರಸ್ತ ವ್ಯಕ್ತಿಯ ನಾಮನಿರ್ದೇಶನದಂತೆ
MRPL ಅಂತಂದ್ರೆ
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 4
ಮನೆ ನಂಬರ್ ಸೋ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿದ್ದು ದಿನಾಂಕ 25 ನಿರ್ಮಿತ ಕುಟುಂಬದವರಿಗೆ ಸ್ವಂತ ಬಾಡಿಗೆ
Lord, annexure J, my lord, I have submitted to the respondent number 2 and 3. Respondent number 2.
ಕೋರಿಕೆ ಮತ್ತು ಸ್ವಾಧೀನ ಇಲಾಖೆ KDP ಭವಿಷ್ಯದಲ್ಲಿ. Don't see both of them consider that.
Yes, my lord, 2 to 4, my lords.
Yes, in this writ petition,
Your Honor, I shall file my wakalat as well as my statement of
feel permitted
objections.
to file wakalat. You
Uh,
just consider in
Statement of
accordance.
objections, 2 weeks times may be granted. After
I am
that,
not giving any positive order. I will
That's-
say that
this-
consider in terms of the rules.
my lords, today morning itself I received the petition copy.
I thought.
2 weeks time.
That's a mandamus.
No, after my statement of objection, then we shall.
They have to file statement
Yes,
of
sir.
objection.
Opportunity. may-
Next week, any day.
No, 2 weeks.
Yes.
It's
What's
only
your
consider,
name?
my lord, let them reject, my lord, at least let us know status of my application.
I need to hear.
No, you are appearing for whom?
Respond number 4, MRPL.
My lord, the application is for KIDB, my lord, let the,
You have given representation to MRPL also.
no, my lord, only to KIDB.
No, ನೀವು 3 and 4 ಹೇಳಿದ್ರಲ್ಲ.
ಎಲ್ಲಿದೆ your representation?
Annexure J, my lord, page 54.
Annexure J 54 to whom?
My lord, respondent number 2.
Then you are now formal party, your name will be shown.
Astu.
So and so is undertake to appear for respondent number 4. ವಕಾಲತ್ ಹಾಕ್ತೀರಾ ಅಥವಾ ಟೈಮ್ ಕೊಡ್ಬೇಕು?
No, I shall file my lords.
Yes.
Registry.
You will
2 weeks
say-
time, my lord.
No, I will grant time to file wakalat. I will
Okay.
dispose of.
No,
There
my
is no
lord.
relief against you, madam.
No, whatever, my lord, I need to see the instructions. my
No,
lord.
then you delete
weeks,
that
ma'am.
respondent number 4.
ಅಲ್ಲ, the beneficiary ಅಲ್ಲಿ ನನಗೆ ಉದ್ಯೋಗ ಕೊಡಬೇಕು. ಇವ್ರು KIDB has to
No, you are
consider.
not
my lord.
sought for that. They need not be necessary for you. Delete that and then.
My lord, Lord, they would be pro forma necessary parties, my lord. Though not necessary, my lord, they are proper parties.
Yes.
But my lord, lordship may kindly see,
Petitioner sought following.
R2 ಗೆ ನಾನು ಪೇರಲ್ಲ R2 ಅಂತಾನೆ ಕೇಳಿದ್ದೀನಿ.
Yes. No, I have very difficult to convince her. Therefore, I said that delete her. What to do that? Yes. Sought following relief. The case of the petitioner that. Second respondent board. Case of petitioner was an absolute owner of
Petition scheduled
property.
property.
Petition scheduled property.
Yes.
The said petition scheduled property was acquired by the respondent 1 to 3 under KDB Act. The annexure ಯಾವುದು ಇದು scheme?
Scheme annexure H. That is, my lord,
The government has then framed in a scheme
the rehabilitation and resettlement scheme.
for rehabilitation and resettlement scheme for the benefit of land losers.
Yes.
Accordingly, the family members of the land losers are entitled for appointment in fourth respondent company. Therefore, petitioner has submitted a representation with annexure J dated 25/3/2025 to respondent number 2. So far, their representation has not been considered. Therefore, the petitioner is before this court. Who is where is Chandrasekhar? Yes.
I think
Since-
BB Patil has filed.
BB Patil. Since representation submitted by the petitioner with annexure J dated 25/3/2025 has not been considered by the respondent number 2, it is suffice for this court to direct that respondent number 2 to consider that representation submitted by the petitioner with annexure J dated 25/3/2025 in accordance with law as expeditiously as possible, not later than 3 months from date of receipt of copy of this order. So and so is permitted to file wakalat within 4 weeks. Yes.
Much obliged.
Bill number
Statement of
62,
objection.
Naveed Ahmad for petitioner, Reshma KT.
Yes.
Just the short question is about a height discrepancy, CRPF constable, my lord.
Yes.
When measurement was done, ನಮ್ಮಿದ್ರಲ್ಲಿ 168.3
Ah,
ಅಂತ
that's connected matters I have dismissed. You have the copy.
I don't have a copy of that one.
Connected matter I have dismissed that it cannot be permitted to do
Yes.
again and again.
That is
They have
the
filed an
position.
appeal and confirmed that in appellate authority also.
Here preferred. He stays silent for 9 days
Yes, let
And
us,
then he
yes, read this matter after 2 weeks,
Please, my lords.
after 4 weeks, yes.
Interim order is there.
What is that interim order?
Recruitment to the post of subject to outcome of this.
Other, interim order granted will extend it till next date of it.
Bill number 63, Arsha P. Banat. 63.
Yes.
This is with respect to the cancellation of selection process of Anganwadi workers.
Yes, madam.
And we are alleging that there's a political interference. So
Ready.
ಅದಕ್ಕೆ
My lord, we are filed out objections, my lord.
Yes, what is this?
on the last date of occasion, the court had directed us to file judgments along with memo.
What is that judgment on what point?
The point is that the petitioner does not have a indefeasible right when her name is there in the selection list. However, if the selection process is cancelled, it shouldn't be arbitrary. So we are on the point of arbitrariness on which the selection process is cancelled.
No, that, what is that cancelled, madam?
My lord, the notification, my lord, was cancelled due to the reason, my lord, one Mr. Vinoda, who had applied to the post, my lord, was a meritorious candidate. However, my lord, during the uploading of the documents, my lord, the residence certificate, my lord, has been incorrectly uploaded. Thereafter, my lord, she made a representation and sought for corrections, my lord. And the committee, my lord, decided not to, my lord, proceed further and decided to cancel the notification and issue a fresh notification, which is under challenge.
No, petitioner is also one of the applicant.
Please,
But she's not a meritorious, my lord. One, Vinoda was a meritorious candidate.
Selection agita. Where is
Provisional selection had happened, my lord. If I may take your kind attention to page number.
Where is that provisional selection?
Page. It's at page number 37. Page number 37, last para.
Yes.
ಕ್ರಮ ಸಂಖ್ಯೆ 1 ರಿಂದ 7ರವರೆಗಿನ ಅರ್ಹ ಅಭ್ಯರ್ಥಿಗಳ ಪೈಕಿ ಕ್ರಮ ಸಂಖ್ಯೆ 1 ಅಭ್ಯರ್ಥಿ ಶ್ರೀಮತಿ ಪೂಜಾ ಶ್ರೀ ಸಿಂಗನಮನೆ ಇವರು ಅತಿ ಹೆಚ್ಚು ಅಂಕ ಗಳಿಸಿದ್ದು.
ಸಮಿತಿ ಆಯ್ಕೆ ಸಮಿತಿ ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆ ಪಟ್ಟಿ.
Subsequently, a letter was written by the local MLA, my lord, which is at annexure E, page number 43, 42. So he says, ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಭದ್ರಾವತಿ ತಾಲೂಕು ಶಾಂತಿನಗರ ಗ್ರಾಮಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶಾಂತಿನಗರ 1 ಅಂಗನವಾಡಿ ಕೇಂದ್ರಕ್ಕೆ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆಗೆ ಶಾಂತಿನಗರ ಗ್ರಾಮದ ವಾಸಿಯಾದ ಶ್ರೀಮತಿ ವಿನೋದ ಎಂ ಇವರು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ದಿನಾಂಕ 29/7/24ರಂದು ಘನ ರಾಜ್ಯ ಸರ್ಕಾರದಿಂದ ಅಂಗನವಾಡಿ ಕೇಂದ್ರದ ಕಾರ್ಯಕರ್ತೆ ಹಾಗೂ ಸಹಾಯಕಿಯರ ಹುದ್ದೆಗೆ ಅರ್ಜಿ ಆಹ್ವಾನಿಸಿದ್ದು ಸದರಿಯವರು ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ದಿನಾಂಕ 9/1/23ರಂದು ಪಡೆದಂತಹ ನಿವಾಸ ದೃಢೀಕರಣ ಪತ್ರವನ್ನು ಕೈತಪ್ಪಿನಿಂದ ಅಪ್ಲೋಡ್ ಮಾಡಿರುತ್ತಾರೆ. So while uploading online, she has committed a mistake. And he has recommended to select her. Subsequently, my lord,
ಸರಿಯಾದ ವಾಸಸ್ಥಳ ಪ್ರಮಾಣ ಪತ್ರವಿದ್ದು who has selected under the provisional selection?
The district selection committee, my lord.
ಯಾರು ಸೆಲೆಕ್ಟ್ ಆಗಿದ್ರಿ provisional selection?
Pujashri, my lord, the petitioner. Petitioner was selected. It so happened that there were two.
Where is your name, mister, in the serial number? Which Anganwadi center?
Singanamane Anganwadi center.
Singanamane Anganwadi center.
Shantinagar 1.
ನಿಮ್ಮ ಹೆಸರು ಪೂಜಶ್ರೀ. ನೀವು ಸೆಲೆಕ್ಟ್ ಆಗಿದ್ರಿ?
ನಾವು ಸೆಲೆಕ್ಟ್ ಆಗಿದ್ವಿ. We are selected, though we stood second, we are selected because the rival candidate, one Srimati Vinoda, she had not uploaded proper documents.
Yes.
So that is why we were selected by the provisionally by the district committee, and subsequently MLA writes a letter, and then the district committee again considers it, which is at page number 48, my lord, the minutes.
Yes.
If I may read out. So adralli they say that the rival candidates contentions cannot be considered because if she has not uploaded proper documents, it will open the Pandora's box. Subsequently, we were selected by the district committee finally. It's at page number 54, my lord. Page number 54 is the committee, and relevant para is at page number 57.
Yes.
So last
select
para
ಮಾಡಿದ್ದಾರೆ.
ಅದ್ರಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಮೇಡಮ್.
ಆಯ್ತು, ಆಮೇಲೆ ಏನಾಯ್ತು?
ಆಮೇಲೆ then we were not intimated, and then we sent a legal notice, and subsequently finally we got an intimation which is at annexure M, saying that the entire process for this particular center, that is Shantinagar 1, has been cancelled.
No, you have finally selected.
I am selected.
Yes.
But this the committee has resoluted that.
Approved, committee has passed in a resolution that you have been selected.
Yes, subsequently it has been subsequently they have cancelled it.
Who?
The committee, the same committee.
Yes, how can
Committee
that, madam,
has
to
cancelled the
till that
notification
respondent is get certificate, you have to go on postponing that till she has to be selected.
My lord, but the committee, my lord, has taken a decision, my lord. The committee consists of,
Consist of so many people, but deciding on the basis of the MLA letter.
no, not at all.
Now, why you have cancelled then?
My lord,
No,
committee is of
petitioner
the
has
opinion-
selected.
The committee is of the opinion, my lord, such defects, my lord, cannot be cured again and again. Therefore, my lord, the committee opined that a fresh notification would suffice.
Why is fresh notification? She has not selected. The petitioner has selected. Why do you want that fresh notification?
Because one Vinoda, my lord, was a meritorious candidate. Therefore, my lord, the committee took such decision, my
Now,
lord.
how can that, can you do it? That's what that. Just because Vinoda has not obtained, then another candidate says that still I have applied that, I have not passed this degree. You wait that, you will wait it. Is it that rule? Which is the law?
There is.
Yes, what is that judgment you are?
My lord, if I may pass on. One is the apex court judgment. One is the apex court judgment.
Now, once appointment has been approved by that passing a resolution. Now, if the appointment is not approved, then he has no rights at all. If it is approved, can it be cancelled? Just because of to help that other candidates.
Page number.
And also they are producing that MLA letter. Yes, page number.
Page number 5, paragraph number 7, my lord, if I may read out. It is not correct to say that if a number of vacancies are notified for appointment and adequate number of candidates are
Page
found
number
fit.
5,
Para 7, man.
Yes.
It is not correct to say that if the number of vacancies are notified for appointment.
Copy ಕೊಟ್ಟಿದ್ದೀರಾ ಅವರಿಗೆ?
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಅವರಿಗೆ ಕಾಪಿ ಕೊಡಿ. ನೋಡ್ಕೊ ಬನ್ನಿ. We'll have it on 26th.
26.
If only on that basis it has to go, madam. Can't.
Number
Yes.
64.
You
Girish
select that
Kumar.
petitioner.
Yes,
Is she not qualified? If she is qualified, she has to be selected. ಒಂದು ಅಂಗನವಾಡಿ ವರ್ಕರಿಗೂ ಎಷ್ಟು ಒಂದು ಇದು ನಡೀತದೆ ನೋಡಿ. Yes.
This case I am
number 2 in
seeking for writ of Mandamus to consider the annexure D, page number 15.
Serial
my
number?
lord.
Let's a week's time may be granted in
Writ
this
of
matter.
Mandamus.
Need to file objection in this matter. Still number
What is that mandamus? ಕೊಡಿ.
To direct to give the earned leaves, pay the earned leaves amount and also encashment of the group insurance.
You consider it. If she is entitled, you give it.
No, my lords, I need to file objections.
You are appearing for whom?
I responded number 2. I am
Only consider my representative, that's all, my lord.
If she is not entitled, you give an endorsement.
Yes,
I
my
don't have
lord.
instructions in this matter.
You are not, you don't give anything. I will pass an order. Yes.
My lords, I request to have it on day after tomorrow, my lords.
This writ petition, petitioner sought following relief. Mandamus appropriate direction to representation given petitioner. Yes. The case of the petitioner that petitioner was appointed as,
PDO.
petitioner was working as a PDO in office of
Jinenalli Gram Panchayat. Jinenalli Gram Panchayat, Chennai Panchayat.
Panchayat and retired from the service when
39/2024.
39/2024. Thereafter petitioner has submitted a representation. Yen retirement benefit ಕೊಟ್ಟಿಲ್ವಾ?
Yes, my earned leaves and group insurance. my lord.
Leave benefits ಕೊಡಿ ಅಂತ ಸ್ವಾಮಿ.
ಯಾರು ತಾಲೂಕು ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್ ಕೊಡ್ಬೇಕಾ?
Yes, yes.
Whom you have given a representation?
Representation to
To
Taluk
respondent number
Executive
2
Officer.
executive officer, my lords.
Annexure?
Annexure D, my lord, page number 50.
The retirement benefit has not been. ಏನೇನ್ ಕೊಡ್ಬೇಕು?
Earned leave and group insurance amount, my lord.
Earned leave and group insurance amount has not been sanctioned to the petitioner. Therefore, petitioner has submitted in a representation with annexure.
Annexure D,
Annexure D,
dated 17/2/2025.
25 to that respondent number 2. The respondent number 2 is directed to consider that representation in accordance with law as expeditiously as possible, not later than 8 weeks from date of receipt of the copy of. ಅಷ್ಟೇ ನಿಮಗೆ ಬರಲ್ಲ ಅಂದ್ರೆ
65, Sadananda J. Shastri.
to appear for the petitioner in this matter, my lord. Short point involved is, my lord, petitioner comes to be transferred from his YTPS, YCCP plant Bangalore to Raichur initially, my lord, at Annexure A. Thereafter, once again, he is transferred to Bidadi, my lord. Petitioner is a person who has suffered disability, 20% burns, my lord. While working, he got electrocuted with the.
Where is your opponent? Who is that?
Now, my lord, what has happened? Only 8 months of service is left.
Ah.
So even according to the rules,
Stay is there.
no stay is there, my lord. That's the reason. Last date, your lordship directed that let them come on record. We'll consider the objections. Now, another aspect, my lord, he suffered a heart attack last week. So kindly some interim protection may be granted, my lord, so that he can continue.
Leave this matter in orders on 25th. We'll have it on order. It's all transfer matter. Either way, we'll decide.
My lord, only one submission, my lord. ಈ ತರ ಕೈ ಸುಟ್ಟೋಗಿದೆ ಅವರಿಗೆ ಪೂರ್ತಿ.
24th hour ಬರ್ಲಿ. I can't pass any order if they are not there. Yes.
Very well. 24th.
I represent my lord petitioner in this case, my lord. Lord, this is case, my lord, only to consider my representation.
Yes, Mr. Nagarajappa, is it that?
Like consider ಮಾಡಬಹುದು. Consider in accordance ತಲ್ಲ my lord.
Yes.
ಅದರದೇ.
Yes, my lord. Annexure A is the representation, my lord. I have tendered my
representation.
Annexure A.
Resignation ಕೊಟ್ಟಿದ್ರು withdrawal ಕೊಟ್ಟಿದ್ದಾರೆ. Whether that is.
Yes. Seek following relief. The petitioner is an employee of which panchayat, Mr.
Respondent number 1 to 3, my lord.
ಮುದ್ದಿನಕೊಪ್ಪ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಶಿವಮೊಗ್ಗ.
Yes, working as an attender in respondent number 3 Gram Panchayat. While he was in, he has submitted in a resignation yavattu.
30/12/2024.
24 ಕೊಟ್ಟು ಈಗ ವಾಪಸ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ immediately within 20 days we have given the
has submitted in a resignation on 3/1/2024.
Yes, my lord. 30/12/2024.
30/12.
ಹೌದು ಸ್ವಾಮಿ. Annexure
30/12.
Annexure E.
Page number 21, my lord.
21.
Yes.
Has submitted in a resignation to that post. With annexure
E.
With annexure E.
And annexure F is the
annexure E dated 30/12/2024. Thereafter, he has filed a representation with annexure.
He has withdrawn his resignation with letter dated 20/1/2025.
Annexure A ಅಂತ ಹೇಳದವರು.
Annexure F.
He has given a representation on 20/1/2025 seeking for withdrawal of
the resignation.
Resignation letter, since his representation dated 20/1/2025 has not been considered.
And also, my lord, on 30th November 39, 2025, also I have given one more representation.
Yes.
Annexure
Thereafter,
A.
he has given one more representation. Annexure?
Annexure A, my lord.
Annexure A.
39/2025.
His representation is not considered. The petitioner is before this court. Shri Nagarajappa, Learned Counsel, appearing for respondents has submitted that representation of the petitioner will be considered in accordance with law if this court grants some reasonable time. In view of the above, without expressing any opinion on the merit of the case, the respondent, who has to consider?
Respondent number 1 to 3, my lord.
Development officer, respondent number 1 to 3 are directed to consider that representation of the petitioner so and so in accordance with law as expeditiously as possible, not later than 8 weeks from date of.
67 PS.
Your lordship, I appear for petition in this case, your lordship.
Yes.
Your lordship, for R2 and R3, we had filed statement of objections and vacating for stay. Due to inadvertence, couldn't enclose one of the annexures, your lordship.
You do it. When do you want?
Your lordship, a short date may be fixed and the direction may be given to the pending branch so that we will comply with it.
Your lordship, I also filed an application for disobedience of the interim order, your lordship.
Yes.
That application is also pending.
Council for, at the request of Learned Counsel for respondent number 2 and 3, read this matter on 5th.
Your lordship, interim order extended.
Interim order granted earlier is extended till next
Lordship,
year.
a direction may be noted, your lordship.
What is the direction?
We'll just enclose the annexure. We did not enclose the annexure in the objections due to clerical error.
File additional this thing. How can that permitted? Yes.
68 urgent, 69 Raghavendrayan.
Petitioner.
Yes.
Petitioner is only seeking writ of Mandamus, my lord, to consider the representation dated 1/2026, my lord. The fact of the case is that, my lord, the petitioner is.
Yes, Mr. It can be
My
disposed.
lord, what has happened, my lord, the Mysore City Corporation, my lord, there are two accountant superintendent. My lord, from there, my lord, respondent number 5 has been transferred to Mangalore Corporation.
No,
To
what
this
is that
respondent.
representation he is seeking?
He has to report to the duty in Mangalore City Corporation, then we'll relieve her from the, because she is the only post, my lord, we have. If she relieves, my lord, it's a year ending, my lord, we have a works, my lord, that has to
No,
be.
no. What is
My
that?
lord, the petitioner
Wait,
was
Mister. This is that matter. 2 days back I have.
Yes, my lord, please, that is the
Now,
matter.
where is the transfer order?
My lord, it is at annexure E, my lord.
Annexure?
E.
Annexure
my
E.
lord.
Yes, my lord.
Government has transferred you from where?
From Mangalore City Corporation to Mysore City Corporation. my lord.
Mangalore City Corporation to,
Mysore City
and
Corporation.
then you have to relieve.
We have to relieve, my lord. My lord, what has happened? Again, that from the respondent number 5 hearing, my lord, transferred from Mysore City Corporation to Mangalore City Corporation. He has to report
That
duty.
is not the concern, Mister. It's a government order.
My lord.
Transfer order, you forthwith relieve.
My lord, what has happened?
No,
my lord?
you have nothing to do with that, Mister.
My lord, my humble submission. Time frame may be fixed, my lord. Even respondent number 5 may be directed to respondent number 5 may be directed to take charge, because, my lord, it's a financial year ending, my lord. We have a work.
No, respondent number 5 is not taken charge. The government will take an action if they are not taken charge. Why they have been transferred, madam?
My lord.
What is that? Who is appearing for respondent number 5?
He has served, my lord.
The private directed at the forthwith respondent has to be yes.
My lord, with the direction, my lord, respondent number
Yes,
5
yes.
to
This
take a
petition.
charge. Because only one post we have, my lord. In Mysore City Corporation, there are 2 posts. Even one post is not available, they can manage with that. my
You
lord.
go and ask the government, mister. Ask the government to withdraw the transfer. When government has passed on a transfer, you have nothing to say, mister. There is a transfer order. It is issued by the state government, but you are not saying that I will not relieve.
My lord,
Then what is the
I'm
effect
not
of the-
saying I'm not relieving her, my lord.
No,
the
your
person
problem,
with
you
the-
have to be sort out with that government, mister. You go and ask the government to withdraw that, otherwise close that corporation. If government wants that, close that corporation. That's what your this thing. Yes, third.
My lord, kindly, my lord, the one direction I'm seeking, my lord, at least respondent number 4 is also served. He's a Mysore City Corporation. Even let them answer, my
Respondent
lord.
number 5 pursuant to the transfer order, if it is not reported, take an action. Madam. Yes. If unless it is challenged and stayed by any other court. Yes. You are working as an what, mister?
Account
Accountant
superintendent.
Yes. This petitioner sought for ಟ್ರಾನ್ಸ್ಫರ್ ಆದವ್ರು ಹೋಗಲ್ಲ ಅಂತ ಕೋರ್ಟಿಗೆ ಬರ್ತಾರೆ ಅವ್ರು ಹೋಗ್ತೀನಿ ಅಂತರೂ ನೀವು ಕಳ್ಸೋದಿಲ್ಲ ಅಂತ
ಅಲ್ಲ ನಮ್ಗೆ ಅವ್ರೊಬ್ರೇ ಇರೋದು ಇವಾಗ ಅವ್ರೊಬ್ರು ಹೋಗ್ಬಿಟ್ರೆ ವರ್ಕ್ ಪೆಂಡಿಂಗ್
ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ಮೇಲೆ ನಾಳೆ ಅವನಿಗೆ ಹೋಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀನ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿ ಹೋಗಿಲ್ಲ ಅಂತ ಸಂಬಳ ಕೊಡೋದಿಲ್ಲ ಅವರಿಗೆ ಯು ನೋ ದಟ್
It's a vice versa transfer.
yes short following relief the petitioner was appointed as an accountant on 30th 8 2017 in 4th respondent and he was working in 4th respondent corporation by order dated, which is the transfer order. Annexure E dated 31/12/2025. State government has transferred the petitioner from Mangalore City Corporation to
Mysore City Corporation.
Mysore City Corporation. Thereafter, petitioner has submitted a representation.
By annexure A1.
By annexure
A, my lord. On
Annexure
1/1/2026.
to third respondent to relieve the petitioner to report in Mysore City Corporation. Since the respondent number 4-3 has not issued relieving order, the petitioner is before this court. Since the order passed by the government dated 31/12/2022 passed transferring the petitioner from
25, my lord. 31/12 to
25 petitioner from Mangalore City Corporation to Mysore City Corporation. Vice versa, fifth respondent has been transferred from Mysore City Corporation to Mangalore City Corporation. Once that government order has been passed, the respondent has to relieve, respondent number 3 has to relieve the petitioner and permitted them to report in Mysore City Corporation. Since the respondent has not relieved the petitioner as per that government order, transfer order dated Annexure E, the third respondent is directed to relieve that petitioner from the post of which post?
Account superintendent.
Account superintendent in
Mangalore City Corporation.
Mangalore City Corporation, and permitted him to report in Mysore City Corporation. And also respondent number 5 is directed forthwith report in Mangalore City Corporation. If respondent is not, third respondent is not reported forthwith in Mangalore City Corporation, the competent authority is directed to take action against the respondent number. Yes.
Fifth respondent. Time frame, my lord.
Forthwith. Please. Yes. They
Third
will not take my
respondent
order.
ಅಂತ ಆಯ್ತು, fifth respondent.
Last
Third
one.
respondent ಅಂತ ಆಯ್ತು last ಅಲ್ಲಿ. It's a fifth respondent.
Fifth respondent. Fifth respondent has to report it to forthwith, otherwise competent authority take action. Yes.
Bill number 70 adjourned. 71, Gautam Dev C. Ullad for petitioner, connected matter, Anusha L.
71 point.
ಸ್ವಾಮಿ ಇದರಲ್ಲಿ 71 ನಲ್ಲಿ ಒಂದು ಮೊದಲನೇದು R3 has not
Your lordships are directed in the very connected matter dated 5/2/26 that Shishira Amarnath to take notice anta. Melods will receive a copy, Melods, because in the usual course what happens is Melods the department directs us Melods idral appear agi anta. That instruction was not there. We have not filed wakalat, Melods. But now I'll
7 January only I have.
You serve a copy.
I will receive a copy, your lordships.
Copies. When do you want?
Similar matter, my lords, where salary is not being.
Salaries.
May be connected with this, my lords.
Call this matter along with that so and so on 9th.
ಸ್ವಾಮಿ ಅದರಲ್ಲಿ in 71 ನಲ್ಲಿ the petitioner is going to retire this month ಸ್ವಾಮಿ. ಅದಕ್ಕೆ kindly it may be because from 21 January 7 ಸತಿ 4 ಸತಿ ಅರ್ಜನ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಇನ್ನ ಅವ್ರು ಇದ್ ಮಾಡಿ.
Now he has appeared. Let us see that.
ಅಲ್ಲ ಅದಕ್ಕೆ ಶನಿವಾರ ಹಾಕಿದ್ರೆ
Melods, in the
kindly.
connected
ಅಲ್ಲ
matter also, we
because
have returned to the department, Melods, that is R1. Melods.
R1 and
We
2
have
has undertake to
9th. Yes.
ಅಲ್ಲ ಶನಿವಾರಕ್ಕೆ ಹಾಕಿದ್ರೆ
ಶನಿವಾರಕ್ಕಾಗಲ್ಲ.
Kindly,
Yes.
because
No, Mr. He has to file. Yes.
72, Prithvi
the date
Shanke.
some
Yes. What is this, Mr. Same that matter.
This is KPCL, different subject matter.
Different
Only thing is chemistry and chemist and chemical supervisor. Our contention is question papers exchange agide anta. If it can be referred to an expert, my lords, and report is submitted, it will close. Ashta.
Yes. Where is that other side?
Last time also they were not.
Have it next week.
Very well.
Yes.
Please, oblige.
For matter.
Yes.
Seal number 32, my lords.
ಏನಾಗಿದೆ?
Adರಲ್ಲಿ, that's the matter where age relaxation was claimed and
ಏನಾಗಿದೆ?
thereafter appointed as general merit. My lords wanted to seal number 32, my lords.
Passover.
Please, my lords.
Yes. Passover will have it on 4th.
Please, Saturday.
Saturday password matter, 36 serial number.
ಏನು? 30?
36, my lord.
36. What is this matter?
Milords, the petitioner was appointed as a driver, my lord. Now he has been dismissed, stating that he has produced the fake mask card, my lords.
9th.
Please, my lords.
Yes.
Oblige.
Number 33, my lords.
33.
33.
Passover.
It's a passed over matter, my lords. May I request it to be taken up on Saturday, my lords. Very short question, my lords.
Saturday, so many matters, and all matters which the world I have given a date to dispose of.
Any date next week, my lords. It's matter relating to payment of gratuity is a
5th. Yes.
Please, ma'am.
70?
73, because it's old matter.
I'm for the petitioner.
ಏನ್ ಮ್ಯಾಟರ್ ಇದು?
Service matter.
Station of pay my lord.
Yes, 12th.
12. Much obliged.
60. 16 ಏನಾಯ್ತು?
Office objection, compliance ತಗೊಂಡಿದ್ರು.
Office objection?
Compliance.
16, fresh matter.
ಹೌದು sir.
Fresh matter, it will come day after tomorrow, Mr. Not Saturday, day after tomorrow is what? Yes. Fresh matter will come if the office objection is compliant. Very good.
Sir, past over 31.
31 ಒಂದಿದೆಯಾ? ತಗೊಳ್ಳಿ ಸರ್, ಸೆಕೆಂಡ್ ವೀಕ್, ಥರ್ಡ್ ವೀಕ್ ಮಾರ್ಚ್ ಅಲ್ಲಿ ತಗೊಳ್ಳಿ 31. ಅದೇ ಯಾವ್ದು ಹೇಳಿ. ಆಯ್ತು ಬಿಡಿ. 18 ಬಿಡಿ, 18. ಸಾಹೇಬ್ರು ಕೊಟ್ಟಿರೋದೆ. ಈಗ ಡೇಟ್ ಕೊಡಕ್ಕಾಗಲ್ಲ, ಮಧ್ಯಾಹ್ನ ಆದ್ಮೇಲೆ ಆಗೋಯ್ತು.
Court officer, sir. Serial number 37.
ಕೊಡ್ಲಮ್ಮ.
Serial number 37 pass over ಆಗಿತ್ತು ಸರ್. ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
ಪಾಸ್ ಓವರ್ ಏನಾಗಿರ್ಲಿಲ್ಲ ಸರ್.
37 7
16/3 ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
16/3. Thank you, sir.
ಹ್ಮ್. 2 weeks. ಡೇಟ್ ತಗೊಂಡ್ರಲ್ಲ ಅವ್ರು 12ನೇ ತಾರೀಕಿಗೆ. ಲೀಸ್ಟ್ ಅಲ್ಲಿ ಮೊದಲು ಬರಲ್ಲ ಸರ್. ಲೀಸ್ಟ್ ಅಲ್ಲಿ ಯಾವತ್ತೂ ಮೊದಲು ಬರಲ್ಲ. ಅದ್ ಬರ್ದಿಟ್ಕೊಳ್ಳಿ. ಫೈನಲ್ ಇಯರಿಂಗ್ ಮ್ಯಾಟರ್ ಲೀಸ್ಟ್ ಅಲ್ಲಿ ಮೊದ್ಲೆಲ್ಲಿ ಬರುತ್ತೆ. ಆಯ್ತು. ನೀವ್ ಯಾಕೆ ಬರಕ್ ಹೋಗ್ತೀರಾ? ಅವ್ರಿಗೆ ಹೇಳಿದಿರಲ್ಲ, ನನಗೆ ಬೇಜಾರಾಗ್ತದೆ ಸರ್. ಅವ್ರಿಗೆ ಯಾಕೆ ಬರಕ್ ಹೇಳ್ತೀರಾ ಪಾಪ? ಅಲ್ಲ, ಹಿಯರಿಂಗ್ ತಗೊಳಲ್ಲ ಸರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಅವ್ರನ್ನೇ ಕೇಳಿ, ಅಡ್ವೊಕೇಟ್ ಗೊತ್ತಿಲ್ಲ. ನಾವ್ ಇಲ್ಲಿ ಇತ್ಕೊಂಡು ಹೇಳಂಗಿಲ್ಲ ಪಾಪ. ನೀವ್ ಯಾಕೆ ಬರಕ್ ಹೋಗ್ತೀರೋ ಗೊತ್ತಿಲ್ಲ. ಸರಿ, ಹೋಗ್ಲಿ ಬಿಡಿ. ನಿಮ್ಮ ಅದೃಷ್ಟ ಯಾವತ್ತೋ ಬರುತ್ತೆ, ಬರ್ರಿ. ನಮ್ಗೆ ಬೇಜಾರಾಗುತ್ತೆ.